Honorable members, shall we pray? Almighty God, we humbly beseech thee to look with favor upon this Parliament of the Republic of Ghana. Grant that it may perform its high duty as in thy sight. Give divine guidance to the President of the Republic. Endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government, this land and people will be well and truly served, and that good purposes for the common human life be realized in our midst. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people and the love for the common good. Bless the efforts of those who struggle to make this vision a living reality. Inspire and strengthen our people, that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. Honorable members, item 3. I did indicate earlier on that I'll be making a statement, not a formal communication, a statement under Order 53(1)(I) and Order 71. The statement is in respect of the refusal of His Excellency the President to assent to the Criminal Offences Amendment Bill 2023, Criminal Offences Amendment Number 2B 2023, and the Armed Forces Amendment Bill 2023. Honorable members, on the 12th of December 2023, I received a communication from the President of the Republic, His Excellency Nana Addo Dankwa Akufo-Addo, in the form of a memorandum dated the 12th of December 2023 in respect of 3 bills out and sent to him for assent. The former communication to me was copied to the Majority Leader and Minister of Parliamentary Affairs, Honorable Osechi Mensah Bonsu. Honorable members, as you may recall, on Monday, the 18th of December 2023, I brought to your attention the President's refusal to assent to these three critical bills. A decision conveyed through a letter dated the 12th of December 2023, as I just stated. The bills, the subject matter of His Excellency's communication to me are: 1. The Criminal Offences Amendment Bill 2023. 2. The Criminal Offences Amendment Bill number 2, 2023. And 3. The Armed Forces Amendment Bill 2023. Following the reading of this letter, I openly express my strong disagreement with the President's position on the matter. Today, I present this formal statement to thoroughly articulate the reasons behind my dissent and to lay a clear path for this esteemed House to deliberate on our subsequent actions. At the outset, it is imperative to remind ourselves of our collective responsibility, be it as members of the executive, judiciary, legislature, or as citizens of Ghana, to uphold and defend the Constitution. The Constitution is supreme and serves as the litmus test to determine the validity or otherwise of our actions. Let me recount the famous dictum of Aqua JSC, as it then was, who noted rather succinctly in the case of Mensima versus Attorney General as follows. I quote him: Article 1(2) of the 1992 Constitution is the bulwark which not only fortifies the supremacy of the Constitution, but also makes it impossible for any law or provision inconsistent with the Constitution to be given effect to. You all know Article 1(2), but I want to read it to the hearing of everybody. Article 1(2) says, "This Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void." Honorable members, the supremacy of the 1992 Constitution as asserted by the Supreme Court is critical. Under the concept, governmental powers, be they executive, legislative, or judicial, are to be exercised subject to the provisions and dictates of the Constitution. This Parliament, unique in our nation's history, now stands at the precipice of an unprecedented challenge. For the first time, especially under the Fourth Republic, we are witnessing a president's refusal to assent to and to retain 3 bills that have been passed by Parliament. This situation demands our utmost prudence and a deep sense of gravity, as it bears significant implications for the evolution and resilience of our burgeoning democracy. Our roles as the President, Speaker of Parliament, Members of Parliament, among others, are conferred upon us by the 1992 Constitution. It is of utmost importance that we remain acutely aware of the Constitution's provisions, ensuring that in exercising the powers bestowed upon us, we adhere strictly to the boundaries and limits set forth. Our actions and decisions must always reflect a deep respect for and adherence to the constitutional framework that governs our nation. It's important I give a background to this whole matter. Honorable members, to ensure my position on this matter is clearly contextualized and exigencies on how we got here is required. Conversant with Ghana's pro-abolitionist position on the death penalty since 1993, and the strong proposal to replace it with imprisonment for life. In answering an urgent question filed by Honorable Francis Xavier Kojo-Sosu on July 28, 2021, the Minister for Justice and the Attorney General suggested Parliament could enact the relevant laws to amend the existing law via a private member's bill. Members can read the official report of 27th July 2021 at page 064, column 2. Members, you recall on the 9th of June 2021, the said member submitted a request to Parliament for the drafting of a private member's bill to amend the Criminal Offences Act 1960, Act 29, to give effect to the recommendations of the Constitution Review Commission on the abolition of the death penalty. On the advice of the Legislative Drafting Office of Parliament, the Speaker admitted the request of the member and directed the Drafting Office to submit a draft legislation for the consideration and comments of the member. Given the sensitive and critical nature of this bill, it underwent extensive stakeholder consultations to gather diverse perspectives on its provisions. Among the stakeholders engaged were the Ministry of Justice and Attorney General, Justice of the Court of Appeal, diplomats, chiefs, private legal practitioners, representatives from the Ghana Police Service and the Ghana Armed Forces, Amnesty International, and various human rights groups. The feedback was overwhelmingly positive, with many stakeholders acknowledging the bill's merits and lending it their robust support. The Attorney General's Department assisted the committee throughout its meetings and workshops until the bill was read the third time and passed on the 25th of July, 2023. The bill was submitted to the President for assent by a letter dated 3rd August 2023 and assented to same day by the President, even though written 2nd August 2023. The bill was gazetted as the Criminal Offences Amendment Act 2023, Act 1101, published and made available to the public. So it was no longer a bill, it's now an act. After the passage of the other bills, the other two bills, that is the Criminal Offences Amendment No. 2 Bill 2023 and the Armed Forces Amendment Bill 2023. They were sent to His Excellency for assent. As mentioned earlier, the President declined to give his assent. He based his refusal on a detailed examination of the relevant constitutional and legislative frameworks, notably Article 108 of the Constitution and Section 100 of the Public Financial Management Act 2016, Act 921. The President's assessment concluded that the bills introduced as private members' bills failed to align with constitutional provisions. He concluded that given their significant fiscal implications, these bills should not have been introduced without a comprehensive fiscal impact analysis and without being initiated by or on behalf of the President. The foundation of my disagreement with the President's position on the refusal to assent to the three bills is anchored on four critical aspects of constitutional interpretation and procedural adherence. Firstly, honorable members, I'll be expecting your comments, and so if you talking, you may not hear what I have stated. Firstly, I have already stated that the Criminal Offences Amendment Bill 2023 had been assented to by the President on the 3rd of August 2023. It has been gazetted, it has been published, and it's now an act, Act 1101. The President can no longer come back and say that he will not assent to it as a bill when it is now not a bill. It's already an act. And it was communicated to Parliament with copies of the assented bill, which was published as act and sent to us, and is being made available to the public already as an act. That's the first point. Secondly, there exists a fundamental discrepancy between the President's understanding of Article 108, particularly its fiscal implications, and the actual text and context of Articles 106 and 108 of the Constitution. This misinterpretation overlooks the nuanced distinction between fiscal and financial impacts as outlined in the Constitution. Thirdly, the determination of any unconstitutionality is the sole purview of the Supreme Court, not the President. Hence, if there were concerns about Parliament acting beyond its constitutional authority, the appropriate course of action would be an action before the Supreme Court, not an declaration of unconstitutionality. Again, the constitutional discretion vested in the person presiding over the proceedings in Parliament as per Article 108 and subject to Article 296 suggests that any allegations of misuse of this discretion should be contested in the court of competent jurisdiction rather than being preemptively adjudicated upon by the President. The President has no right to review the decision of the Speaker in this matter. Moreover, Article 1068 clearly outlines the protocol for presidential refusal to assent, which involves specifying objections for parliamentary reconsideration, not a blanket rejection of the bill. This approach, as taken by the President, not only contradicts the constitutional procedure, but also poses serious implications for the future of private members' bills, as it implies an unrealistic standard where virtually every bill could be construed as having financial implications. Honourable members, let's look at Articles 106 and 108 and the exercise of legislative power. Article 106 of our Constitution is clear in its mandate. It provides that the power of Parliament to make laws is exercised through bills accompanied by detailed explanatory memoranda and published in the Gazette well before their introduction in Parliament. And let me quote Article 106 in extenso. It says, the power of Parliament to make laws shall be exercised by bills passed by Parliament and assented to by the President. Clause 2 says, no bill other than such a bill as is referred to in paragraph A of Article 108 of this Constitution shall be introduced in Parliament unless A, it is accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defect law, the remedies proposed to deal with those defects, and the necessity for its introduction. And B, it has been published in the Gazette at least 14 days before the date of its introduction in Parliament. Article 108 specifies the kind of legislation that requires introduction by, on behalf of the President, particularly focusing on fiscal matters such as the imposition or alteration of taxation or charges on public funds. It is my firm contention that the bill, while carrying financial implications incidentally, do not fall within this narrow scope of fiscal legislation as defined by Article 108. And Article 108 says, Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, A, proceed upon a bill, including an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following. Roman 1, the imposition of taxation or the alteration of taxation otherwise than by reduction. Or Roman 2, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of such charge otherwise than by reduction. Or Roman 3, the payment, issue, or withdrawal from the consolidated fund or other public funds of Ghana of any monies not charged on the consolidated fund or any increase in the amount of that payment, issue, or withdrawal. Or Roman 4, the composition or remission of any debt due to the government of Ghana. Or B, proceed upon a motion, including an amendment to a motion, the effect of which, in the opinion of the person presiding, would be to make provision for any of the purposes specified in paragraph A of this article. Honorable members, the Constitution must be read and interpreted as a cohesive whole. The framers of our Constitution, in their wisdom, did not intend to create an absurdity where any bill with financial consequences would fall under the stringent requirements of Article 108. Such a view would be overly restrictive and would significantly impede the legislative function of Parliament as envisaged under Article 106. The provisions in the Constitution are supposed to work harmoniously from a rational, consistent framework. In the case of Tufo versus Attorney General, the Supreme Court noted that, and I quote, should be avoided which leads to absurdity. And when a particular interpretation leads to two, shall we say, inconsistent results, the spirit of the Constitution would demand that the more reasonable of the two should be adhered to. We must recourse to the Constitution as a whole, unquote. Honorable members, a thorough review of Article 106 through to 108 would outline the mode of exercising leading legislative powers and the limits thereto. The President admits in his letter that the Constitution admits a possible scenario of the initiation of private members' bills. That one is not in contention. The text of Article 106 read together with Article 108 clearly demonstrates that not all bills to be deliberated upon by the House ought to be introduced by the President. In Article 106(2), it outlines that the usual procedure for enacting bills does not apply to special categories of bills outlined in Article 108. Similarly, The restriction on delaying a bill in Parliament for more than 3 months applies only to bills initiated by President as outlined in Article 106, Clause 14. To that extent, it is quite clear that the 1992 Constitution contemplates the introduction of bills by the President. The restrictions on such bills include the bar on retrospectivity as outlined in Article 108, and then the settlement of financial matters as outlined in Article 108. The main question that then arises is, if the provisions in Article 108 suggest that any bill that has financial implication for the state must be brought within the boundaries of that provision, is that the suggestion? Honorable members, to address this, let us turn to the language of the article, and please, I will not repeat it because I've already read it to members. The term imposition of a charge generally refers to the act of applying a fee, levy, or financial demand on an individual, organization, or entity. This provision, honorable members, speaks directly to a process of legally mandating payments of financial obligations from the consolidated fund or other public funds, which must be initiated by a bill presented by the President. The emphasis here is on direct financial obligations, that is, explicit requirements for payments from these funds. This is essentially the legislative process of allocating money from the consolidated and the other funds for specific government expenditures. Honorable members, when read in conjunction with Article 108, Clause A, Roman 2, Article 178 outlines the conditions under which withdrawals can be made from the consolidated fund. The Constitution provides in Article 178, Clause 1, Subclause A, that, I quote, no monies shall be withdrawn from the consolidated fund except to meet expenditure that is charged on that fund by this Constitution or by an Act of Parliament. The same term is used there, charged. Similarly, Article 179 elaborates on the authorization of government expenditure, including the preparation of budget estimates by the President, which are then laid before Parliament. By reading these provisions conjunctively, it becomes clear that Article 108, Clause A, Subclause Roman 2, is concerned with direct payments and explicit financial obligations from the consolidated fund and other public funds primarily related to government expenditure. These are not just incidental or indirect financial implications, but are specifically about the allocation and use of state funds in a direct manner. In this analysis, honorable members, let us consider Chapter 13 of the Constitution, which deals with finance. This chapter provides the necessary context for dealing with fiscal matters, elaborating on the processes and principles governing the management of public funds, budgetary allocations, taxation, and financial legislation. Reading Articles 108, 178, and 179 together, one can come to the conclusion that Article 108 Clause A Roman subclause 2 relates to direct payments and financial obligations from the Consolidated Fund and other public funds to meet government expenditure. Now let's consider the nature of the bills in question. Whilst they may carry financial implications, primarily related to the costs of incarceration and healthcare, these do not amount to the direct imposition of a new charge on the Consolidated Fund or other public funds. The financial implications here are consequential and incidental, rather than being the creation of a new fiscal obligation. Therefore, interpreting these bills as falling within the ambit of fiscal legislation as outlined in Article 108A subclause 2 stretches the meaning of imposition of a charge beyond its intended scope. Honourable members, it is imperative to underscore that literal and narrow interpretation of fiscal bills could unduly constrict the legislative autonomy granted to Parliament. Such an approach will not only be contrary to the spirit of the Constitution, but will also set a precedent that could hinder our ability to address the diverse needs of our nation through private members' legislation. Honourable members, the bills under consideration do not create new fiscal obligations, therefore should not be constrained by the provisions of Article 108. It is worth noting that the President nor Parliament has no power to declare an act unconstitutional. Out of the abundance of caution, I must note that Article 2(1) of the Constitution outlines that any allegation of any unconstitutionality must of necessity be grounded in a course of action before the Supreme Court. The Constitution vests the power to declare an act unconstitutional solely in the Supreme Court. This principle is central to the doctrine of separation of powers and the rule of law. Firstly, it is crucial to understand that if the President believed that Parliament acted ultra vires or beyond its constitutional powers in passing these bills, the constitutionally sanctioned course of action would be to refer the matter to the Supreme Court. The President does not possess the authority to unilaterally declare parliamentary actions unconstitutional based on personal or executive assessments. Such a course of action is not only within the contemplation of our laws, but breaches the established procedure for constitutional adjudication. Honourable members, in the context of our discussion, this means that the bills passed by Parliament are presumed to have been enacted following all due processes and constitutional requirements unless proven otherwise. The presumption of regularity of official acts, a principle embedded in Section 37 of our Evidence Act 1975, NRCD 323 is pertinent. This presumption implies that official duties and actions such as those undertaken by this Parliament, are presumed to have been carried out in accordance with the law and established procedures. The burden of proof, therefore, lies on those who assert irregularity or unconstitutionality. Until evidence to the contrary is presented and substantiated in the court of competent jurisdiction, this presumption of regularity stands. Therefore, honorable members, in the absence of a judicial determination from the Supreme Court, the President's unilateral assessment of unconstitutionality does not hold legal water. It is a departure from the established legal procedure, norms, and practices that govern our constitutional democracy. The appropriate lawful response, if there were genuine concerns about the constitutionality of the legislative action of this House, would have been to seek judicial review from the Supreme Court. The steps taken by the President in this matter reflect a misunderstanding of the constitutional process and undermine the principles that uphold our democratic governance. Honorable members, I want to emphasize that the constitutional responsibility to determine whether a bill falls under Article 108 or not is mandated, and it resides in the person presiding over the proceedings. Honorable members, it is imperative to understand this discretionary power is not arbitrary, but is governed by principles laid out in Article 296 of the Constitution. Article 296 regulates the exercise of discretionary power, mandating fairness, candidness, and reasonableness. It provides a framework within which such discretion must be exercised, that it is not used capriciously, but in line with constitutional principles and the rule of law. Therefore, the determination of whether a bill complies with the stipulations of Article 108A is exclusively within the purview of the person presiding over the parliamentary proceedings. It is their constitutional mandate to assess and decide, guided by the principles of Article 296, whether the proposed legislation falls within the ambit of financial or fiscal matters, which requires presidential introduction. Honorable members, the discretionary power vested in the presiding officer is a safeguard of parliamentary autonomy and a cornerstone of our legislative process. Therefore, any attempt to usurp or undermine this discretion, not grounded in judicial review, is not only constitutionally unsound, but also a breach of the fundamental principles that govern our democratic state. Under Article 1068, when the President refuses to assent to a bill, two courses of action are available to him. Firstly, he is required to state in a memorandum to the Speaker the specific provisions of the bill which, in his opinion, need reconsideration by Parliament. This includes recommendations for amendments if necessary. the President can inform the Speaker that he has referred the bill to the Council of State for consideration and comment under Article 90 of the Constitution. Following this, Article 1069 mandates that Parliament shall then reconsider the bill, taking into account the comments made either by the President or by the Council of State. This process ensures that concerns raised are duly addressed and that the legislative process remains dynamic and responsive. Honorable members, finally, Article 106(10) stipulates that if a bill upon reconsideration is passed by Parliament with a resolution supported by not less than 2/3 of all members of Parliament, the President is then obligated to assent to it within 30 days of the passing of the resolution. Honorable members, this procedure underlines a critical aspect of our constitutional democracy. The President cannot outrightly a bill in its entirety. The constitutional route provided for dealing with disagreements on the bill requires specific actions focused on collaboration and reconsideration rather than outright dismissal. The approach adopted by the President in this instance, where the bill has been wholly rejected and not returned to Parliament but retained by the President, is not within the contemplation of our laws as stipulated in Article 106. This procedure adopted by the President, bypassing dialogue and reconsideration, undermines the constitutional process and the legislative authority of Parliament. Honorable members, I have stated clearly that one of the bills, the Criminal Offences Amendment Bill 2023, is already an act. Criminal Offences Amendment Act 2023, Act 1101, after it was assented to by the President on the 3rd of August 2023. So the President can no longer write a letter to say that he is not going to assent to that bill. There is no longer any such bill before the House. In light of these considerations, honorable members, it becomes clear that the actions taken by the President in refusing to assent to all the three bills do not align with the constitutional principles and procedures that govern our legislative process. This House, as the representative of the people and the custodian of legislative authority, must uphold the sanctity of the Constitution and ensure that its provisions are adhered to in both the letter and the spirit. Honorable members, the floor is now open for your deliberations. This is a moment for us to engage in a thoughtful and constructive dialogue to express our views and to bring our collective wisdom to bear on this matter of national importance. The resolutions or decisions we arrive at following these deliberations will guide our next step in this matter. They will form the basis of our collective response to the President and will chart the course for how this Parliament handles similar situations in the future. This is a defining moment for our democracy, and the decisions we make will have lasting implications. Our actions here will reaffirm our commitment to democratic principles and the rule of law, ensuring that the will of Parliament, as the embodiment of the people's will, is respected and upheld. Honourable members, I want to remind you of a similar situation in this House, where this House decided to legislate and to give its authority to determine the number of ministries to the executive. And as a result, the executive now decides how many ministries to establish and how many ministers to appoint. I hope in this particular instance, Parliament will take note and be advised accordingly. I thank you all for your attention. We will take comments on this statement. Honorable Yes, Deputy Majority Leader.
Mr. Speaker, thank you for the invitation made to us as a House to comment on your opinion by way of response to a view expressed by His Excellency the President on this matter. Suffice to state that, Mr. Speaker, when Mr. President's letter came, you urged on us to hold fire and that you want to give a detailed view. You want to express a detailed view on this matter. And Mr. Speaker, we've heard you. My view is that since you wanted to make good input on the views expressed by Mr. President, perhaps it would be helpful, Mr. Speaker, if you give us your opinion, you circulate it for us to also digest. Then we can make a much more informed comment on this. Yes, both, correct. All right, Mr. Speaker, my respected friend, the Minority Chief Whip, has asked me to amend my application so that it will help all of us. So, Mr. Speaker, this House will be pleased to have the letter from Mr. President, your own opinion critiquing Mr. President, so that, Mr. Speaker, we can have a well-informed discussion on this matter. So, Mr. Speaker, having said so, I pray that we place the request to make comment immediately on ice until such a time that the House will be seized with your critique and that of Mr. President's opinion on the legislative powers exercised by us. Mr. Speaker, I humbly so submit, sir. Thank you.
Let me talk about the application. I will come to you. All what you need have been made available to you. First, all the communications from the President are read to you here, and they are contained in the Hansard official report. So there's nothing that is not made available to you. Today, I have made available to you my opinion, and it's also captured in the official report. That is also available to you. including my personal comments as I read the messages. There are some pieces of advice and there are some personal comments I make. The only application I can consider is if the House is requesting for a later date to make comments, but not that I should make available the communications and my views or opinions to you. That one has been made available to you. But let me listen to the others and then I'll come back to that. Yes, Honorable Mama Yarga.
Mr. Speaker, on this specific issue of when we should be commenting on your very erudite, well-reasoned and deeply intellectual ruling on the communication from Mr. President, I don't believe that, given the legal capacity of the deputy majority leader, who has practiced in all the courts up to the Supreme Court, and who has been trained to reason on his feet. Mr. Speaker, I doubt if he needs, in advance, your script in order to be able to comment eloquently on what you have presented. Mr. Speaker, unless he wants to run away from the discussion today. If he wants to run away from the discussion today, he can tell us. But knowing him, I am very confident that he is very capable of commenting on what you have said and what the President said, and which was communicated to this House several days ago. Mr. Speaker, I don't think there's a need for us to buy more time to discuss this. It is so important that members should be given the opportunity to comment on it, Mr. Speaker. And that is why I want to proceed to comment on the matter. Mr. Speaker.
Let me listen to Majority Leader. I'll come back to you. Yes, Majority Leader, you were trying to make a point.
Yes, Mr. Speaker. I wanted to reinforce the facts of the application before you. You are indicating to us that all what you require to say in the President's communication to you finds expression in the Hansard. But, Mr. Speaker, what you have done today doesn't find expression in the Hansard because the Hansard is not available. And that is why the Deputy Majority Leader was urging you to stand any discussion on what you have said, because you want to place the two in a scale and be able to deliberate and speak to the issues that you are speaking to. You yourself, after the communication that came to you on Speaker, you had the communication on the was it the 12th? The 12th of December. And you communicated to us, was it the 18th or so? It took some time for you to come to this House and communicate to us what the President had submitted to you. And after that, your own initial remarks, you said we should hold on any comment and wait for your reasoned analysis, which is what we've done today. And I think that the most appropriate thing to do would be to avail what you have said to us, so be able to properly interrogate what the President has communicated to us and your own understanding of the law will put the two together there for us to make an informed deliberation on the two. Because, Mr. Speaker, after all, progressing on the matter further rests with this House. It rests with this House and not the chair. So I would want to appeal that yield to the application which has been submitted by the Deputy Majority Leader. So we hold fire, and then at the appropriate time, we come and thoroughly debate this matter. Mr. Speaker, thank you.
Honorable Majority Leader, the communication was received in my office on the 12th of August, but got to me 13th August, and so I brought it and read to you on the 13th August. And immediately after reading it to you, I made those comments on the 13th of August.
Mr. Speaker, you are getting the dates wrong. It's not August. You read to us in December. You read them to us in December.
I'm talking about December, not August. Yes, it was received in my office on the 12th of December and got to me on the 13th of December. And I read it to the House the same day, 13th of December, and made comments on the same day. Now, the proposal being put across is that when a statement is being made on the floor, because the answer is not available, it means it cannot be commented upon. We have to postpone for members to get the answer before you do so. That, I believe, is not correct. And so, it's not something that can convince me to postpone your comments, even though I'm taking your views into consideration. Again, when you talk about a house, this house includes the 275 plus the speaker. So the steps to be taken after your comments is not only left to the 275, it includes the speaker, and that is the chair you referred to. So the chair will still be part of the next steps to take in this matter. Was to start with, communication between Parliament and the office of the Speaker is through the Speaker. And the office of the President is through the Speaker. And that is one of the things that, after the comments, this House will have to proceed to amend some laws in this country. Because after the passage of the bills here, apart from financial bills, the Speaker doesn't get to have sight of what is compiled before they are submitted to the office of the President. And so all these things that I've narrated to you happen behind the back of the Speaker. I had no knowledge of it until I received the letters from the President. And my research in the matter has unearthed a lot of irregularities. That's why I used the first term the other day, that it was irregular, wrongful, and unconstitutional. And this opportunity is for us to comment, for us to improve the legal framework in the country. So please, let's take it serious. He was on his feet, Honorable Mama Yarga.
Thank you very much, Mr. Speaker. Mr. Speaker, I'm sure for the past 3 decades in this House, the issue of whether or not, as a Parliament on our own, we can initiate legislation has been a very vexed issue. In recent times, under your leadership, we have made significant gains in that members have been encouraged and several private members' bills have come to this House. Members have enthusiastically participated
in processing those bills. And in fact, one of the bills that is the subject of the discussions today, the person sponsoring the bill took time off and visited the president in his office and tried to win his support even before the introduction of the bill. And I read newspaper publications of the president encouraging him to proceed with the bill in Parliament. And he then came and sponsored a private member's bill. And when we deliberated and passed the bill, the president assented, Mr. Speaker. So to have the president do a U-turn the way we see him do raises very serious constitutional issues. But Mr. Speaker, like we are all doing here, the president is equally entitled to raise constitutional issues. He's equally entitled. Just as Mr. Speaker is entitled to raise constitutional issues, I am entitled to raise constitutional issues. I believe that the president also has a right to raise constitutional issues and may raise them. The question is, under what circumstances, at what forum, and where can the president raise which constitutional issue? So, Mr. Speaker, I think that the issue is that in this matter, our constitution is clear that when a private member's bill is being introduced, it is within the discretion of Mr. Speaker to determine whether or not it has the financial implications that are contemplated by the Constitution as grounds on which those bills can only be introduced for or on behalf of the President. If he misses that opportunity, Mr. Speaker, if he misses that opportunity, his next stop in trying to stop a bill will be the Supreme Court. He cannot come back to this House.
Only where it is inconsistent. Only.
If he misses that opportunity to have the issue raised at the point when the bill is being introduced, and you, Mr. Speaker, are exercising the discretion to admit that private member's bill, if he misses it, he has to go to the Supreme Court. Mr. Speaker, the President has no excuse for missing the opportunity to raise the issue. And the reason why I say he has no excuse is that in this House, the President has appointed a minister responsible for parliamentary affairs and who is the head of government business in the House. So it cannot be said that the introduction of the bills happened on the blind side of Mr. President, because his minister responsible for parliamentary affairs and head of government business in the House was here sitting in this House and participated in conclave with you, Mr. Speaker, and is aware that such bills are being introduced in this House. So Mr. President is constructively aware of the exercise of your discretion to admit this bill. Mr. Speaker, beyond him, the President has a Minister for Justice and Attorney General who is a non-voting member of this House and who is aware of this bill. Indeed, officials of the ministry were conscripted and participated in helping to shape the final outcome of the bill. And I participated in some of the seminars and the meetings where officials of the Attorney General were present and helped to shape this bill. So again, the President is constructively aware of the exercise of your discretion to admit this bill. So he cannot, after everything is done, go and write a letter like this to this House. Mr. Speaker, it is important to note that there is a provision in Article 69 of the Constitution, Mr. Speaker, Article 69 of the Constitution is very, very important. That is the article that deals with the issue of removal of president. Removal of president. Mr. Speaker, is very, very important. Removal of president. It says that the president shall be removed from office if he is found in accordance with the provisions of this article. A. To have acted in willful violation of the oath of allegiance and the presidential oath set out in the second schedule, or in willful violation of any other provision of this Constitution. Any other provision of this Constitution. If the president willfully violates any other provision of this Constitution, it is grounds for his removal, Mr. President.
Mr. Speaker.
Mr. Speaker, it is grounds for his removal. And I went to pains to establish the fact that the president was aware of what happened, encouraged what happened, patronized what happened, and after it had happened, all in accordance with the Constitution, he then willfully, Mr. Speaker, willfully wrote a letter and clearly violated provisions of the Constitution. That is why I'm drawing attention to the fact that what he has done constitutes grounds for his removal. They constitute grounds for the removal of Mr. President. So, Mr. Speaker, this is not a light matter. I don't want to go into the details because what you have said, Mr. Speaker, is enough to explain the legal implications of what he has done. Mr. Speaker, I don't believe that there is any other useful legal argument that we can make in support of what you have already said. It is within your discretion to admit a private member's bill, even if in fact, Mr. Speaker, even if in fact you abuse your discretion, it is not through a letter to this House that Mr. President can exercise your own abuse of your discretion. Even if, without admitting that you abuse your discretion, that you interpreted the Constitution wrongly, that the bill actually had financial implications, but you decided not to admit that they have financial implications and went ahead and admitted those bills to be considered by this. Even if you abuse your discretion, the position of this Constitution is that the President cannot write a letter to you or this House saying that he will not sign or assent to a bill or refer it to the Council of State because he thinks that the bill had financial implications and therefore were in violation of the Constitution. That is where I see the flagrant violation of the Constitution by Mr. President. That's why I'm drawing his attention to Article 69. So, Mr. Speaker, I am surprised that this has happened, and I know that there's been background discussions of this matter. I recall that you raised the issue some time ago in this House, and so, Mr. Speaker, we even had some discussions in this House about whether or not, properly speaking, he had refused to assent to the bill within the constitutionally prescribed period within which he was either to assent or communicate his decision not to assent. So this is a matter that has been going on for a while. So it is obvious that what has happened is a president deliberately engaging in a conduct aimed at violating a provision of this Constitution, the provision on the passage of legislation, which says that when we have finished our work and presented it to him for his assent, either he assents or writes to you to say, I will not assent. And if he does so, he should refer it to Council of State. It is obvious in the Constitution. If he refuses to do that, but chooses to write a letter to you to tell you that our conduct is unconstitutional, he has willfully violated the provisions of the Constitution that give us the power to do what we have done, and which also gives him a responsibility after we do what we have done. So, Mr. Speaker, I think that we should begin to think of triggering the provisions of the Constitution relating to what to do to the President when we willfully violate a provision of the Constitution. We should begin triggering those provisions. The President has violated the Constitution. Violation of the Constitution is grounds for his removal from office. Mr. Speaker, I think that is where the direction of discussion should be going from now onwards. Thank you very much, Mr. Speaker.
Deputy Majority Leader.
Mr. Speaker, save that you have not ruled on my application, I shall proceed to express some limited views pending my full receipt of your opinion. And if you so grant this House another opportunity, I would make known my full views on the matter. So, Speaker, you, in justifying why we should express views now, did say that when a statement is made, that statement does not need to get into the Hansard before members may comment. But, Mr. Speaker, those are statements to be made by members or ministers under Order 72 of the rules of this House. Because in that situation, the admissibility is determined by you. And when it's admitted, it is circulated. Members are given copies ahead of time before the statement is read. So, Mr. Speaker, yes, Mr. Speaker, that's a practice. So, Mr. Speaker, to say that you are invoking Order 72 to direct that we should make comments now, Mr. Speaker, you are the sovereign of this House.
Honourable member, please. I have not directed.
Mr. Speaker,
I have not directed.
What have you done, sir?
I have not directed you should make comments now. I just decided to listen to a number of you express your views, not just comments. And you express yours. He has just done that. I've not given any directive. But you know that statements are not distributed to members before they are read on the floor. You know it. And you have just stated that.
Mr. Speaker, ordinarily, you know I wouldn't want to challenge you. But, Mr. Speaker, my few years in this House, when you admit statements, members give copies ahead of the reading of the statement. Mr. Speaker, that has been the practice. And I say so for a fact, Mr. Speaker. I say so for a fact. I beg to disagree, Mr. Speaker, just as you disagree with Mr. President. I beg to disagree. It is a practice in this House that when statements are admitted, the member who has filed the statement, whose statement has been admitted, gives copies to members. Mr. Speaker, that is not the case in this matter. But, Mr. Speaker, you are the most wise sovereign, well placed in the east of this chamber to preside. Therefore, we will yield to your directions, your suggestions. And if you insist, we would proceed. Mr. Speaker, I would, Mr. Speaker, suggest strongly that, Mr. Speaker, please consider my application. Mr. Speaker, because you have a detailed opinion, which opinion is not only expressing a disagreement, but is also critiquing an opinion expressed. Mr. Speaker, we know as tried learning that procedure is as important as the substance for which any rule seeks to achieve. Mr. Speaker, in our courts, when the procedure is wrong, the entire superstructure of substance is brought down. And we know you can't place something on nothing. We know that maxim. So, Mr. Speaker, we have before us an opinion expressed on a matter of procedure. No one should incline to the views by Honorable Ayerega, who is trying to take us to another arena of constitutional breach by Mr. President. Mr. Speaker, he had really nothing to say except to try another political game. Mr. Speaker, there is an opinion that has been expressed. That opinion has received a counter opinion. But unfortunately, this opinion appears to be a critique of another opinion. And Mr. Speaker, for any member here to say that we should turn this into an NDC MPP affair will not help the constitutional development of our democracy. Yeah, Mr. Speaker says he's not forcing us to make comments. He only invited us. But Mr. Speaker, we need the detailed opinion of Mr. Speaker in order to proceed. Mr. Speaker, the Honorable Professor, I know the Honorable Professor has not spoken into the mic, but he claims that he has heard Mr. Speaker. You see, what Mr. Speaker has done is a matter of law. It's a matter of law. And he's teasing our views. We need details of it so that we can enrich the debate. And that is the government of my prayer. We should pay attention and listen well so that we can all contribute. Mr. Speaker, I therefore submit again.
Yes, please.
Mr. Speaker, I therefore submit again that on all fours, the burden of my call is well founded. That, Mr. Speaker, if you listen to your little boy, we will make very useful input. Just as you've done, Mr. Speaker, on the 13th, you had this communication, and Mr. Speaker said, stay put. Members, don't comment yet. Let me also go and read. Mr. Speaker, you've done a great research. You don't want us to research and make comments for Hansard, for posterity to also come and read what we have done. Mr. Speaker, that would be unfair. And if members insist that they have merely listened and they want to proceed, they may proceed. Save that, Mr. Speaker. You may give another opportunity for us to do a detailed discussion on this matter. I rest my case.
Honorable members, this is a statement and it's not for debate. It's for comments. This House can proceed based on the comments to a debate by converting it into a motion or whatever later, because it will be the decision of the House that will determine the next step to take by this Parliament. I've told you that the bills have not been returned even to us. They have been retained at the presidency. The presidency has not pointed any provision that they disagree with. They have not given us any comments on any provision as stated in the Constitution, but just that they have constitutional concerns. If that is how you want us to go, then forget about private members' bills, because every president will always have constitutional concerns. Please, I say comments. After that, we'll determine whether to do a debate later or not. But let me listen. Honorable Dafimakwa wanted to raise an issue. He will speak. Okay, your leader wants to say something.
Honorable Speaker, yes, the honorable member will speak, but we wanted to, first of all, make the point that we are agreeing with you that we do initial comments on these very heavy issues you've raised, which really borders on the Constitution. We believe that we have to revisit the issues at a later time, as has been proposed, for a very thorough debate. But I think your call was in the right direction. First of all, you started off with Order 53 the order of business and went to order 71, which was within your right to do so. And after that, you have access to make comments. Our suggestion is that you allow 3 people on each side to make those comments. And we believe that at a future date, you have the opportunity to thoroughly debate this matter.
What we have there.
Thank you very much, Speaker.
Yes, Honorable Dafio.
Speaker, thank you for the opportunity to state that the attempt by the Deputy Majority Leader to rehash his application that you had ruled on is salient to this House. He knows what to do. If he is agreed by your decision, he knows what to do. He knows that he has to come formally. Mr. Speaker, let me use the opportunity to make my comments on the statement that you eruditely placed before the House. Mr. Speaker, the Constitution is very clear that what the President did, Mr. Speaker, is very, very alien to the Constitution. Because the Constitution is very clear that where the President decides not to assent to a bill, the communication to the House is not supposed to be in the letter. The Constitution prescribes what you should do. It says a memorandum. A memorandum is not a dear Mr. Speaker. He has to come formally with the terms of his concerns in the bill, the recommendations, and all that. Mr. Speaker, and therefore I agree with you that the President acted in a manner that is alien to our constitutional provisions. He is obligated in law and under the Constitution to remit the bills back to the House for reconsideration. He hasn't done that. The time limited for that is past. That is why I adopt the submission by my senior at the bar and the chamber, the Honorable Mama Yariga, that it appears that the conduct of the President is one that we can regard as willful. Is willful breach of the Constitution. Mr. Speaker, your ruling today, in addition to other rulings that you have given in this House, it said that it will be a precedent for future speakers to follow. Mr. Speaker, when you go to other parliaments, the parliaments of Australia, the parliament of Canada, the parliament of the UK, the parliament of New Zealand, speaker on serious matters of procedure gives rulings. And Mr. Speaker, the Honorable Deputy Majority Leader, you know what to do when you disagree with me. So don't yell across the aisle. Keep calm, take notes, and respond to me. Mr. Speaker, what you have done is to rule on the propriety of the procedure adopted by the President. And he says there is not a ruling. It's a ruling. You have ruled. You have determined that the President was wrong in writing letter to him. He ought to have come by a memorandum detailing. You see, rulings don't come from only judges. In our parliamentary jurisprudence, speakers deliver what we call rulings. My brother, on matters of parliamentary procedure, the parliamentary procedure for the President to engage Speaker or the House in this matter is contained. Mr. Speaker, with your leave, let me read. If you go to Article 106 clause 8, it says where the President refuses to assent to a bill, he shall within 14 days, Mr. Speaker, after the refusal, that's the procedure. The Honorable Deputy Majority Leader should listen, that's the procedure. A, state in a memorandum to the Speaker any specific provisions of the bill which in his opinion should be reconsidered by Parliament. That is the procedure. He didn't follow that. Mr. Speaker, the provision continues, including his recommendations for amendments, if any. He hasn't come to this House with any recommendations. It's a procedure that he has breached. Mr. Speaker, B is to the effect that or he will inform the Speaker that he has referred the bill to the Council of State, the consideration and comments and the Article 90 of this Constitution. Mr. Speaker, clearly, he has also told you that he has by election referred the bill to the Council of State. So your statement to this house this morning is actually a ruling on the constitutional procedure adopted by the President in engaging the House. Mr. Speaker, I thank you for the opportunity.
Yes, Honorable Bernard Ayefo.
Mr. Speaker, thank you very much for giving me the opportunity to comment on your erudite statement showing great knowledge of law. Mr. Speaker, I have read the letter emanating from the President as well as the memorandum of understanding on the bills passed by this House and presented to the President for assent, and I vehemently disagreed with the President and agree with your statement in all force, because it is in line with the Constitution, it is in line with the laws that govern our legislative process. Mr. Speaker, it is trite-learning that when a procedure is set down for a right to be exercised, it is that procedure alone that will have to be followed in exercising the right. Mr. Speaker, this is clearly spelled out in the case of Ashka versus Karam, reported in 1972 One Ghana Law Report, page 1. Mr. Speaker, so also is the decision of the court in the case of Boyfield versus NTAC, reported in 1997-98 One Ghana Law Report, page 768. Mr. Speaker, we all know that the legislative power is vested in Parliament, and that is clearly spelled out in Article 93 of the Constitution of the Republic of Ghana. And the procedure that Parliament use or exercise the legislative power in making law is spelled out in Article 106 of the Constitution of the Republic of Ghana. Mr. Speaker, this private member's bill has gone through the procedure, satisfied the conditions, and Parliament indeed passed these bills and presented it to the President for assent. Mr. Speaker, what the President is also supposed to do is regulated by the Constitution, specifically Article 106, 7 and 8. Mr. Speaker, the President, upon presentation of the bill, is supposed to signify within 7 days his assent to the bill or refusal to assent to the bill. And 8 is very clear that if the President refuses to assent to the bill, then within 14 days, the bill must come back with a memo from the President stating the provisions of the bill that he disagrees with and offering an opinion, including amendment to the provisions that the President has disagreed with. This is clearly spelled out in the Constitution. So failure to do this is a constitutional breach on part of the President. Therefore, I agree with Honorable Ayariga that the President clearly is in breach of the Constitution, and then the impeachment under Article 67 must start now. Article 69 must start now. Mr. Speaker, it is very absurd that after the President has assented to the Criminal Offences Amendment Bill into an act, the President will bring a memorandum that he is refusing to assent. Mr. Speaker, I hold in my hand the 1101st Act of Parliament of the Republic of Ghana, entitled Criminal Offences Amendment Act 2023. Mr. Speaker, an act to amend the Criminal Offences Act 1960, Act 29, to substitute the penalty of life imprisonment for death penalty and to provide for related matters. Date of assent 2nd August 2023. Mr. Speaker, how on earth will a President of the Republic of Ghana, after assenting to a bill, bring a memo, first a letter and followed by a memo saying that he is unable to assent to the bill? Mr. Speaker, something definitely is going wrong at the presidency, and I dedicate myself to support the majority leader to help solve that particular problem happening at the presidency. You cannot assent to a bill and bring it back that you have refused to assent to the bill. It is unfathomable. It can happen in any country. Why? It is clear. You have assented to the bill. It is now an act of Parliament. Mr. Speaker, looking at the letter of the President and the memo, the President indicated that he has agreed and he supports the content of the bill. Of course, he cannot afford to disagree, because what the Armed Forces Amendment Bill and the Criminal Offences Amendment Bill number 1 is seeking to do leads consequentially death sentence and substitute it with life imprisonment. So this is very simple. Once the President has assented to the Criminal and Other Offences Bill into an act, similarly the Armed Forces Amendment Bill, which is the same as the Criminal and Other Offences Amendment, because both bills are seeking to delete the death penalty and then substitute it with life imprisonment. The President must also assent to that particular one. Mr. Speaker, looking at the reasons given by the President in the memo for even attempting to refuse what he has already assented to, is that he has a constitutional concern in Article 108 of the 1992 Constitution of Ghana. Mr. Speaker, Article 108 clearly states that in the opinion of the person presiding, the question therefore, is the President the person presiding? Was he the one who presided over those bills? So, if in the opinion of the person presiding, these bills will not constitute a charge on the consolidated fund, how can the President and the Attorney General constitute themselves into the Supreme Court of Ghana to have been interpreting Article 108 of the Constitution of the Republic of Ghana? Mr. Speaker, it is the Supreme Court that has the exclusive original jurisdiction to interpret the Constitution of the Republic of Ghana, and that is clearly Article 130 of the Constitution of the Republic of Ghana. So, the Attorney General and the President of the Republic of Ghana cannot usurp that exclusive original jurisdiction of the Supreme Court and purport to be interpreting the Constitution of the Republic of Ghana. But Mr. Speaker, what I am suspecting is that the President is trying to preempt assenting to the famous LGBTQ bill. That is why he is having these afterthoughts of trying to now refuse a bill that he has already assented to. Mr. Speaker, these bills are private members' bills. They are very, very important bills. They are of national and international concern. So if the President feels that this is a bill that he ought to have done, but he failed to do it, and he took a private member from the NDC side to shepherd this particular bill into law, and is now trying to arrogate that to himself and take credit for what is not due. Mr. Speaker, I don't think the House should allow the President so to do. Mr. Speaker, what will resolve the problem and probably guard against Article 69 of the 1992 Constitution is for the President to do the honorable thing by assenting to the bill. Mr. Speaker, I thank you for the opportunity to comment on your statement.
Yes, we take Honorable Aruna. Chairman. Yes, after Honorable Aruna, we will.
Mr. Speaker, let me thank you for the opportunity. And Mr. Speaker, I have not enjoyed a lecture on constitutionalism and constitutional law much as I have done listening to you today. And therefore, Mr. Speaker, I want to describe your statement as a gratuitous expression on constitutionalism. And Mr. Speaker, I go home today with 10 takeaways from your illuminating elucidation on constitutional law, the supremacy of Ghana's 1992 Constitution, and the fact that Parliament is not sovereign, and the fact that the President cannot set aside proprietary procedure established by you. And Mr. Speaker, in doing so, you drew attention first to Article 108, and that has been the sole reliance of President Nana Addo Dankwa in trying to set aside what Parliament is lawfully and legitimately authorized to do. Lawmaking is our mandate. Mr. Speaker, you refer to Article 108, and for emphasis, Mr. Speaker, and for learners, let me reread it and emphasize it. Article 108 reads that Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President. So a minister can come for and on behalf of the President. But Mr. Speaker, it says further that in this bill there are exemptions. And Mr. Speaker, you read the exemptions. That if in the opinion of the person presiding, Mr. Speaker, any lawful interpretation of the Constitution rooted in the most authoritative ruling is that give words their ordinary meaning. The ordinary meaning is the person presiding is Alban Sumana Bagbe, the Speaker of Parliament. Ordinary meaning, no absurdity. That if in the opinion of the person presiding, so Mr. Speaker, legitimately and lawfully, not just our standing orders, on the admission of a private member's bill, the discretion is vested in you. And you reminded us again, Mr. Speaker, that in exercising that discretion under Article 296 of the Constitution, you did so candidly, fairly, and not capriciously. That is why, Mr. Speaker, my second takeaway is that you are saying that this Parliament must wake up to its responsibility, its strength, its authority, its mandate, and that Parliament is never subservient to the executive. It's only this parliament that can remove a president. When the Honorable Muhammad Ayerga leaves the debate and says that President Nana Addo Dankwa Akufo-Addo, the President of the Republic, himself a trained lawyer, is a potential candidate for impeachment because he is potentially in breach of the Constitution. Mr. Speaker, may I with respect, and that's my third takeaway, read Article 69 of the Constitution. Purposes, I want to rely on 69(2). I will even go to Mama Ayerga 69(1), but I'll come back to it. Mr. Speaker, Article 69(2) reads, "The President shall be removed from office if it is found in accordance with the provisions of this article." And Mr. Speaker, I go as I said to have conducted himself in a manner which brings or is likely to bring the high office of President into disrepute and ridicule. If a president assents to a bill and the bill becomes an act, and the same president writes a letter to the Speaker purporting that I cannot assent to the bill, that is a conduct in ridicule. The President of Ghana cannot afford to be doing that. It's a ridiculous conduct. President of Ghana, trained by law, respected constitutional lawyer, you have assented to a bill referred to as Criminal Offences Amendment Act 2023 Act 1101. How can you somersault and change your mind? So, Mr. Speaker, my fourth takeaway is that you are telling President Nana Addo Dankwa that he is late in coming, and procedurally he is wrong. If the President had any objections to the bill so passed by Parliament, he should have exercised his right under Article 106 by writing back to you and the Council of State. And Mr. Speaker, may I go to Article 106? So, Honorable Mama Ayerga, you relied on 69(1)(a), violation of the Constitution and violation of his oath, because he swore to uphold the Constitution, the letter and spirit of the Constitution. How can you then assent to an act? It becomes law. And Mr. Speaker, it's strike law that anything on the statutes book is good law. Anything. So today, at 1101 is part of the statutes of Ghana. It's good law. So, and then fifth takeaway, Mr. President, you further reminded the President of the Republic that even if he has disagreement, the appropriate forum is for him to get an action initiated in the Supreme Court, which has the authority under Article 131. And Mr. Speaker, may I refer to Article 131 in order that I drive home the very important point you made today. Mr. Speaker, Article 131 reads, "Subject to the jurisdiction of this court, the enforcement of fundamental human rights and freedoms as provided in Article 2 of this Constitution, the Supreme Court shall have, and I emphasize, exclusive original jurisdiction in all matters relating to the enforcement or interpretation of this Constitution." So neither Parliament nor the President or the Executive is clothed with any authority to interpret this Constitution. Therefore, the forum, if he has any disagreement, it will, with respect shown, go to the Supreme Court for an interpretation. And Mr. Speaker, you rightly and appropriately also quoted Article 1(2), which is the most important. Indeed, in constitutional law, the supremacy of the law in any legal system is what we establish. That is why in Article 93, in Article 58, it says that Parliament shall subject to this Constitution. The President shall subject to this Constitution. It means that Parliament is not sovereign, neither is the President sovereign, even as Executive President. So, Mr. Speaker, the fact that President Nana Addo Dankwa, how can you get this so basically wrong? That you don't know that the appropriate forum to interpret the Constitution is the Supreme Court, and not by a lengthy letter to the President questioning him when you are wrong, even by not respecting the procedure. Mr. Speaker, my sixth takeaway, and that is for this House itself. Mr. Speaker, when we go through third reading of bill, And that is why I agree that someday we must revisit this matter. Between when the bill is remitted to the president and the executive, the speaker must have a role, Parliament itself must have a role, then we will begin counting the 14 days. We will begin counting the 14 days. So, Mr. Speaker, may I again refer you to Article 106 of the Constitution, where the President could have agreed or disagreed. Mr. Speaker, 106(7) reads, where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill. So, Mr. Speaker, another takeaway. When we finish third reading and the bill is so clean by your drafting section, between the number of days the bill travels to the President, this Parliament must now have a register for us to count when it left Parliament under your hand to the President, so that we can count whether he has respected the 7 days requirement or even the 14 days requirement. It cannot be a matter that something assented to in August, then the President of the Republic comes in December, August, September, October, November, December. President Nana Dankwa, you couldn't have gotten this right. Then finally, Mr. Speaker, this Parliament is too yielded to the executive. We are too yielded to the executive. This is the only forum that this evening, if we so take a decision that the President must go home, he will go home. If this Parliament, yes, by today's resolution, we take a decision that he must go home, he will go home. But because we have decided to play second fiddle. So, Mr. Speaker, let me thank you profoundly for your elucidation on the supremacy of Ghana's 1992 Constitution. Your reminder to the President to respect procedure. And that, Mr. Speaker, we couldn't agree more with you that this your statement must mark a turning point on, and that's my conclusion, respect for the functional operation of the doctrine of separation of powers. The co-equal organs of state, the executive, the judiciary, and the legislature must respect each other. I do not think that the President lengthy letter to you demonstrates respect in respecting the mandate of this House. The fact that a bill comes here and says passed by Parliament and assented to by the President does not make the President part of the lawmaking process. No. But because bills must emanate from him, it can end with him. But, Mr. Speaker, Article 93 is clear, and I read it for the purpose of the Hansard. 93 reads, and Mr. Speaker, I quote, there shall be a Parliament of Ghana. Then it says in 93(2), subject to the provisions of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. Mr. Speaker, my final takeaway from your rendition. What has Parliament done wrong by following dutifully the provisions of Article 106? A bill is introduced, and Mr. Speaker, for the record, even this matter of Criminal Offences Act of the death penalty, the UK Parliament sent a delegation to this Parliament. The UK Parliament sent a delegation to this Parliament to discuss the subject and to get our input. Then you sign onto it to law. And Mr. Speaker, as rightly observed by the ranking member of constitutional law, the Attorney General has questions to answer. He must come and explain to Mr. Speaker in this House that who misled the President, if he thinks that he was misled, who misled him to change his mind on this. But Mr. Speaker, let us say it. The British Prime Minister called Sunak, who is leading the Conservative Party, recently addressing the Conservatives in London, said that it is common sense that a man is a man and a woman is a woman. He did, Sunak. A man is a man and a woman is a woman. In United Kingdom, nobody took him on. President Nana Addo only raised this issue. Mr. Speaker, I have reason to believe, because he anticipates the passage of some bill, that when the bill comes, he would have run to rely on Article 108. And Mr. Speaker, I listened to you carefully, and I'm quoting your words, that where the charge on the consolidated fund is not incidental and consequential, your opinion is right and appropriate. I thank you for the opportunity.
Honorable members, I think it's proper. Yes, Majority Leader.
Mr. Speaker, the position of the majority has been canvassed by the Deputy Majority Leader, that unless and until we have copies of your own statement, we are not going to debate this matter. Having said so, Mr. Speaker,
Majority Leader, I have not called on you to debate. I call on you to comment.
Mr. Speaker,
there is a difference.
I know. But the day you communicated the President's own statement or communication to us, that was 13th, on that day, you gave your preliminary observations and restrained the House from commenting. It's taking you 1 week to do your research. And then you come, you read your own statement and tell us that immediately let's launch into it. That is not equitable. That is not fair.
Majority
and that is why we insist.
Please, when you want to comment and your comments are directly on me, you are inviting me to come in. You are inviting me to come in. And you know that right after the beginning, I said the communication to me in the form of a letter was copied you. It's there in the letter. Now, so you in person had the opportunity that I had from the very beginning. So don't be referring to me in your comments. Just make your comments and let's move on.
Thank you. Mr. Speaker, if you are listening to me, the greatest respect. I was not referring to the communication from the President. I'm talking about what you have done now. I'm talking about the statement that you have read copiously and laboriously to us today.
Yes, but you stated that I had the opportunity to research.
Yes.
And I'm saying that you also have that opportunity because you also got the letter the same day I got the letter. So if I did my research, you have also had the opportunity to do your research. The other members agree, but not you.
Mr. Speaker, it is what you have read. Are you going to give me the opportunity now then to also read what I have also researched? Is that what you are going to do? You are not going to do that. And that is why I'm saying that I am aligning with what the Deputy Leader has said, that we need time to study what you have said. Because it's taking you more than 1 week. Yes, we having said so, the Honorable Mahama Ayariga made some factual inaccuracies. First of all, he said that the issue in contention, that is, if the constitutionality of the bill should have been questioned by the President, it should have been done through me, or maybe I should have informed the President. He gets it totally wrong. The Speaker, before the bill came to be introduced in this House, you had already admitted it. So it is not when it came here before you admitted. You admitted before it came here. And so that is the gate. When you made the decision to admit it before it entered here, your gate of admitting it is where that constitutionality issue perhaps would have been raised. But I was not privy to it because the visibility of that statement rests solely with you. So he cannot bring me in. He gets it totally wrong. Mr. Speaker, he and maybe I should refer him to the imperatives of Order 66 of our standing orders. Mr. Speaker, the Honorable Mahama Yandra should not be bearing false witness. He says I was here when the bill was introduced. I wasn't even here. This bill was introduced in the last week of July, and business was transacted on it in the last week of July. All these bills. Mr. Speaker, you are aware that I have traveled out of the jurisdiction. Don't bear false witness. Mr. Speaker, the issue raised by the Deputy Majority Leader still remains on your table. He called for a ruling on the application. That ruling has not as of yet been made. The ruling that the Deputy Majority Leader sought, even though people have gone on to make their own comments and gone on their own frolics, Mr. Speaker, as of yet, they have not made the ruling. And the Honorable Dashama was saying that if the Deputy Leader wants to challenge your ruling, he knows what to do. He must come by a motion. Who told you that? Who told you that? Mr. Speaker, people misread the orders of this House. The only time that the ruling of the Speaker, if challenged, must come by a motion is when he rules on the point of order. That's the only point. Read our orders. Mr. Speaker, let me remind you of the imperatives of Order 98. So people rise up and talk without referring to the standing orders. He doesn't even know what he's talking about.
But Majority Leader, he didn't say he should come by motion. He said he should come formally.
How formally?
That was the word he used. He didn't say by motion.
How formally?
Please.
How formally? Mr. Speaker, with the greatest respect, if I can land, because I intend to land very shortly.
I'm not too sure you are landing.
I'll land and land safely. Mr. Speaker, the Fiscal of the House insists that it's taking you 1 week to respond to the President, and this is a weighty issue. You've raised constitutional matters, even though you said the President cannot go into constitutional interpretation. You have done exactly that. We will deal with that in the fullness of time. So give us time. Let us have what you have written. And then we have enough time to also digest, interrogate the issues, and come properly and debate the matter. Mr. Speaker, I thank you very much. In the meantime, I will implore this House. We have work to do. It's 2 o'clock now. It's 2 o'clock now. I will need to deal with the sectoral allocations. Parliament's own has not been attended to. Parliament's own has not been attended to.
Majority Leader, you can't blame this Parliament for not attending to Parliament's votes. Yesterday, this item was called. You yourself said the report was not ready. So why are you now trying to blame Parliament?
Because I say why? Because when we only have cause to look at it only yesterday. Parliament's own. It was only yesterday in the morning that we did.
So don't blame the committee. It's not the House.
Don't blame the committee either.
It's not the fault of this House either. So please, let's move on. Honorable members, I decided to listen to the House before I give directions. It's important to get the sense of the House. I just don't sit and dictate to the House. That is why I allowed the preliminary comments. That has been done, and I heard from both sides of the House the proposal to give more room, more time to you to do research and to come properly to make your comments. If after your research you want us to convert it into a motion to be debated, I am prepared for it, because that is the decision of the House, not of the Speaker. And so listening to you is what will give me the ingredients to make a decision. There's nothing wrong with that. So I agree that looking at the seriousness of this matter, the process that this has gone through, the advantage that this country has taken on this process, and the benefits that are accrued to this country, and the conduct of a number of officials in this matter, you need time to investigate and come properly to debate it in the House. Not just comments. Not just comments. I see that you want to debate the matter, and I will permit the House to do so, because I have all documents on this matter, and I know who did what and the dates that all acted, to the extent that if you go through the Constitution, the President having stated clearly that he agrees with the contents of the bill, what is then there for him? No comment on any provision, but I have constitutional concerns, and so I detain your bills, and I will send them to the Attorney General to reintroduce to the House. That completely is unacceptable. But it's left to you. If you decide to give that out to the President, it's up to you. It's not the Speaker. So I direct that this matter be deferred.
Speaker, you said you were looking for a date. We believe this is a threat to the Constitution.
Yes.
I was going to propose that, though we are rising sine die today, we would set the process in motion to recall Parliament on the 16th of January to debate this matter and take decisions. It's a very serious matter. We recall Parliament on the 16th of January, debate this matter and take a decision, Mr. Speaker.
Honorable members, I will engage leadership for us to agree on the date and how to couch either the motion or whatever instrument we want to use to at least get a decision from this House to guide all of us in the country. It's a very important matter. So please, do I have your support to engage members, that particularly the leadership, to decide on the date for a further deliberation on this matter? Thank you so much. Honorable members, it's a few minutes after 2, and I just want, in view of the nature of business on the floor, to extend the sitting time beyond the normal stipulated period. With this, we move on to item 4, correction of votes and proceedings and official reports. Item 4, let's be quick on that. We'll start with the votes and proceedings of Thursday, 21st December 2023, page 1. Page 2, page 3, page 4, page 6, page 7, page 8, Page 9. Page 9, yes.
Thank you, Mr. Speaker. Mr. Speaker, on page 9, item 7, under statements, the Honourable Member for Tamale South, Mr. Haruna Idrisu, made M-A-D-E, but it's captured here as N-A-D-E.
Yes, thank you, Honourable Member. That's the printer's devil. Table office, can you take note? Page 10. Page 11. Page 12. Page 13. Page 14. Page 15. Page 16. Page 17. And page 18. Honourable members, in the absence of any further corrections, the votes and proceedings of the 37th sitting, dated Thursday, 21st December 2023, are adopted as a true record of proceedings. I have a copy of the official report of Wednesday, 6th December 2023. Any corrections? Honourable members, in the absence of any corrections, the official report of Wednesday, 6th December 2023 is hereby adopted as the true record of proceedings. Can we move to statements? Yes.
Speaker, at the commencement of public business, may we move to page 6. Page 6 of today's order paper and take item 8. Speaker, may I seek your leave for it to be done by the Deputy Leader?
Honourable members, at the commencement of public business, item 8, motion, Majority Leader.
If Mr. Speaker will be pleased, I rise to move the House to approve the sum of 1,022,482,000.
Who are you?
Mr. Speaker, with respect, an application was made.
By who?
For your leave. By the Chief Whip.
The application was for me to move to public business.
No, Mr. Speaker, he did a composite application. But if it pleases you, he may repeat same.
No, you don't make composite. We are at
Mr. Speaker,
item 5.
Mr. Speaker, the applicant is right here.
So make the application.
Very well. Mr. Speaker, if you may be pleased, I pray for leave to move this motion for and on behalf of the Majority Leader.
Yes, minority from bench.
Mr. Speaker, I have no objection to that application.
Honourable Deputy Majority Leader, you may do so.
If it pleases Mr. Speaker, I rise to move this House to adopt the report to approve the sum of 1,022,408,803 for the services of Parliament and the Parliamentary service for the year ending 31st 2024. I so move, sir.
Motion moved. Any seconder?
Right, Mr. Speaker, I second the motion.
Motion moved and seconded is for the consideration of the House. Yes. Oh. This is a matter that has been carefully considered for by leadership and the committee. But any member who wants, yes, please, honourable member for Aswase.
Thank you very much, Mr. Speaker. Mr. Speaker, as you rightly said, leadership have gone through it. Time is fast spent. Mr. Speaker, it is important to state that the budget of Parliament is one that should be She was not up on her feet, and I was up. The Speaker have called me.
Honourable member, address me.
Mr. Speaker, I realize that my colleagues on the majority bench are trying to draw an attention to a vice chair or a chair of the special budget that needs to speak before to present the report.
Nobody.
Yes.
Initially, it was the member for the young lady, honourable lady father, the one behind. She was moving around and I thought she was on her feet. But after that, nobody stood up. You stood up, and that's why you caught my eye. So please, you may continue.
Mr. Speaker, I'm told that the report of the committee has not been presented. And therefore, that has to be done before we can comment. So, he only moved the motion. The deputy majority leader moved the motion, and it was supposed to be seconded by the chair and present a report. So,
please, the motion was moved and seconded. It's for the consideration of the House. You all have copies of the report. And so when you get up to contribute, you are using what is before you.
yes.
Later on, she could also come in. Because the report was presented to the House and I directed that copies be made available to all members.
Yes.
Once you get your copy, you have it. But later on, she could come in to dilate more on the report. It doesn't necessarily mean that, because she didn't second it. It was seconded by the minority chief whip.
Well, thank you, Mr. Speaker. Mr. Speaker, I know time is fast spent, but Mr. Speaker, let me say that a budget of about 1.1 billion that has to still be trimmed by Mr. President. Even though we ended up getting about 92%, I still believe that that 1.1 billion could still have been considered, looking at the enormous responsibility that is before Parliament. Mr. Speaker, I want to make reference to your committee's report, paragraph 6.2, about the construction of the constituency offices for members of Parliament. Mr. Speaker, as you may recall, for a very long period of time, we've been arguing that it is not fair that the expenses in our various constituencies be left for individual members of Parliament to continue to bear, because it erodes the meager salary that MPs receive. Mr. Speaker, I hope that as we continue to make effort to start the construction, we should be able to give some allowance for members to be able to take care of their constituency offices. It's very, very important. Because as it stands now, any one of us who has an office in his or her constituency is fully bearing the full cost of maintaining those offices and all those who work in those offices. And Mr. Speaker, I think that's very unfair for members of Parliament. Mr. Speaker, the other thing that is worth mentioning is the beefing up of the security around Parliament. Mr. Speaker, if you notice since this week, the sheer number of persons that are hovering in almost every corridor of this house is very scary. And there's nothing apart from trying to extort money from members of Parliament. And Speaker, I wonder the way they have access to almost our offices. It's a big danger. And I hope that the Parliamentary Service, especially the Chief Executive, the clerk and his team, will have to be up in doing. Because, Mr. Speaker, we spend time and resources to construct the holding place, which is around the car park, Mr. Speaker, is almost abandoned. It's not being used after it's been commissioned. And you still have people trooping almost everywhere. Mr. Speaker, the tea area you go, members do not have privacy anymore. You go under the, what do you call it, in the corridor. The only place that, Mr. Speaker, you could have to talk to your colleague is probably, Mr. Speaker, from your office and the small corridor to the chamber. That's the only one that is left. Almost every other place has been hijacked by visitors. And Mr. Speaker, all they do is just to be harassing MPs for one thing or the other. And Mr. Speaker, yes, we represent them. But this is not fair for them to virtually evade the car park, the corridors everywhere. That is a serious threat to members of Parliament. Mr. Speaker, the other thing that I want to mention is the facility that we are using. Mr. Speaker, if you close in the evening and you have the pain to go around the floors, air conditions are left on, lights are left on, even in the daylight, as we speak now. If you walk across the floors, Mr. Speaker, and you see the lightning all on, with this minimum or meager resources that is given us, if we don't use them judiciously, we have ourselves to blame. And Mr. Speaker, today, there are so many technology where you move in, the lights come on, you move out, the light goes off, even the air conditions. And I want to urge the Parliamentary Service Board to look at investing in that, because in the long term, the savings that we're making will be more than enough to be able to take care of that investment. Lastly, Mr. Speaker, I didn't see in the report and in the budget any provision made to take care of our colleagues who have left this House. Mr. Speaker, you recollect that in the previous Parliament, which is the 7th Parliament, leadership took a decision together with the Parliamentary Service Board that former members of Parliament could visit our clinic. But if they have to buy, then they will go outside to buy. Mr. Speaker, if you look at the predicament of most of our colleagues, I always say, yesterday they were like us. Tomorrow we are going to be like them. If we don't work hard to improve, at least for medical care of former members of Parliament, we will not be doing ourselves any good. And I want this House to consider that seriously, so that into the future we'll be making adequate provisions to take care of. At least medication should be enough in the clinic. I know we'll not be able to foot the bill of former members of Parliament going out to buy prescription and come to make a claim. But if we have some critical medication in our clinic, such that when former members of Parliament visit the clinic, at least they can be taken care of. It will do us a lot of good. Mr. Speaker, I know time is spent and others will want to make some comment about the budget of Parliament. I must take this, Mr. Speaker. I know it may be a little digression. The loss of one of our colleagues or one of our brothers, Paul, which the body was brought today. I was sad because I know many staff died who only talk about members of Parliament. But this is a gentleman that works directly into this chamber, Mr. Paul. And remember during the post-budget workshop, he sat here throughout. He was even making the roll call, and unfortunately, he lost his life going home and just not waking up. Mr. Speaker, we must know it is not only the members of Parliament that goes through tremendous stress working here. Same is with our staff, especially some categories of our staff. Those who work directly with us, until we close and go home, they are not able to go home. Some of them, even when we have closed, they have to still stay behind to prepare the next for the next day. And I recollect very well throughout my leadership, this young man, yes, 49 may not be too young, but today, because of the advancement of medicine, to die at 49, he died too young. Mr. Speaker, we need to encourage the clerk to make sure that we make provision for our staff. Their health is so critical. Because today, nobody takes care of others' children. Yes, we may all mourn tomorrow and bid him farewell. What happens to his children? The wife, the family that he was taking care of. Mr. Speaker, let's invest in the health of our staff, especially the core ones. And I just want to take this opportunity to wish the family, to extend our condolences to the family, and pray that he finds peace in the bosom of the Lord. I thank you very much, Mr. Speaker, for the opportunity to have made this comment. Thank you very much, sir.
Thank you, Mr. Speaker, for supporting the motion on the floor, item number 8 on page 6 of today's order. Mr. Speaker, the committee, after examining the estimates of the Parliamentary Service and the Parliament of Ghana, took a number of considerations to the operations and the supervision of parliamentary activities. And Mr. Speaker, I would like to mention that what is of great concern to Parliament, to the committee, was the fact that for 3 consecutive terms, provisions have been made for the construction of members of Parliament offices in their various constituencies. But we have not pursued seriously the construction exercise, which last year member took notice that a provision was made for the construction of 40 constituency offices for members. Mr. Speaker, members were concerned because the explanation given for the non-construction of the 40 constituency offices were the shortfalls that they were experiencing in the releases of the budget allocation. And Mr. Speaker, we believe that your tenure here should supervise at least the construction of not less than 20 constituency offices. So we are appealing as a committee that in order for us to be seen, to be concerned about the way the various constituencies are lacking facilities that members of their constituencies can revert to when they need the help of the MP, they will have a place to revert to. Mr. Speaker, and therefore we are appealing that the various gaps or variances in the provision of the budget for Parliament should and be necessarily be communicated to the right places to ensure that these variances are demanded so that we can prosecute the agenda of constructing not less than 40 of the constituency head offices. And Mr. Speaker, one other issue of concern, even though budgetary allocation has been made for, members were concerned about the type of elevators that have been placed on the new block. And members were recommending that we should be concerned about the elevators that we procure, especially for the job 600. And we need to ensure that they have the right brain and not elevators that don't have the right brain to the demands of the people who are using these elevators. We were also concerned about the allocation of budgetary needs for the various committees. Mr. Speaker, we took notice of committees like the Public Accounts Committee, the Government Assurance Committee, and if we look at the type of allocations that have been made for these committees and consider the fact that they have to be sitting in camera and then be sitting on a quarterly basis, you realize that their budget allocation is woefully inadequate as compared to some other budgetary needs of the committees doing the oversight responsibility, and therefore urge that the criteria normally apply to the allocation of these committee sums should be reconsidered and ensure that we boost up the oversighting responsibility of the of Parliament. Mr. Speaker, there was another concern that if you look at the allocation made for the various committees as against the expenditure on foreign travels, it became a lot of people were concerned that we have to ensure that these allocations are boosted up a bit to take care of the local activities that are undertaken in the country, to ensure that we will be able to do our oversight responsibility or pursue our oversight responsibility responsibly. Mr. Speaker, in conclusion, I'd like to add my voice to the numerous contributions so far made, that the committee has carefully examined the program-based budget estimate for Parliament and Parliamentary service and found the program and policies planned for the 2024 financial year to be necessary towards achieving goals and objectives of the Parliament of Ghana. And Mr. Speaker, the committee recommends to the House to adopt this report and approve the sum of 1,022,482,803 Ghana cedis for the service, 1,482,803 Ghana cedis for the services of Parliament and the Parliamentary service for the 2024 financial year. And with this, Mr. Speaker, I urge the House to support the motion. Thank you.
Honourable members, before I put the question, please, it doesn't lie in the mouth of Parliament to always complain that the budget allocation to Parliament is on the low side, because you approve it. You are the people who decide how much will be given to you. So who are you complaining to? That who should come and increase your budget for you? You are the same people who decide, for whatever reason, to give yourself a low budget. Then after that, you are demanding that those administering the budget should let you do other things that are not captured in the budget. That is not possible. We have tried for some time now to always find something for the former members of Parliament and the former staff of Parliament, and we have allowed them the free use of the medical center. The only challenge they have is the medical center is located in Accra, and these members are spread all over the country. How do they come down here to access the care? And so sometimes we have to receive some invoices or receipts to try to refund expenses if they are not on the high side for the treatment of our members who are now not with us, and then also the same for the staff. For the offices, the decision was delayed by this same House. This same House will not give us feedback as to what to do at the board level. It's now been decided, and the season is not good for us to get much for this year. That is 2024. So that is why you have that amount there. The elevators procurement is by the procurement committee made up of mostly members of parliament. It's not just by the board. Procurement committee is there. But the committee's allocation is usually a bulk amount, and the leader of the house is the one that discusses and decides how much to allocate to each committee. That is not done by the board, but there's always a bulk amount for the committees. But we have now developed some guidelines for the leadership to use in the allocation to the various committees. This is the first time we are getting guidelines on it. So that is the situation now. But I see that leadership wants to make contribution before I put the question. Yes.
Thank you, Mr. Speaker, for this opportunity. Mr. Speaker, I rise to speak in favor of the motion on the floor. By doing so, Mr. Speaker, a lot of things were discussed at the committee level, and I consider not all of them have been captured in the report. Mr. Speaker, the members of the committee at the committee sitting were highly not impressed at all about the budget reduction of Parliament budget by the President of the Republic of Ghana. Mr. Speaker, your committee did not take it lightly about the 8% reduction of the Parliament budget by His Excellency the President. And Mr. Speaker, what angered the members of the committee more was because, Mr. Speaker, we are considering all the estimates of the various sectors and ministries. But Mr. Speaker, I have been here for 15 years. Mr. Speaker, you are privileged to be here since 1992. So if we want institutional memory, we can fall on you. And if what was started by our predecessor could not be done, and Mr. Speaker, today as we speak, we've gone back to what happened in 1992, just as when we were starting this parliament. In 1993, Mr. Speaker, out of the 200 parliamentarians who started this parliament in the Fourth Republic, there were only 2 former MPs with parliamentary experience. And that's the Honorable J. Osu Achampon from Brikun and Honorable Note Kwali from Osu constituency. The Speaker, today as we are here, in the name out of the 275 MPs here, we have only you and the Honorable Collins Dauda, meaning we've gone back to where we started from. The majority leader came in 1997. So almost all the old hands are gone. But the foundation that you wanted to lay, Mr. Speaker, we are not able to build upon it. Mr. Speaker, if you look at the other sectors' budget, Security and Exchange Commission is building an office of about $17 million. Bank of Ghana, $250 million. GRA, $79 million. Ministry of Finance, $20 million. And Parliament cannot build a single office for a single member in any of the constituencies. And we come and we are approving all this for them. What do you think we are doing to ourselves? Mr. Speaker, we are approving about 176 billion. Yes, and we are asking of only one. And His Excellency says he cannot give that one to us. What are we doing to ourselves? From 2010, we said we were building offices for members. It was fiercely supported by the late, may his soul rest in perfect peace,
the late ranking member of the Finance Committee, Honorable Akoto, say, we couldn't do it, he's gone. Honorable Papa spoke in favor of it. He couldn't do it. We couldn't do it. He's gone. Honorable Doaja was in support of it. Today, none of them is here. Mr. Speaker, we are privileged to have you, the then majority or minority leader, as now the Speaker of the House. And we are privileged to have the then minority leader as the leader of the House, the majority leader now. So, and today, if what your predecessor could not do, looking at this budget, there is no inspiration that any of the offices could even be built. Because the clerk made it clear to us that because of the 8% budget cut, it was the investment budget that was cut. So because of that, what we are going to do is land acquisition. Mr. Speaker, from the back bench to the front bench, to the white seat, to the big seat, all you could do for Parliament as a legacy is land acquisition. So, Speaker, we must generously support you, and the leader of the House must support you. And we made it clear that it must find expression in the report. I found it very worrying that the chairman of the committee did not write that one as part of our recommendations. Because the members of the committee stated it that it must find expression in the report. And the de facto chairperson can bear me out. Mr. Speaker, I think the time has come for Parliament to do for itself what Parliament did for the judiciary. The time has come for Parliament to do for itself what Parliament did for the Council of State. The time has come for Parliament to do for itself what Parliament has been doing for others. Last year budget, Mr. Speaker, the Council of State budget was taken as part of the Office of the President budget. This House argued strongly that constitutionally the Council of State must have their own independent budget. We spoke in support of it and we did it. And we took the budget of the Council of State from under the budget of the Office of the President. We did it for Council of State. Mr. Speaker, when those days when lawyers could dress nicely and go to Cocoa Affairs Court under wooden structures, this Parliament made it clear to the President, the ladies, may he so rest in perfect peace, that he had no authority to cut down on the investment budget of the judiciary. And therefore, together, Mr. Speaker, you were the leader of the House. You stood your grounds and you made it clear that the late Professor Mills as President could not do that. And Mr. Speaker, you went ahead to support the executive to go to Fidelity Bank to go and borrow an amount of $74 million to go and build the 34 courthouse that we have in Tema Station. You did it for them. Now we are just going to build just a small office for a member of Parliament in her constituency. And what are we saying? That cannot be done, or we don't want to do it. Mr. Speaker, if we want to enforce accountability and fight corruption, it is not just by launching anti-corruption strategy or anti-corruption plan. Corruption can be fought by the combined effort of members of Parliament, including the Honorable Obi Amwa. Mr. Speaker, oversight is one of our core functions, and we are constitutionally mandated by the Constitution, Mr. Speaker, to combat corruption. We can summon ministers of state and agencies to appear before us. We can go on field visit to go and look and investigate their books and see what is happening there. Mr. Speaker, look at the number of documents that we have here. You go to the district assembly and you have no office, and you are going to fight with your DCE, and you say you are going to oversight him. Mr. Speaker, what Parliament is embarking to do is not out of place at all. Mr. Speaker, can you imagine the cost involved when you took the entire Parliament to Nadolika Liu, took the entire Parliament to Sunyani West, took the entire Parliament to WA, that we are going to do parliamentary engagement with the people? Yes, we could do that. But if those offices were to be there, as we are speaking here, the people of Bana could convert in my secretariat and be watching what is happening here and could be giving me information, and it will enrich my debate on the floor.
Second Deputy Speaker to take the floor. Sorry, to take the chair.
So, Mr. Speaker, what we are saying is that those who started it pursued it for 10 years and couldn't achieve it. So if this is the budget that is given to Parliament with 8% budget cut, that we should go and do land acquisition of about 40 plots or 40 constituencies and initiate it. That was started in 2010. 10 of those offices were built by the late Professor Mills. May his soul rest in perfect peace. And in 2023, we are still talking of land acquisition. Mr. Speaker, I beg to differ. I therefore, Mr. Speaker, want to strongly suggest to this House, and my rendition is that, Mr. Speaker, the 8% must be reinstated. And I know majority leader will support me. At least, Mr. Speaker, what befitting thing that we can do for the majority leader and leader of the House is to provide a constituency office for the good people of Swami. And it will be a symbol, and we can name it Chairman Bonso.
Democratic Center.
Center of Institute. Mr. Speaker, and most of us will be going there and be meeting the sitting MP who will then be there and will be tapping on the institutional memory of the leader of the House. So, Mr. Speaker, what we want to do, we are losing a lot, and Parliament is losing and throwing away the capacities that are built. Mr. Speaker, it's unfortunate the clerk has no voice on the floor, but Mr. Speaker, when you meet these our Ghanaian senior MPs on international fora, how people are sorting after them, trying to seek and solve their ideas. Mr. Speaker, you may desire it. And therefore, Mr. Speaker, I think the reinstatement of the 8% investment budget for the Office of Parliament will help Parliament to fight corruption and corruption proper. It will strengthen the committees of Parliament to do their work. Mr. Speaker, one other thing that came fiercely was lack of funds for committees members to embark upon their field visit. And how can we sit in Accra and say we are oversighting, whilst you cannot move to go and do fact finding for yourself? So, Mr. Speaker, I don't intend to belabor the point, but I know and know very well that we were made to understand that many of the items are still yet to be considered, and therefore we must include the 8% budget cut as one of the items to be considered. And leader, in the media budget review, if we start the process with the 40, when the time comes in July that we are doing budget review, we must top up, so that, Mr. Speaker, we will come back to where we had wanted to start from January. But to say that if there has been 8% budget cut and we consider it as a budget cut and this is the recommended one given to us, Mr. Speaker, go through the 2023 budget performance of the Office of the President. There's budget overrun. You are not giving yours. Even what is budgeted for, you are not giving. You are what you give to them. They overspend. So, Speaker, are we really having the power of the purse? And where is the purse? Parliament, we are the representative of the people, and we control the power of the purse. And when you are controlling the power of the purse and you are going along begging, is it not, Mr. Speaker, is it not a bad situation that we who have the power of the purse are now begging for the purse? Then what is the essence of the power? And where is the power? Mr. Speaker, in conclusion, the Honorable Esla Osu do agree with me that I'm strongly right and vehemently she will support this House for the 8% budget cut. For the 8% budget cut. And Mr. Speaker, we must have a befitting office in Dansuma, so that when I go there in terms of communication, I can engage with Honorable Oswald for consultation. So, Mr. Speaker, with these few words, Mr. Speaker, with these few words, I want to call on members, distinguished members, to support the motion on the floor and to approve the budget of Parliament, and to recommend that in July, that 8% budget cut must be reinstated. Because even if the 100% is approved, we are not going to spend all the 100 before July. Therefore, we must take that one as the starting point. And I know once the Honorable Abraham Ofe Asar is here, definitely all those recommendations will be complied with. Thank you, Mr. Speaker, for the opportunity.
Thank you very much. Honourable members, at the conclusion of the debate, all those in favour that motion listed 8 in today's order paper, all those in favour say aye. All those against say no. Honourable members, the ayes have it. The motion listed 8 in today's order paper is hereby adopted, and that this Honourable House approves the sum of 1,222,482,803 Ghana cedis for the services of Parliament and the Parliamentary service for the year ending 31st December 2024. Yes, Leader, may I come to you?
Speaker, Speaker, the motion listed as item number 9 is still outstanding. The Finance Committee is cleaning it up, and even though we've had the engagement, I think the chairman is doing the final cleanup for it to be run. So I guess we may have to suspend sitting. Yes. Mr. Speaker, we may have to suspend sitting, but before then, I would want to, on behalf of the Minister for Energy, responsible for energy, I want to present the National Petroleum Authority Bill 2023. If you indulge me, I'll do that on behalf of the Minister.
Yes, Leader, you may do so.
An act to establish the National Petroleum Authority, amend and consolidate the laws relating to the petroleum downstream industry and to provide for related matters.
Honourable members, the bill is presented and read for the first time and is referred to the Committee of Energy for consideration and report.
Speaker, the committee responsible for energy is required to immediately.
Honourable members,
they're required to immediately attend to this bill because the bill has not been gazetted. So they are required to make a determination of the urgency of it, not to deal with the matter today, but just so that the committee will be seized of it and use the holidays to do the appropriate consultations, so that by the time we return, Parliament resumes, we'll be in a position to report. And, Speaker, it will then allow for the bill to be gazetted after the committee makes the determination.
Can you repeat it again? I didn't hear it well.
Speaker, I was saying that this bill has not been gazetted as of yet. So the minister requires the committee to make a determination as to its urgency, not to deal with it today, that is within 1 day, but just so that they will be seized of it, and then after they make the determination, then the bill can thereafter be gazetted, such that during the holidays, during the recess period, the committee then could act on it and have the appropriate consultations.
Thank you. Well, leader, let me find out, is it the committee that is supposed to determine the urgency otherwise, or the minister?
The committee makes the determination. The minister, in submitting it without gazette, is making an application to the House. So that is what it is.
So I made direct that the committee, when they are looking at it, should consider the agency or otherwise of it when they report back to the House. Yes. Yes, leader.
Yes, Speaker, in much the same way, a referral was made to the Committee on Roads and Transport and on the National Roads Authority Bill. And the Speaker, they have determined, they have made a determination. So I would entreat you to allow the committee to come under order 74 to make the requisite application and pass on the relevant information to the House. Speaker, thank you.
Thank you, Mr. Speaker. Mr. Speaker, the Committee on Roads and Transport met on Tuesday, the 20th of December, with officials from the Ministry of Roads and Highways to determine a referral that was made to the committee to determine the urgency of a proposed establishment of National Roads Authority, which the bill was laid before the House on 6th of December. Mr. Speaker, your committee met, and after extensive discussion with the ministry, and we are of the view that even though the National Road Authority is a very critical if we are able to pass the bill and get a law to back it, but we are of the view that looking at the nature of it and how there are several interested parties, especially stakeholders, who will be affected with
this establishment or this law, if it is passed, we believe that we will need an ample time to engage with all these stakeholders to also solicit their views. And therefore, we are recommending that this bill must not be taken through under certificate of urgency, but we have to go through the processes. Accordingly, I want to table the report of the committee so that the table office will be able to have the full details of the report. Mr. Speaker, I respectfully submit. Thank you.
Very well. So, if I got you well, referral was made to your committee, and as part of the referral, you were to make whether the referral is supposed to be taken as a matter of urgency. And you are telling us that you need time to do it. So this is just a matter of information to the House. Very well.
Yeah, Mr. Speaker, I think the chairman is right. This road authority is very critical in the management of our road infrastructure. And we had privilege to be at the pre-laying when we're taking through the bill, at least the policy part of it. And I think what is before us today is just to determine whether we can take it under certificate of urgency. As the chairman said, there are many stakeholders, including colleagues from both sides of the House, who believe this bill is very important and want to play a role. And as you can see, we don't even have the time left on our hands to be able to do anything if it's actually urgent. So we don't think it is necessary to take it under certificate of urgency, but rather it should have its own full life, and hopefully we shall be able to craft a law that is befitting and can help the ministry manage our road infrastructure. Mr. Speaker, I am in full support of what the chairman said.
Very well. So, first Deputy Speaker.
Thank you, Mr. Speaker. Mr. Speaker, it's a pity that I'm hearing about this for the first time. But I'm worried about re-centralization of agencies that should be taking care of the local areas. Department of Feeder Roads to be merged with an authority somewhere. Already we have a problem with over-centralization of these local authorities. By law, we say they have been decentralized. They are part of the MMDAs. But they can't do anything on their own. They can't even pay their own offices on their own. So, they have no budget on their own. Procurement of roads in their districts are done for them by the national. So when we bring another body to apparently superimpose upon them, I think we are deepening the woes of the operators on the ground. This is one law I think that we should rethink, particularly in respect of local and feeder roads. The agencies down there, just 2 months ago, Honorable Minister, I'll give it to you, but just making signs, because the highway is passing through a high school and the students were agitated that the drivers drive too fast. So I invited the urban road director to discuss putting speed limiting signs so that the students don't cut through the road themselves. He didn't have a budget to just put signs there. If I could raise the money, then they would do it. This is how difficult it is, I think, in their current circumstances. So if you're going to place another road authority which will decide which will go to which department or which agency, I think we should rethink the principles, because currently the situation outside the bridgings and the national capital is not good enough for those of us in those localities. Honorable Minister, I truly need you to think with me, because Awinari is going to suffer like Bekwa. And so is Formuna, and my Lord's hometown is not even on the highway. Mr. Speaker's hometown is also a branch to a corner somewhere. If you are not careful, nobody will remember us in the planning. So I think we should rethink this issue. Thank you.
Yes, Minister. Minister, give me 1 minute. Let me hear before I can.
Sorry. Mr. Speaker is very right. In fact, the reason for this bill is to cure exactly what he's talking about. Mr. Speaker, currently, we know if you drive on the Spintex road, you will notice that it's quite a road that's probably the longest commercial road in our country. A lot of activities. Whilst Urban Road thinks that the road reservation should pave the way for us to expand that road and make it motorable, the local authority have gone to do a rezoning by themselves and have given it to people to build shops. So by the time Urban Roads the minister gets to know, Urban Roads have done something differently. We are saying that when you have the National Road Authority, decisions like that have to be taken when the minister is aware. So Urban Road cannot just go and redesignate a right of way which is left for future development, and then Federal Road can decide that they can do something different. So Federal Roads will exist, Urban Roads will exist, and then all of them will exist. But the way they operate, somebody must be responsible. So the minister can find out who the head of the National Road Authority is and question him. In fact, Parliament can request that that individual appear before the House at an appropriate way, so that we can deal with the thing. So, Mr. Speaker, it is not actually supposed to be something that Mr. Speaker should be afraid of. It's actually the solution to the fears he is having. And when the bill comes, I think the body of the bill will all contribute to make it reflect our views on how to make our roads better and work for us. Mr. Speaker, I believe when we do this, even funding of roads, currently, what is the cost, what is the price tag of all the roads we have in the country? Can we actually leverage on the roads we have currently to say that this is how much it is? We want people to invest, to give us money to continue instead of going to borrow money from abroad. All those will be expressed in the bill. And Mr. Speaker, I think it's a very important thing that we should all support the bill when it comes to the floor of the House. Mr. Speaker, I thank you for the opportunity.
Yes, Minister, if you can have a comment.
Thank you very much, Right Honourable Speaker. I have taken note of all the concerns expressed by the Honourable First Deputy Speaker. He has made a good point there, but I do not want to even overstretch the issue, because the Minority Chief Whip, who has worked with us all these years and is very knowledgeable in the road sector. So because this is one issue that both sides, particularly the leadership, are uneven, and my ministry is bedeviled with a lot of problems. And the decision to come out with the bill, to promote and to bring into being and existence the National Road Authority is to deal exactly with the issues and the programs being seen and being expressed by the Honourable First Deputy Speaker. The ministry, as it exists now, goes through 3 different agencies, as he did say. The National, the Ghana National Road Authority will bring them together, all the 3, the Ghana Highway Authority, Department of Urban Roads, Department of Federal Roads, so that we avoid duplication of functions.
so that it becomes one solid, united authority. And if the Honorable First Deputy Speaker gets the opportunity to go through the bill and the consultation that we want to do, the extensive consultation, that is why we are saying that you should go through the normal processes so that you get the opportunity to contact all stakeholders and take a decision before we come to Parliament for the plenary. So those issues will be addressed. So there should be no fears of the good intentions of the bill. Thank you.
So, thank you very much. So, now, members, this is just information that was given to the House. So leader.
Speaker. The Speaker, if we allow the Deputy Minister for Local Government, Decentralization and Rural Development to present the paper listed as item 6A. 6A.
Yes. Honourable members, let's turn to page 3. Page 3. Item listed 6. And we are dealing with A by the Minister for Local Government. So the Minister of State for Local Government can do as the honors.
Local Government Mpoho Fiase District Assembly Establishment Instrument 2023.
Honourable members, the instrument has been duly presented. It is referred to the Committee on Subsidiary Legislation for consideration and report. Yes.
Speaker, item 9 on page 7. Item 9 on page 7. And Speaker, let me seek your leave for it to be done by the Deputy Minister.
So, honourable members, let's turn to page 7. Page 7. Let's turn to page 7, honourable members. Item listed 9. Motion by the Minister for Finance.
Mr. Speaker, I beg to move that this Honourable House approves the sum of 171 billion and funds 49,901,169 for other government obligations for the year ending 31st Ghana cedis for other government obligations for the year ending 31st December 2024. I so move.
Very well, thank you. Honourable members, the motion has been moved. Let's invite the chairman of the committee to second and present the committee's report.
I thank you, Mr. Speaker. I rise to second the motion and in the process submit the committee's report. I request the Hansa Department to take the capture the entire report whilst I go straight to the conclusion. Mr. Speaker, the committee, having carefully examined the estimates of the other government obligations, recommends to the House to adopt this report and approve the sum of 171,049,901,169 169 Ghana cedis for the discharge of the other government obligations, also referred to as statutory payments, for the financial year commencing on the 1st day of January 2024 and ending on the 31st day of December 2024. But Mr. Speaker, before I submit the report, I'd like to draw honourable members' attention to paragraph 3.5 and seek your leave, Mr. Speaker, to make some corrections. Under paragraph 3.5, reallocation, line 2. Mr. Speaker, that line must be deleted. Line 2 must be deleted. Line 4. The fourth item must also be deleted. The third item should now read, Agenda 111, captured under General Government Services, to Ghana Investment and Infrastructure Fund. So the reallocation, the committee is recommending for the House's approval: 1, La General Hospital; 2, Ministry of Health. And if I could take it for members, the committee found the need to do the following reallocations from other government obligations: 1, La General Hospital; 2, Ministry of Health. And then the second one is Agenda 111, captured under General Government Services, to Ghana Investment and Infrastructure Fund. The remaining reallocations stand deleted as corrections. Respectfully submitted. I thank you, Mr. Speaker.
Very well. Yes. Thank you very much, Mr. Speaker. The approval for the other government obligations is supported by the whole members of the House, particularly on the committee, with some modifications that have already been stated by the chairman of the committee, except that we found that the Ghana Revenue Authority retention also required some tweaking, because the Ghana Revenue Authority, as we investigated its expenditures, were found to have budgeted for a number of projects in the 2024 budget. But those projects were based on multi-year commitments, the agreements of which they had signed with certain agencies. One of the agencies that has signed such an agreement with is the Strategic Mobilization Ghana Limited, which is shortened as SML. Mr. Speaker, you would have heard in the media in recent times that there is an investigative journalist called Manasseh Azure who had done some work on the action, and members of the committee took very keen interest in the findings of that journalist, and therefore requested for the agreement covering this transaction. Members realized that these agreements were multi-year commitments, and per the Section 33 of the Public Financial Management Act, those multi-year commitments required the approval of this House. We therefore recommend to this committee that to this House, the Ghana Revenue Authority should be made aware of this statutory requirement, so that they can properly come before this House and lay that multi-year agreement in accordance with Section 33 of the Act. Mr. Speaker, we further recommend that the committee undertake investigation into that agreement, the agreement between the GRA and SML under Section 103 of the Constitution, and to ensure that the payments that are supposed to be made from next year on that contract to SML be suspended
until the committee comes out with its reports, which reports will give indication as to how to proceed with the GRA and the SML. Mr. Speaker, this is a very important development because Parliament must be seen to be protecting the public purse. And to the extent that the public had reason to complain about that agreement, the Finance Committee deemed it necessary to make these recommendations to the House. Mr. Speaker, we are also aware that the other government obligations constitute about 70 to 73% of the entire budget. Most of those funds are centralized at the Ministry of Finance. And we that when so much money is vested in one center, you are not able to achieve the level of transparency and accountability that you desire. It is in that vein that we require that the general hospital's allocation included in general government services be so properly transferred to the Ministry of Health. Mr. Speaker, we also think that the contingency vote has been abused by the Minister for Finance. The Minister for Finance used the contingency vote to fund capital expenditure in the National Cathedral. And as a result, we did not feel confident that we would give him a contingency vote. As a result, we recommend that any monies that are made to deal with emergencies and contingencies be transferred to the supervision of Parliament under the contingency fund. So while the contingency vote is controlled by the Finance Minister, the contingency fund is controlled by Parliament through the Finance Committee. We actually require that if there is any emergency, the members of the Parliament of Ghana, particularly on the Finance Committee, commit to work around the clock to make resources available to the government to deal with those emergencies. As a result, we think that there is already enough provision in this House for this contingency vote to be moved to the contingency fund. Mr. Speaker, we further believe that some amount of money that will be agreed from the general services can be used to increase the buffer on the contingency fund to prepare the country for unforeseen emergencies. Mr. Speaker, with these few words, I wish to recommend to approve the other government obligations. Thank you very much, Mr. Speaker.
Yes.
Thank you, Right Honourable Speaker. Mr. Speaker, I think that the ranking member, the able Honorable Isaac Adongo, has stated some of the positions we took at committee level. Mr. Speaker, with your permission, even though I'm a member, let me commend the chairman and the ranking member for putting partisan interests aside and putting the national interests to the fore as far as this budget is concerned. And like was rightly said, Mr. Speaker, we are talking of 171 billion. That's a huge amount. I think that, Mr. Speaker, going forward, we should begin to find ways and means where most of these funds can be allocated directly to the sector ministries. This idea where huge sums sit with the finance minister ought to be discouraged. Because if you look at some of them, for instance, like you want to build a hospital and you can't allow the Ministry of Health to do that. That's why I commend the committee and Parliament in general for taking the position that some of these specific identifiable projects ought to be put directly under the supervision of the sector ministers. That way, Parliament finds it easy summoning ministers here and dealing with them. Most of the projects under the presidency, it becomes very, very difficult. And sometimes Parliament has to find a way of dealing with it. But I'm even more interested in, for instance, the interest payment. Despite the so-called debt restructuring and haircut, it does appear that our interest payment continue to increase. Indeed, the interest payment is moving from 52 based on the 2023 budget to 55 billion. And some of this comes largely on the back of the currency
depreciation. And so whilst you may make some gains from domestic haircuts, the foreign component is very, very difficult and staring at us. Mr. Speaker, my final comment has to do with the recommendation on SML. Like has been rightly captured, this is a multi-year project, this is a multi-year contract, and should have come to Parliament in the first instance. Some of us therefore hold the view that, Mr. Speaker, the best thing to do is to suspend this contract with immediate effect. Mr. Speaker, the contract must be suspended with immediate effect. Because coming from the Mines and Energy Committee, I am convinced beyond reasonable doubt that the MPA has the capacity, has the logistical well-being, and they can do what SML is doing. And so we need not be paying over $20 million every month to an entity, and I'm happy that the Finance Committee is going to go into it. And so I do not want to belabor the point. I do not want to preempt the point. There will be a showdown at the Finance Committee, Mr. Speaker, when we go into this matter. There will be a showdown as far as this contract is concerned. Mr. Speaker, but even before the showdown, even before the showdown, Mr. Speaker, Parliament must call on the relevant agencies, i.e., the GRA and the Ministry of Finance, to immediately suspend this contract. And finally, they are extending it to the oil sector. And when you read the contract, Mr. Speaker, every barrel of oil, SML is getting $0.75 off 1 barrel of oil. If you look at our annual production of 55 million barrels of oil, it means that this company could be walking away with about $40 million. Mr. Speaker, it is my hope that even though they've gotten PP approval, they have not executed this contract. If you haven't executed it, my advice to you is simple: halt it and let the committee deal with it, and based on the recommendation, we can move forward. Mr. Speaker, on this note, let me thank the ranking member and the chairman once again, and also thank our Deputy Minister, the Honorable, for the and let me thank the Deputy Minister. She's been very, very diligent. She's been very cooperative, and I think that she also deserves commendation. Thank you very much, Right Honorable Speaker.
Yes, let me come to Okaikwe Central. Okaikwe Central. Okaikwe Central.
Thank you very much, Mr. Speaker. Mr. Speaker, let me add my voice to the motion requesting this House to approve of the estimated amount for other government obligations for the 2024 budget of an amount of 171,049,901,169. Mr. Speaker, I listened to a very good submission from the ranking member where he touched on some of the views of the members of the committee. It was reiterated by my brother from Yape Kusagu. Mr. Speaker, we observed, and rightly so, that some of the line items ought to be realigned. Secondly, Mr. Speaker, I was also happy with some of the allocations, especially for the Accra-Tema motorway, which has become a subject matter for public discourse. Mr. Speaker, much as I agree that the allocation for Lao General Hospital ought to be transferred to the Ministry of Health, I also believe that issues of infrastructure, especially where the loan agreement for that project of Tema motorway was also brought to the House by the Minister for Roads, ought to also be realigned or sent to the Ministry of Roads. I think that point escaped some of my colleagues who spoke earlier on, Mr. Speaker. Mr. Speaker, if you look at items on interest payment, 55 billion, which comprise of about 36 billion for domestic
and the remainder for external sources. It tells you that we need to do more with regards to the strengthening of our currency and restructuring of some of our debts to give room for proper investment into other sectors of the economy. Mr. Speaker, I'm also happy to speak about subsidies on petroleum products. Honorable Jinapo, I thought he was going to talk about that. That is an area that consumes a lot, and I believe is for the underprivileged in society and for our fisher folks, Mr. Speaker. Mr. Speaker, that notwithstanding, the allocation for the resettlement of victims who are affected by the Akosombo Dam spillage ought to be commended, because that is a huge national issue, and I think that my colleagues who were affected, whose constituencies were affected, must applaud government for at least taking a bold step to take care of those affected by the Akosombo Dam. But I think, Mr. Speaker, people from the Savannah region were also affected. People from Bono East, Eastern region were also affected by some of these floods. So I think it will be better for the Minister of Finance to also find some space from this allocation to support those who are affected by other floods in other parts of the country. With these few words, Mr. Speaker, I thank you very much and I support the motion. Thank you.
Yes, let me come to Bobo.
Thank you very much, Mr. Speaker, for the opportunity to contribute to this debate. And in doing that, Mr. Speaker, first and foremost, let me congratulate the Committee on Finance, the chairman and the ranking and the members, for the recommendation they've given in terms of suspension of payments to SML. The reason is simple, Mr. Speaker, from where I sit and where you also sit, because we belong to the same committee, this is a contract that to a very large extent, just to be kind, is fraudulent. I say this because, Mr. Speaker, the National Petroleum Authority has a system known as the Enterprise Relational Database Management System, the ERDMS. This is a system where even before the BDC's order for petroleum products outside the country, they key in the quantities into this system. Anytime the OMCs, that is the oil marketing companies, decide to make an order from the BDCs, Mr. Speaker, the quantity, the price, the destination of the products, and even the truck that has to take the product from the storage tanks to wherever they are going, and the number is recorded in this system. And Mr. Speaker, the interesting part of it is that the integrated customs, that's the ICOMS, what's the full name? Yes, the integrated customs management system, ICOMS, is hooked to this particular system. So what it means is that just by a press of a button, you know the quantities of petroleum products that are being sent. And because you've been able to ascertain the quantities, tax liability is established. And so for GRA to go again and sign another contract with SML, who, by the way, from the information we have, are not even hooked to the ICOMS, to an extent that the state is spending so much money in paying for a job that is being done by a state agency, clearly means that we have a problem. So, Mr. Speaker, I want to commend the Finance Committee, and I'm also excited that should this particular report be approved, what it simply means is that that particular contract will have to be suspended, and to a very large extent, Mr. Speaker, I intend to say that this House must, if there will be one important investigation that we will do as a House, just to be able to let Ghanaians know that we want to protect the taxpayers' money. It is this one. It is this particular investigation. And I just plead that as we rise, that Parliament will find time to let a committee investigate this. Because, in my very humble opinion, it is inimical, it is fraudulent, and it is just money that has been created for individuals to benefit at the expense of Ghanaians. Thank you very much, Mr. Speaker.
Yes.
Thank you, Mr. Speaker. Mr. Speaker, I rise to also contribute to the motion. But, Mr. Speaker, I want some clarification from the chair of the committee on page 4 of the report, under item 3.3, contingency vote. The committee observed that an amount of 1,058 million has been allocated to the contingency vote for the 2024 financial year. This represents funds set aside for unforeseen expenditure. Mr. Speaker, the assumptions underlying this allocation is that about 503 million is set aside for unforeseen expenditure for goods and services, and additional 555 million is set aside for unforeseen critical expenditure for CAPEX. So, Speaker, what I want to find out from the chair is that I remember when this House was approving the report for Ministry of Food and Agriculture, their budget was increased by 300 million. The amount in the budget document was increased by 300 million. So the expectation was that taken from the contingency vote, but if not, where will that additional 300 million be funded from? Is the committee chair able to tell us, or the deputy minister able to tell us? Because if that is not clear, what it means that the appropriation that the Minister of Finance is requesting the House to do will have to be increased by 300 million. Because you need to drop some item in order to remain at the appropriation figure requested by the Minister of Finance. If you don't drop any other item, yet you are increasing that of the Ministry of Food and Agriculture, it means that the entire global figure being requested for will have to go up by 300 million. So that if the chairman can tell us how that additional 300 will be funded. Thank you.
Yes, Honorable Chairman.
Well, thank you, Mr. Speaker. Mr. Speaker, I take the honorable member's question, in fact, as advice. I think the fundamental point is that the projected inflows should be able to finance or fund the projected expenditures. So if we make variation in any part of the expenditures, then we would need to do some adjustments elsewhere. These adjustments, honorable members, would be done during appropriation, because the referral you speak of, under which adjustment was made independent of the Finance Committee's work. And we have also done this. When we sit to do the appropriation, we'll take into account all the adjustments that have been made on the floor, and then we'll ensure that in the end we live within our means, including transport, I understand. So we will consider and address all that under the appropriation consideration.
So, then come to leadership.
Mr. Speaker, first, it is the same reason why the very question that Honorable Abeji posed to the chairman of the Finance Committee and Deputy Minister. That is the reason why the Ministers of Finance must be present in the chamber at all times when we are considering the budget. Mr. Speaker, so that they can take note of some of these approvals and make sure that we do not make mistakes going to the end of the appropriations bill. Mr. Speaker, it is not only what the chairman has said, but I can count about 5. Even yesterday, I raised an issue on one relating to retention of an IGF for the Committee of the Committee of Judiciary. There was a case, Mr. Speaker. So it is important that we take note, and an appropriations bill before us, it is yet to be laid. But immediately we have to ensure that all of this are reflected. But Mr. Speaker, I have 2 main concerns on the approval for the budget or the allocation for other government obligations. Mr. Speaker, the amount before us is 171 billion Ghana cedis. 171 billion. It represents over 70% of the entire appropriations. So all done. When we started debating the estimate, this report alone is about 70% of the work we have done. This report is about 70% of the work we have done. Be interested in it. Mr. Speaker, if the entire appropriations is under 250 billion, it's about 236, and this one is about 171 billion. It speaks volumes, and we should be interested in it. First, Mr. Speaker, the concern I have here has to do with over-concentration of resources at the Ministry of Finance. Over-concentration of resources at the Ministry of Finance. So, you have a budget where all MDAs controls about 30%. In the Ministry of Finance alone, you have a concentration of about 70% of total resource allocation. Yes, Mr. Speaker, I agree. And let me refer you. I agree that a number of them will be transferred to certain statutory agencies. But first, it will be at the Ministry of Finance. But I will give you the details. And then, Mr. Speaker, I agree that you use some also to pay for interest. But there are some that cause for major concerns. All of us to debate. Mr. Speaker, we need to address some of them. We have here items that, Mr. Speaker, for example, the contingency votes. 1 billion Ghana cedis contingency votes to be used at the discretion of the minister responsible for finance. 1 billion. Well, whether it's gone or not, what is before us is a billion. A billion gets used, which is more than the entire Parliament's budget. Yes! Parliament's budget is how much? It's 901. It's about a billion. Yes, of course. A billion. So, Mr. Speaker, at the discretion. First, I would have thought that the committee responsible for finance would have asked the ministry. In fact, it's the ministry. You have to first account for what we approved for you as contingency last year. How you use the money. How you use the money, the contingency, because expenditure returns must be accounted. And you should attach it to the statement so that we know the contingency votes that we approved for you, how you spend the money. Aside that, they have 11 billion Ghana cedis for the payment of arrests, also sitting at the Ministry of Finance. Then, Mr. Speaker, if you look at the report, they are saying that they are going to spend 150 million for the purposes of the rebuilding of La General Hospital. And it's also sitting at the Ministry of Finance. Ministry of Finance, since when did you start building hospitals? Mr. Speaker, and I'm happy that the Committee of Finance have transferred, reallocated this money to the Ministry of Health. We need to commend the Ministry, the Committee of Finance, particularly the chairman, for doing this, because it's critical. It is critical. The Ministry of Finance cannot be the one performing the functions of the Ministry of Health. And Mr. Speaker, many more. There was something we have here, General Government Services, 2.732 billion Ghana cedis. And they are saying that these are estimates of expenditure that do not fall directly under any specific MDAs, as well as one-off expenditures. This is this is completion of ongoing health infrastructure under Agenda 111 program. So we have an Agenda 111 also sitting at the Ministry of Finance. What is the Ministry of Health doing? It should be Ministry of Health. Then aside that, they are saying that Hyperion upgrade and enterprise licensing. What is Hyperion? I know of Hyperion, but I don't know what is enterprise licensing. What enterprise licenses are we talking about?
Enterprise what?
Enterprise licensing.
I know enterprise.
So Mr. Speaker, there was a lot more. Composite budget training for 261 MMDAs. Upgrade of Oracle e-business suite and supported infrastructure. Mr. Speaker, it goes on, and that is 2.7 billion Ghana cedis. Clearly, it is only right that you give us a breakdown of all of this, so that if we were to get some breakdown, we'll be able to appreciate the issues. Mr. Speaker, Ghana case, 800 million Ghana cedis to fund the growth agenda, including economic enclave project. Mr. Speaker, this ministry has been implementing Ghana Cares for 3 years now. 3 years, at least, since 2021, I think 2021. So since 2021, you've been implementing Ghana Cares. By now, you should know what to do. Reallocate this money to Ghana, to the agencies that you are, they are going to perform this function. And guide them. I don't know what you gain, Ministry of Finance, that you want to control everything. Are you the president? Are you the president of the Republic of Ghana? You can't control everything. Give some away. Let your colleague ministers do some of the work. You can't be in charge of everything. Are you Captain Planet? You can't do all of this. Give some and then you concentrate on macro fiscal. That is your core mandate, not expenditure management. Macro fiscal. So that you know how to manage our debt, how to manage our, the rail sector. That is your job. Don't concentrate resources into the Ministry of Finance alone. Allow others to perform. Mr. Speaker, I'm of the view that this contingency vote is too much. This contingency vote is too much. $1 billion plus at the Ministry of Finance. When we get to appropriations, we insist that this matter, this amount, they should tell us where they are going and reallocate. If they are not going to reallocate, then they should give the money to send the money to contingency fund. It serves the same purposes. Contingency vote is at the discretion of the Ministry of Finance. The contingency fund is a constitutional provision that gives the power to the Finance Committee of Parliament. So if the minister wants to spend from the contingency fund, then they have to bring a report and ask the ministry to Parliament to approve. But what we are seeing here, we are giving them a blank check. A blank check. But I don't think that we should continue this part. It is this same contingency vote that they use part to pay for the National Cathedral. Because clearly it has been abused in the past. So I have very cold feet, very cold feet to support the approval of the contingency vote. Mr. Speaker, let me commend the Finance Committee for taking the matter of the Strategic Mobilization Ghana Limited, SML contract frontally. Mr. Speaker, and all committees must learn from this. We are here to work for our country and the people of Ghana. And when a matter becomes a national issue, Parliament, being the representative of the people, must seize the opportunity to get to the bottom of the matter. Mr. Speaker, if we fail, oftentimes we have not been able to rise up to the counter. But at this occasion, Mr. Speaker, this is one side. But the Committee of Finance has seen the need to get to the bottom of the matter. And they have initiated their own probe. So, Speaker, we encourage them, we wish them well, but I urge other committees to learn from this and to increase public confidence in the work that we do. Because this is a matter that, so Speaker, it has gotten to the heart of the public discussion and everybody is concerned. So I can only commend them. But let me also say and caution GRA that clearly the matter relating to the SML contract has to do with a multi-year commitment. Multi-year commitment. And multi-year commitment is covered under Section 33 of the Public Financial Management Act. They should do what is right. They should come before Parliament and ask Parliament to approve it. Mr. Speaker, if they fail to ask Parliament to approve this matter, Mr. Speaker, they cannot continue the way they are continuing. Mr. Speaker, to end on this matter, I want to say that, all in all, we should all support the approval for the other government obligation budget to be part of the appropriations bill. Mr. Speaker, the Ministry of Finance and the Finance Committee must know that the only thing left now is the appropriations bill, if this goes through, and in terms of the estimates. And so immediately they should reconvene for us to go through the details of the appropriations bill by crossing the T's and dotting the I's, because there's a lot you have done here that probably you have not factored in the appropriations bill. So we need for us to get the appropriations bill to properly balance and tally with the budget document. We need to do a lot more work, and it will depend on how quick you will be. Else, Mr. Speaker, it may mean that we have to hang around for some time before we take action. But we are in your hands. You have to work fast in a way that we'll be able to do it. But taking note of some of the concerns that this report and other reports that we have approved, Mr. Speaker, I support the motion.
Yes, Leader.
Mr. Speaker, I just want to add my voice to those who have already contributed, and to say that even though the figure 171,049,901,169 Ghana cedis on the face of it appears huge, Mr. Speaker, if you do the breakdown analysis, you will see that really the amount is appropriate for the purpose for which they have been allocated. Thus we can look at social contribution, 6,777,773,591. Then interest payments, the Speaker, then you come to grants to other government units, arrears, clearance, amortization, over 20 billion, and clearance of outstanding BTAs. The Speaker, these are just 6. The 6 together gives over 137 billion. These 6 items, which are critical, the Speaker, are cross-checked, and it's come to my notice that even the 200 million, the 2.6 billion owed to outstanding BTAs does not even include that of Parliament, which is in the region of about 64 million. So, Mr. Speaker, what is here really is nothing strange. I must commend the committee, as others have done, that they have come with some recommendations which the House stands together to accommodate. So, Mr. Speaker, without much ado, I would urge on all of us to approve this, subject to the amendment proposed by the chairman of the committee, and which has been supported by both the ranking member and the minority leader. Mr. Speaker, thank you very much.
Honourable members, at the conclusion of the debate, all those in favour that motion listed 9 in today's order paper, all those in favour say aye. All those in favour say aye. All those against say no. Honourable members, the ayes have it. The motion listed 9 in today's order paper is hereby adopted. and that this Honorable House approves the sum of 171 billion 49,901,169 Ghana cedis for the other government obligations for the year ending 31st December 2024.
The Speaker, if I may draw attention to other paper addendum. No. Mr. Speaker, to attend to the other paper addendum and for the chairman of the committee to present his report to the House.
Very well. Honourable members, let's turn to other paper addendum. Other paper addendum. Item 1. Presentation of papers by the chairman of the appointment committee.
33rd report of the Appointments Committee of His Excellency, the President's nomination for the appointment as justices to the Supreme Court of Ghana.
Honourable members, the report has been duly presented. They are for distribution to honourable members.
Yes, Speaker, we go back to the original order paper to enable the page 6, page 7A for the Minister of Finance to present the Appropriations Bill 2023 to the House. Speaker, if I may, I want to seek the indulgence of the House to allow the Deputy Minister for Finance to do the presentation on behalf of her Minister.
Deputy Minister for Finance. Honourable members, let's turn to page 6. Page 6, item listed 7A, presentation of papers by the Finance Minister. So the Deputy Finance Minister will do that on behalf of his boss. Yes.
An act to provide for the withdrawal of sums of money necessary to meet government expenditure for the 2024 financial year from the Consolidated Fund and other public funds and for related matters.
Honourable members, the bill as presented is read for the first time and it is referred to the Finance Committee for consideration and report.
Leader, any indication? Yes, Mr. Speaker, having referred the appropriations bill to the Finance Committee, I believe it is proper to suspend the House, the sitting of the House for the Speaker, 1.5 hours. The Speaker, 1.5 hours. So we're coming back at 5:30. At 5:30.
Honorable members, Honorable Sam George, yesterday you moderated the NICE program. So today, let's also have a NICE program in the chamber. Yes.
Mr. Speaker, the application before you is for us to suspend for 1.5 hours. Mr. Speaker, today we cannot go home too late. So 1.5 hours should be 1.5 hours. The Finance Committee and the Ministry of Finance must move in and work now. We can't be going home at midnight. 1.5 hours should be 1.5 hours, so that latest by 5:30 we can start setting. So that, Mr. Speaker, we can close early. And I'm sure even your clerks, they are all tired and they all want to go home. Christmas is over the weekend. They want to travel.
Very well, honorable members.
and honorable shoulder, what bread?
Mr. Speaker, it is the wish of all of us that we'll be able to adjourn early enough. But Mr. Speaker, you recognize that even what you have just done, the other government obligations, we have made serious violence. And these must all be considered by the Finance Committee. And the ministry will have to take care of this. But Mr. Speaker, we will even require the table officers, the head person, to be with them, to carry the votes and proceedings, so we know what has been done at where. It is not a child's play. And Mr. Speaker, this man, the current minority leader, when he was the Deputy Finance Minister, once upon a time, the House adjourned at his instance at 11:45 p.m. The record is there. Now he's making a U-turn. The young again shall go.
Honorable members, kindly indulge me to suspend sitting for 1.5 hours. We are coming back exactly at 5:30. 5:30. The House stands suspended.
Welcome back from the suspension. We will be taking item 19 at page 11 of the order paper, and it's a motion to be moved by the chairman of the Committee on Mines and Energy.
Thank you, Right Honourable Speaker.
Try to educate me on this thing because I don't understand it.
Thank you, Right Honourable Speaker.
I say educate me because I don't understand this one.
This one? Oh, okay. I'll do my best to educate. I thought you are so familiar with these matters. But very well.
I have not seen the agreement and I have not.
Yes. Your committee has duly captured everything and I'll explain it.
Thank you.
So whilst on my feet, the lights will be turned on. I'm grateful to you. Honourable Speaker, I beg to move, and notwithstanding the provisions of Standing Order 81, which require that no motion be debated until at least 48 hours have elapsed between the date on which the notice of the motion is given and the date on which the motion is moved. The motion for the adoption of the report of the Committee on Mines and Energy on the trust deed among the Ghana National Petroleum Corporation, Charlo Ghana Limited, Cosmos Energy Ghana HC, Cosmos Energy, formerly Anadarko WCTP Company, Petro SA Ghana Limited, Jubilee Oil Holdings Limited, each a unit party and collectively as unit parties, and the Bank of Ghana as trustee in respect of establishing a decommissioning trust fund for the Jubilee Field Unit located offshore the Republic of Ghana may be moved today. I so move, Honourable Speaker.
Honourable members, any seconder? Yes, please.
Mr. Speaker, I rise to second the motion on the floor, and in seconding the motion on the floor, I want to state that this is a requirement to protect the future decommissioning of our oil field, and it is appropriate, especially with the example that we currently have of the Sorpon oil fields, whose decommissioning has become a burden on the Ghanaian state. It is therefore important that we provide for this decommissioning. Mr. Speaker, this House, subsequent to this, in passing Act 919, provided these same conditions.
I have not crossed the procedural motion level, and I crave the indulgence of Honourable Speaker to give me the space, and then I'll move the motion, and my able brother will second it and then give his comments. Yes. So
we are the procedural.
We are at the procedural level.
Yes. I'm grateful. I'm grateful, Honourable Speaker.
It's procedural. You just second.
Mr. Speaker, I second the motion. Thank you.
Honourable members, motion moved and seconded is for the consideration of the House. Being procedural, I put the question. Those in favor of motion number 19 at page 11 of the order paper, say aye. Those against, say no. Honourable members, the ayes have it. The motion is carried. So we move to the substantive motion, which is number 20 at page 12 of the order paper. Yes, Chairman.
Thank you, Honourable Speaker. I beg to move that this Honourable Court I apologize. I apologize to the House. Honorable Speaker, I beg to move that this Honorable House adopts the report of the Committee on Mines and Energy on the trust deed among the Ghana National Petroleum Corporation, Talo Ghana Limited, Cosmos Energy Ghana HC, Cosmos Energy Ghana Investment, formerly Anadaco WCTP Company, Petro SA Ghana Limited, Jubilee Oil Holdings Limited, each a unit party and collectively as unit parties, and the Bank of Ghana as trustee in the respect of establishing the decommissioning trust fund for the Jubilee Field unit located offshore the Republic of Ghana. And in so doing, I present your committee's report. Honorable Speaker, the fate of this motion is that the Ministry of Energy is looking ahead of time. We have situations in which the oil producing companies will not have sufficient money, that at the end of the oil undertaking, they'll be able to have good money to decommission the field. And this is the intent of this motion. And I request the Hansard Department to capture the entirety of the report as I read the conclusions. The committee has critically examined the two documents relating to the appointment of Bank of Ghana as a trustee of the Decommissioning Trust Fund, and is of the considered view that the ratification of the documents for the establishment of the fund is justified in terms of the existing unitization and unit operating agreement. The establishment of the fund is critically required to guarantee availability of funds for the decommissioning of the Jubilee fields at the end of commercial production. The committee further notes the postponement of the trigger date warranting an urgent ratification by the House to achieve the current trigger date of 31st January 2024. In the premises, the committee recommends the House to adopt the following, to adopt this report and ratify the following documents. Right, Honorable Speaker, they are I and II, respectfully submitted.
Honorable members, any seconder? Yes.
Right, Honorable Speaker, I rise to second the motion moved by the Chairman of the Finance Committee. Right, Honorable Speaker, in doing so, with your permission, I would like to make some few observations. Mr. Speaker, when we talk of decommission, we are talking of a process where you have exhausted the useful life of the oil block or the wells. And because these are wells that produce oil, even when you've exhausted it, there's some level of oil that emanates from the wells. And so you need to cap the wells and seal them in a safe manner so that it doesn't endanger the aqua life in the sea. Mr. Speaker, if you read the report, it tells you that indeed this should have come into effect from 1st December 2020. And so we are even behind time. Better late than never do. And so your committee had to take this under emergent. We get this done before we rise. Mr. Speaker, we are talking of about $700 million worth of funds that will be needed when it's due. Mr. Speaker, we are doing this because we are learning as a country, and the salt pond case is a clear example, where the contractor party completed exhausting the oil, and when it came to decommissioning, there was no money. And so the state, learning from that, has decided that we should begin to set aside some funds so that by the time we are due, we would have the money available. What is interesting is that the committee insisted on ensuring that that money is safeguarded. And we are told that they can only invest in the safest level of investments. That is to say, you invest either in gilts or in US bonds or AA-rated bonds. And so clearly, if this is well managed, it will be taken care of. Because look at the House, we also want to know that the Finance Committee has insisted that every year, twice in a year, the Ministry is compelled to report to this House on the status of this fund, so that Parliament can have an eye on it. Let me also, the two ministries and both Finance and Energy ought to ensure that this House is updated. But even more importantly, Mr. Speaker, the crust of it is that this will not be commingled with public funds. This is not part of Ghana's funds, and so Ghana would not have access to this fund. And so, Mr. Speaker, having explained these issues to the Chamber, and also taking cognizance of Act 919, even though Act 919 post-date this agreement, I think that the Minister has been quite instrumental in ensuring that we claw this back as if this one falls under Act 919. And for me, the Minister has done quite well. He has our support. Let's ensure that the money is kept safely, and that by the time we get to decommissioning, these funds will be available to enable us to undertake that decommissioning exercise. Mr. Speaker, with these words, let me thank you for granting me audience to speak to the issue. Thank you very much, Right Honourable Speaker.
Yes. Mr. Speaker, further to the position of the chair of the committee and my ranking, two issues I will want to bring to the floor and for plenary to take cognizance of. Mr. Speaker, if you look at 9.0 Roman 4, when this document came before the committee, we insisted and asked that Jubilee Oil Holding Limited should not be part of the contracting party. We were given the assurance that the shares of Jubilee Oil Holding Limited, which we think is not a proper party, be transferred to Esproco. We were assured by the Minister and assured by all the officials present that indeed this transfer has been made, and therefore once this is ratified, the appropriate arrangement emanating from the contract will be put in place to ensure that there's an assignment of the interest of Jubilee Oil Holding Limited to Esproco. I want to put that on record, and the committee being satisfied with that explanation. And so, Mr. Speaker, we want to follow up to be sure that this is done. Mr. Speaker, there was also the issue that I think the House must take cognizance of, that there is some dispute between the contracting parties and the government side as to whether GNPC should make a contribution to this fund as a part of the contracting party. Mr. Speaker, we believe the ministry and the parties are capable of resolving that issue. I just thought the House should be informed of this potential. But this is an extremely important document. It is extremely important as a precedent, particularly since this was before Act 919, and since we say our laws cannot take retrospective effect, this agreement cures the defect. I almost say lacuna, but they will say I'm not a lawyer. It cures the defect in the previous, and therefore I support the motion. Thank you, Mr. Speaker.
Thank you, Right Honourable Speaker, for the opportunity to contribute to the debate on the motion on the floor. Speaker, indeed, clearly the comments from my colleagues on the other side indicate that the committee was all unaided with respect to the importance of the instruments that we have placed before the House with respect to the decommissioning. And so clearly everyone is in support of this House approving same, and I must express our appreciation to the committee for their cooperation. The Speaker said to respond and to assure the House that with respect to the JOHL issue that Honourable Comrade Oko raised, indeed, as part of the trust deed instrument, is a deed of accession, where any party that then assents onto the existing agreement is made to execute that deed to be bound by the terms of the trust deed. And so that in itself was a surety that indeed, to the extent that government has indicated its desire to transfer the shares in JOHL to Exloco, which has been completed, and so we're going to take steps to effect the change to reflect in the agreement. Why JOHL was a party as of the time that we were bringing this was because at the time that we were carrying out the negotiation of the Jubilee decommissioning documentations, the proper party was JOHL. At the time, the shares had not been transferred to Exloco. So that's why JOHL is a party at this point. But because that transaction has been consummated, they would then change their name in this document to reflect. But what I indicated to the committee was that even if that change was not effected, because of the instrument of accession that is part of the trust deed, that would be done to ensure that everybody complies with the terms and provisions of the trust deed. Speaker, again on the dispute, yes, the Jubilee partners are of the view that GMPC ought to contribute to the decommissioning fund. But we have obtained a legal opinion from the Attorney General who says that, I'm just explaining, that GMPC should not participate in the contribution. But even before the dispute was resolved, we agreed that because of the importance of the fund, let us go ahead and set it up so that the parties can start the contribution until such time that that dispute is resolved. So we don't miss out on any fund for the decommission. And so that's the explanation I wanted to provide for the record. And so, Mr. Speaker, I'll urge my colleagues lend approval to proceed to execution. I thank you for the opportunity.
Honourable members, question. Those in favour of motion number 20 at page 12 the order paper, say aye. Those against, say no. The ayes have it. The report is accordingly adopted. Are we moving to the resolution? The resolution. Honourable members, item 21, resolution.
Mr. Speaker, I rise to move that the resolution number 21 at page 12 of today's order paper be adopted now. I so move.
Honourable Deputy Minister, I see that you've taken over as the Minister for Energy. But the proper thing should be done. There is no permission or leave from who? It's all permission from you. No. Your leaders are there, none of them sought permission from me. and all of a sudden, the deputy minister is moving the motion. He didn't even say for and on behalf of the minister. Yes, Deputy Majority Leader.
Mr. Speaker, you forgive him, and I know you've forgiven him. But let me, with your leave, pray that he be given the opportunity to do so for and on behalf of the minister, though he is present in the chamber.
Why is the minister
being groomed?
Why is the minister running away from moving?
He's been groomed.
You are sitting. Yes, you may do so now.
Mr. Speaker, I beg to move that the resolution number 21 at page 12 of today's order paper be adopted by this honorable House. I do so for and on behalf of the Honorable Minister for Energy. I so
Honorable members, this is a consequential resolution following the adoption of the report of the committee on motion number 20. So I put the question. Those in favor of the adoption of the resolution say aye. Those against say no. The ayes have it. The resolution is accordingly adopted. Yes, which other item?
Speaker, page 15. Page 15, item 25.
Honorable members, item 25 of the order paper. Motion. Chairman of the committee.
Thank you, Honorable Speaker. I beg to move, and notwithstanding the provisions of Standing Order 81. Yes.
They split the motions.
I put it together. Yeah. For the three, no, the last one. Okay. Honorable Speaker, I beg to move that notwithstanding the provisions of Standing Order 81, which require that no motion shall be debated until at least 48 hours have elapsed between the date on which the notice of the motion is given and the date on which the motion is moved. A motion for the adoption of the report of the Committee on Mines and Energy on the agreement for the establishment of the African Energy Bank be moved today. Honorable Speaker, the same applies to motion number 28 and motion number 31. They are all procedural motions. And there is one report and I'm getting all of them. I so move.
Honorable members, what the chairman has done is to move the procedural motions itemized as 25, 28, and 31. Any seconder to these procedural motions? Yes, please.
Mr. Speaker, I write to second the procedural motion.
3 procedural motions moved and seconded. Those in favor say aye. Those against say no. The ayes have it. The motions are accordingly adopted. Could we now do the consequential motions on the 3 of them? Okay.
Right Honorable Speaker, I beg to move that this Honorable House adopts the report of the Committee on Mines and Energy on the agreement for the establishment of the African Energy Bank, and then the Charter of the African Energy Bank, as well as the headquarters agreement. And in so doing, I'll crave your indulgence to present your committee's report. I invite the Hansard Department to capture the entire report as if it's been fully and totally delivered, whilst I tend to the conclusion and recommendation to the Honorable House. The committee has carefully examined the reference and considers that the establishment of the African Energy Bank by APO would be of tremendous benefit to the members of APO, including Ghana. The establishment of AEB, which is the Energy Bank, will provide access to capital for the exploration, production, and marketing of oil and gas, and the development of technology in various parts of the continent. The committee therefore recommends the House to adopt this report and ratify the following establishment documents for the creation of the Africa Energy Bank. Agreement for the establishment of the African Bank. Charter of the African Energy Bank. And lastly, headquarters agreement between the government of the Republic of Ghana, represented by the Minister for Energy, and the African Energy Bank. I respectfully submit this report. Right, Honorable Speaker.
Motions moved. Any seconder? Yes.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I rise to second the motion, and in doing so, once again, with your permission, to make some few observations. Mr. Speaker, you would recall that Ghana joined the Africa Petroleum Producers Organization, which was established on 27 January 1987 in Lagos. Ostensibly, what it means is that Ghana has joined the League of Petroleum Producing Nations. Mr. Speaker, what this charter seeks to do is to establish an agreement for the establishment of an Africa Energy Bank. Mr. Speaker, the world is fast moving. The world is going through what we call the energy transition. And the energy transition simply means that the world is moving from fossil-based fuel to what you call clean energy, or what others call renewable energy. Mr. Speaker, the truth is that most of the advanced countries have exhausted their oil resources. If you take the United Kingdom and most of those countries, they've either exhausted capacity or their petroleum base is on a decline. That is one. Mr. Speaker, available records also show that when it comes to carbon emission, Africa contributes only 4% to global warming. Indeed, Africa has 17% of the world population, and yet when you take per capita carbon emission, we do just 1 ton per annum as compared to 10.3 tons by North Africa. And so if we do not take a critical look at this energy transition, Ghana, North America, Ghana and some African countries would be in a state of what we call stranded assets, meaning that we have the assets, but we do not have the financial capacity to do that, because ExxonMobil, BP, Chevron, Shell, all of them are beginning to disinvest in oil exploration. So what these African countries are seeking to do is to establish an energy bank that will raise financial resources and support its members to accelerate oil exploration and development, so that we can make maximum use of our petroleum resources before it gets too late. And when you take financial development, Africa's base is very, very low. Indeed, today, even today, when we talk of coal consumption, China, India, and the United States are the three topmost coal-consuming nations. If you take nuclear power, the United States leads with about 30%, followed by China and France. And so even as all these countries are encouraging Africa to move away from fossil fuel, evidence on the ground suggests that they are making maximum use of fossil-based fuel. And when you read the literature, almost all the industrialized countries have enough hydro capacity, which is God-given. They've either depended on coal, they've depended on nuclear, or they've depended on gas or fossil fuel. So they have built their nations to a certain level using cheap base power. And now they are pushing us to go into renewable, which has a high level of variability. And so I want to comment. Once again, I'm compelled, but this time I will not commend the minister. I want to commend this house. I want to commend this house for considering this document. Okay, we can co-share. This is strategic, and I think that all of us should embrace it. Let's support it. And I hope that the establishment of the Energy Bank will be a panacea to raising cheap, available source of capital for petroleum exploration. Thank you very much, Right Honourable Speaker.
I put the question. Those in favor of the adoption of the three motions. Motion number 26, 29, and 32. Say aye. Those against say no. Honourable members, the ayes have it. The motions are carried. We will now proceed to take the consequential resolutions numbered 27, 30, and 33. Yes. Deputy Minister, Energy.
Right Honourable Speaker, with your leave, I beg to move that the resolutions numbered 27, 30, and 33 on pages 16, 17, and 18 of today's order paper be adopted by this Honourable House. I so move.
Any seconder?
Mr. Speaker, I rise to second the move of the motion. Thank you.
Motion for the adoption of three resolutions moved for the consideration of the House. Since they are consequential resolutions, I put the question. Those in favor of the three resolutions numbered 27, 30, and 33, say aye. Those against say no. Honourable members, the ayes have it. The three resolutions are accordingly adopted by the House. Yes, please.
Speaker, shall we proceed to page 13 and take item 22?
Leadership, my attention has just been drawn that item 22, 23, and 24 have not been taken. Yes, please.
They were the items I mentioned. So I started from 22, which is the procedural motion. So we are starting off with 22.
All right, Chairman of the committee, you may move the motion now.
Thank you, Right Honourable Speaker. I beg to move Now, notwithstanding the provisions of Standing Order 81, which require that no motion shall be debated until at least 48 hours have elapsed between the date on which notice of the motion is given and the date on which the motion is moved. The motion for the adoption of the report of the Committee on Mines and Energy on the decommissioning, assumption and release agreement among the government of the Republic of Ghana, represented by the Minister for Energy, and Ghana National Petroleum Corporation (GNPC), Talo Ghana Limited, Cosmos Energy Ghana HC, Cosmos Energy Ghana Investment, formerly Anadeco WCTP Company, Petro SA Ghana Limited, Ghana Jubilee Oil Holdings Limited as parties in respect of the decommission of trust fund for the Jubilee Fuel Unit located offshore the Republic of Ghana be moved today. I so move, Honorable Speaker.
Any seconder?
Mr. Speaker, I second the motion number 22 on page 13. Thank you.
Procedural motion moved and seconded. I put the question. Those in favor say aye. Those against say no. Honourable members, the ayes have it. So we move to the substantive motion 23.
Thank you, Right Honourable Speaker. I beg to move that this House adopts the report of the Committee on Mines and Energy on the decommissioning, assumption and release agreement among the government of the Republic of Ghana, represented by the Minister for Energy, and Ghana National Petroleum Corporation (GNPC), Talo Ghana Limited, Cosmos Energy Ghana HC, Cosmos Energy Ghana Investments, formerly Anadarko WCTP Company, Petro SA Ghana Limited, and Jubilee Oil Holdings Limited as parties in respect of the decommissioning trust fund for the Jubilee Fuel Unit located at offshore the Republic of Ghana. Honorable Speaker, it's the same understanding which we've already debated. So I need to present the report again. Thank you. It's the same report, and again in the two agreements. I'm grateful to you, Honorable Speaker.
Any seconder?
Mr. Speaker, I second the motion number 23 and page 14 on the order paper. Thank you, Mr. Speaker.
Actually, you just seconded only 23. The 24 is the resolution. We haven't got there yet.
He didn't. Oh, I second 23, 24. Thank you, Mr. Speaker.
Honourable members, motion number 23 moved and seconded is for the consideration of the House. I put the question. Those in favor say aye. Those against say no. The ayes have it. Motion number 23 at page 14 of the order paper is accordingly adopted. Item 24, resolution.
Mr. Speaker, with your leave, I beg to move that the resolution listed 24 at page 14 and 15 of today's order paper be adopted by this Honorable House. I so move.
Any seconder?
Mr. Speaker, I write to second the motions 24 on and 23 and 24 on the order paper. I so second.
Motion moved for the adoption of the resolution and seconded. Yes. You want to contribute? Oh, then I put the question. Those in favor of the adoption of the resolution number 24 at page 14 of the order paper, say aye. Those against, say no. Honorable members, the ayes have it. The resolution is accordingly adopted. Yes, please. Majority Chief Whip.
Speaker, shall we now turn to order paper addendum and take item 2. The order paper addendum item number 2.
Honorable Majority Chief Whip, I don't have any order paper addendum. A copy has just been given to me. May I hear you again?
Speaker, order paper addendum, item number 2.
Honorable members, order paper addendum, page 1, motion number 2. Chairman of the committee.
Thank you, Mr. Speaker. Mr. Speaker, I rise to move that this House adopts the motion.
Excuse me, has it been laid? One has been laid.
Yes, Mr. Speaker.
You may do so, yes.
Very well, sir. Mr. Speaker, I rise to move that this House adopts the motion numbered 2 on page 1 of the order paper addendum. I so move, Mr. Speaker.
Honorable members, any seconder?
Mr. Speaker, I second the motion.
Procedural motion moved and seconded. I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. So we move on to the substantive motion. Yes, Chairman.
Thank you, Mr. Speaker. Mr. Speaker, I seek your leave to effect quick amendment before I proceed to move the motion. Mr. Speaker, I refer members to page 36 of the report, item 12.0, the first line. The Speaker, the articles there should read Article 144 sub 2, not Article 78 and 79 of the 1992 Constitution. The Speaker, from there, I write to move that this House adopt the 33rd report of the Appointments Committee on His Excellency the President's nominations for appointment as Supreme Court judges of Ghana. The Speaker, appointment to the Supreme Court of Ghana. The Speaker, I will ask the Answer Department to capture the in its entirety, whilst I only pick on the few salient points contained in the report. Mr. Speaker, on Friday, November 10th, 2023, the President communicated to the House the nomination of Justice Henry Anthony Kofi, who is a Justice of the Appeal, Justice Yauda Kwansari, a Justice of the Appeal, and Justice Richard J. Frimpong, another Justice of the Appeal, to
be appointed to sit on the Supreme Court bench. The Speaker, in accordance with the Standing Order 172, the nominations were referred to the Appointments Committee for consideration and report. The Speaker, in accordance with the same standing orders, the committee published the nominations and asked for memoranda from the public. At the close of the 14-day period which was requested, no memorandum was received in respect of any of the nominees. The Speaker, at the public hearing, the committee took its time to ask all the three nominees all the questions that are necessary. We had referred to their CVs, we spoke to them about their backgrounds, their experience, their knowledge of the law, and their temperament on the bench. The Speaker, I'll go to the conclusion. And the conclusion is that the committee, in the light of the provisions of Article 1442 of the 1992 Constitution and Standing Order 172, considered the three nominations of the President as a Justice of the Supreme Court. The nominees demonstrated knowledge and dexterity in the law and their areas of practice. The committee therefore recommends to the House, by consensus, the adoption of this report and approval of Justices Henry Anthony Kofi, Justice Yao Asare-Darko, and Justice Richard Eje Frimpong for appointment to the Supreme Court. I so move, Mr. Speaker.
Honourable members, motion moved. Any seconder?
Right, Honourable Speaker, I rise to second the motion for the approval of the three Supreme Court nominees and make the few comments, Mr. Speaker. Indeed, the committee invited and took the nominees through various stages. Mr. Speaker, one of the main things we noticed when we were vetting the judges was that, Mr. Speaker, none of them had a tax clearance certificate that was fully executed. One of them had a tax clearance certificate without any show of income, though they are also appeals court judges, which is a bit of an anomaly. The other two had 2021 and 2022 tax records recorded, but nothing in 2023, because we are in December, at least 3 quarters have passed. And then the committee requested that they rectify this, upon which the committee will bring the report to the floor. So once the chairman brought the report, it's assumed that that has been cleared. Mr. Speaker, the second thing was that Parliament was unable to get information about their, in terms of NIB, National Investigation Bureau. None of them, we didn't have record of any of those. And the ranking on the committee, the Honourable Minority Leader made it clear that it is not about criminal record alone, because the fact that you have not been convicted at court doesn't mean that you are clear, because the NIB could determine that you are not fit to become a Supreme Court judge because of something else. Once again, once the chairman has put the report together, we assume that that has now been furnished to Parliament. But Mr. Speaker, I raised an issue at the committee with the second nominee, Justice Yao Dakwasari, and I wanted to know his views about the Supreme Court ruling that suggests that a birth certificate is not proof of your nationality. And I asked him how he will prove, because on his CV he said Ghanaian, and I asked him how he will prove to me he's a Ghanaian. He said you use a passport, and I asked him what will you use to get a passport. His response was that I was aiding him to give me an answer that is already in my head. So he refused to give me the answer, and I said to him that I believe that particular ruling of the Supreme Court, that a birth certificate is not proof of your nationality, was a miscarriage of justice. I asked the same question to the current Chief Justice, who presented a birth certificate which showed she's a Ghanaian, but she was born in 1960 something. The birth certificate was acquired 2 decades later. So I asked, how did you get a birth certificate 2 decades later when you were born in 1962 or thereabout? Because she said a birth certificate doesn't prove you are Ghanaian, but it's written on her birth certificate Ghanaian. Mr. Speaker, I didn't put it to them, but I made them aware that the entire country, or most people in this country, believe that that judgment was not based on any law in our constitution, because Article 6(2) of the constitution is clear. Born in Ghana. How do you determine if somebody is born? Birth certificate. So, Mr. Speaker, I must say, I'm surprised. That took us about 33 minutes. I'm surprised that is not even recorded in the report, and I'm not happy about that. That was a major issue at the committee. So I am entirely unhappy that the issue of birth certificate, which I raised, because it touches on ordinary people. Ordinary people in Adaklu don't acquire passport if they don't travel. The birth certificate they have to get, because they need that to even get Ghana card. So whilst I support the report, I am unhappy that the issue of birth certificate, which until today, the Supreme Court has never given me an answer which is satisfactory that their ruling is based on any law in this constitution. It is not based on any law. The Supreme Court erred, and they must be told that they've made a mistake, and they must trace their steps back and correct the miscarriage of justice that they have visited on the people of this country. Because a Ghanaian birth certificate, it is proof of whether you are a Ghanaian or not. If you are not a Ghanaian, it will say you are not a Ghanaian, because they will say your mother is an American or British. Because of that, you are not a Ghanaian. But if I have my birth certificate, my mother a Ghanaian and my father a Ghanaian, nobody can tell me that my birth certificate is just in the preparation of proving I'm a Ghanaian. So, Mr. Speaker, I think that the omission of that is a major problem with this report. But, Mr. Speaker, vetting them, all of them showed competence in the office they are about to occupy if this House approves them. Some of them, the demeanor of two of them, I am very happy about, because they showed maturity and a way that if I were to appear before them as an accused, I'll feel comfortable, because they don't appear hostile in anything. And we all commended them for that, especially the Justice Richard Ajay Frimpong particularly showed a lot of demeanor, and then Justice Yao Dakwasari as well. They showed very gentlemanly demeanor during their vetting. And Mr. Speaker, I have no reason to say that they are not qualified. In any case, Mr. Speaker, they are justices of the Superior Court, and nothing stops them. They've all served more than 4 years thereabout in that capacity. So, Mr. Speaker, I encourage
and urge colleagues to approve these justices to serve at the Supreme Court. The only thing that we ought to do, Mr. Speaker, is to find out whether the country needs a ceiling on the number of judges, because in an answer one of them said that the number of cases they have versus their number requires that they could even be more. I'm not a judge, but I don't have any way of ascertaining that, but I understand that there may be discourse in the country as to whether we should have a ceiling to the number of Supreme Court judges. But that is an open-ended question. Nobody is able to answer. Mr. Speaker, I want to support this motion and encourage colleagues to approve these justices for appointment to the Supreme Court. And I just hope, Mr. Speaker, let me put this on record. I just hope one day, if a president also decides to appoint more Supreme Court judges, members on this side will support that. Will not say that somebody is appointing too many judges. I hope you walk the talk you speak today and support that president also. Mr. Speaker, with these few words, I support the appointment of these judges. Thank you very much, Mr. Speaker.
Thank you, Mr. Speaker. I rise to support the motion for the adoption of the report of the Appointments Committee recommending Justices Henry Kofi, Yao Dakwasari, and Richard Ajay Fripong for appointment to the Supreme Court of the Republic of Ghana. Mr. Speaker, one after the other, the nominees appeared before the committee and showed mastery of their trade. From the district courts, circuit courts, high courts, and to the Court of Appeal, Justice Yao Dakwasari has had a very long journey on the judicial ladder, and he has done so with a lot of distinction and blemished record. Mr. Speaker, once before the committee, a number of issues came up and we tested their understanding of those issues and whether or not they agreed with the way and manner that things are being handled at the judiciary. Mr. Speaker, one interesting case which happened recently is a case involving one boy family and the Numo Umashi family in respect of 72,000 acres of land involving 70 villages here in Accra. Mr. Speaker, the case is born out of a Court of Appeal decision way back in 1982. And in March, the Supreme Court gave a decision, only for a clarification to come in December this year, just this month. We see that some rights have been approved over the period. And in this instance, the Supreme Court had to clarify whether or not those who have acquired interest in those 72,000 acres of land would now lose them. And it clarified that they have to atone tenancy to the new lawful owner, which is the boy family. There's some amount of confusion in the minds of a lot of people until the clarification came. And this is born also out of the long period of the litigation. So it's important that these matters, are dealt with expeditiously so that rights are not accrued, and then it comes to a time that we are told that you no longer own the land, somebody else owns the land, you bought it from the lawful owner, and so on and so forth. And Mr. Speaker, people lose their lives in some of these instances. Now we are told again that some of these matters come up because there is a load of work before the Supreme Court, and at the current instance they have about 500 pending cases
before the Supreme Court. Currently, we have only 12 justices of the Supreme Court. With these 3 getting approval, then the number will go to about 15, and they have to deal with 500 cases. Every matter by as of right can go all the way to the Supreme Court. Interlocutory matters, appeals, chieftaincy jurisdiction, election petition, and so on and so forth. So, Mr. Speaker, the jurisdiction of the Supreme Court has to be circumscribed one way or the other, and we have to do so by legislation. Of course, the chapter that deals with the judiciary are all, entrenched provisions. So this House has to do something about it. But we also encourage as a judiciary to also make proposals for some amendment that will be able to deal with the expansive jurisdiction. And we compare to the Supreme Court of the United States, for instance, and they do winnowing. They decide which cases that they will take in this term. Our Supreme Court don't have the luxury to decide whether or not they will take these cases or not. Everybody has a right to start the case from the district court and can go all the way to the Supreme Court. So, for instance, interlocutory matters. Must we take interlocutory matters all the way to the Supreme Court and even seek review? Can we legislate in such a way that the matters can terminate at the Court of Appeal level, so that we don't go winding, and then embedding the Supreme Court, with matters that shouldn't go all the way? As a matter of fact, Mr. Speaker, election in respect of parliamentary elections terminates at the Court of Appeal. Why can't we have some of these cases terminate at the Court of Appeal, or even at the High Courts, depending on where the matter is starting from? So, Mr. Speaker, the burden is quite huge on these justices, and I believe even the number 15 or 16 that we have been operating with by convention, the minimum of 9, the maximum is not prescribed, but by convention we have been working with 14 to 16 justices of the Supreme Court. And then the ordinary bench will sit with 5 members. If another bench sits, that's another 5 members. If you go on appeal, then you have 2 more. So, Mr. Speaker, we need to look at this burden that is imposed on the judiciary by our own constitution. Mr. Speaker, there's an issue of tax clearance certificates of some of the nominees. I believe that matters is very, very important. It shouldn't be a fatal matter that would, deny somebody from, being called to the Supreme Court. For instance, Mr. Speaker, on our own, we can write to the security agencies, we can write to the GRA, and then request for the information directly without necessarily asking the nominees to come and then give us those information. So I believe matters is very, very important that we have them. They are not exactly fatal as far as I'm concerned, because we can always, get a way to validate whether or not they have the very tax clearance certificate that we needed. Mr. Speaker, another issue that came up during the vetting was an issue that has to do with access to justice. Access to justice. And even more importantly, Mr. Speaker, sometimes you look at who the parties are. And in the recent case before the High Court regarding the funeral of the Gamanye, 2 or 3 days before the funeral, a High Court granted an injunction to stop the performance of the funeral. I'm not sure whether the High Court Justice was conscious of the fact that that was the Gamanye. Probably having been apprised of the fact that that was the funeral of the Gamanye, the next day, the injunction was vacated. And I asked myself, common person like Tampuli or any other person from my village in the Bushewu constituency, can such a person get the benefit of having an injunction just vacated like that the next day? So, Mr. Speaker, we need to look at some of these situations, and the judiciary has to be conscious of some of these situations. Justice should not be done because somebody is a very important personality in society or somebody is not. It must be done in such a way that everybody must feel that I can come to the judiciary and I will get justice, regardless of who I am or where I come from. And I thought that on that occasion, the Justice of the High Court that granted the injunction and immediately vacated the injunction did not do the judiciary a lot of good. Mr. Speaker, Article 71 also came up for discussion, and there was clarity, the sense that the Article 71 that operates today has judicial justices of the Superior Court, High Court, Court of Appeal, and Supreme Court, and so on and so forth. But it has to be clarified that they do not receive any lump sum the way that members of Parliament or members of the Executive receive. In their case, they retire on their salaries. So if you say justices of the Superior Court receive ex gratia, then we have to really look at it and then clarify that they are not part of the political class that receive Article 71 lump sum as is being perceived. Mr. Speaker, the judiciary has also been beneficiary of a number of facilities. Court of Appeal justices in Kumasi, for instance, have received some of the best accommodation that anyone can talk of. We have also seen the construction of courthouses, district court, Court of Appeal, circuit court, high court, all across the country. Mr. Speaker, unto whom much is given, much is what is expected of them. We expect that the long pile of cases that have delayed justice would be something that we will see of the past. So a lot is expected of our judiciary, and I believe that this House, having considered all the matters that have come up in the course of the vetting, would view positively at this report and also recommend and approve the nomination of Justice Henry Kofi, Justice Yauda Kuwasari, and Justice Richard J. Frimpong. I thank you very much, Mr. Speaker.
Honorable Mama Yaga.
Thank you very much, Mr. Speaker, for the opportunity to speak in support of the motion to adopt the report of the Appointments Committee, which considered the nominations of Justice Richard Ajay Frimpong and Justices Yao Dako Asari, and also lastly Justice Henry Anthony Kofi. Mr. Speaker, let the records reflect that all these are already sitting judges of the Court of Appeal, and upon the examination of their constitutional qualification, the committee clearly is satisfied that these three are qualified to be nominated and considered and approved for appointment to the Supreme Court. Mr. Speaker, during the consideration of their nominations, a number of very critical matters relating to the functioning of our Supreme Court came up. One that persisted across the consideration of the nomination of all three of them was the number of Supreme Court judges that we have. Indeed, their nomination was greeted with some public criticism of the numbers, and an extensive discussion of the numbers took place. There were arguments about what the nominees perceived as a misunderstanding of the structure of our Supreme Court in relation to the Supreme Court of the United States of America. Indeed, all the nominees were at pains to point out that, unknown to many people, every state in the United States of America has its own Supreme Court. Every state has a Supreme Court. And then we have the federal Supreme Court. So the state Supreme Courts tend to deal with many of the cases. And the federal Supreme Court has the power to decide not to hear many cases. Indeed, my recent checks show that on the average, annually, there are about 10,000 petitions to the Supreme Court of the United States of America. 10,000 petitions. But annually, they hear just about 80 cases. They hear just about 80 cases out of the 10,000 petitions. So they have a mechanism for sieving out the cases and determining cases that they think have constitutional significance for the development of the law in the United States. Unlike our Supreme Court, where almost every matter, even a matter involving a single bedroom can end up in the Supreme Court, because people have a right to appeal and appeal up to the Supreme Court. And the Supreme Court must hear those matters. So because of that, they tend to be inundated with a lot, and they tend to be overworked, considering the average ages of the members of our Supreme Court. And that is what has necessitated the increase in the number of the judges on our Supreme Court. Mr. Speaker, I had some discussions with some of the nominees that why don't we as a country review the arrangements that we have? Because, Mr. Speaker, if you look at our Constitution, and we discussed this during the consideration of the nominations, the Supreme Court has what other countries have established their constitutional court to do. Our Supreme Court has that mandate. At the same time, our Supreme Court has an appellate mandate. Then at the same time, our Supreme Court has a supervisory jurisdiction. The constitutional jurisdiction is what is termed as the original jurisdiction. So, if you look at our Supreme Court, you have the general jurisdiction, you have the original jurisdiction, you have the appellate jurisdiction, and you have the supervisory jurisdiction. So 4 key jurisdictions. And we are talking about comparing them to a court that, doesn't deal with all these matters. So my proposal to some of the nominees for consideration when they get to the Supreme Court is to consider having us have a separate team that focuses on the original jurisdiction, which is comparable to the constitutional courts of some countries. South Africa, they have a constitutional court that does exactly what our Supreme Court does in the exercise of its original jurisdiction. And the constitutional court alone in South Africa is made up of 11 Supreme Court judges, just dealing with the issues of constitutional interpretation. So we should have a team of judges that constitutes what is called the original jurisdiction Supreme Court. And they can be there, specialized in constitutional interpretation and appeals in human rights matters from the High Court. Then we can have another team of Supreme Court judges focusing on appellate jurisdiction, and another team focusing on supervisory jurisdiction. If we constituted the Supreme Court that way, the public will appreciate a better understanding of the need for the numbers to increase. Naturally had to increase because 1, the population has increased. 2, we have deepened the rule of law. So people are using the courts for the resolution of disputes instead of using other mechanisms. And the more people who use the courts for the resolution of disputes, the more the courts get inundated with disputes. And the more the disputes, the more the disagreements about the decision of the lower courts, and therefore there will be more appeals to the Court of Appeal and ultimately to the Supreme Court. This is a natural result of the progress that we have achieved as a democratic country as a country that is increasingly deepening the rule of law. So the numbers are increasing, and we cannot insist that we must have that small number of 9 Supreme Court judges resolving all these issues. That is why I advocate that we should have the court divided into 4. One focusing on original jurisdiction, one focus jurisdiction, and then the 4 courts, the 4 courts will then have at least the minimum, which is a minimum of 5. Minimum of 5, because that is the lowest you can have. So that way we won't complain about the numbers, Mr. Speaker. That is a more practical approach to dealing with the problem that is confronting our Supreme Court and the administration of justice. Mr. Speaker, in the last 1 week, the Supreme Court has been adjourning at 6 p.m. every day. They have been adjourning at 6 p.m. every day. And that is as a result of the pressure of work. And of course, we are also demanding that, and some constituencies are demanding that constituencies should be divided into 2, so that they can have more members of parliament here. So there's advocacy on those matters. So, Mr. Speaker, that is one issue that we should consider. Mr. Speaker, the second major issue that came up during the deliberations has been the issue, the perception of corruption. Mr. Speaker, we discussed extensively the fact that corruption or perceived corruption in the judiciary has been undermining our development as a country. It has been undermining the efficacy of the law itself. That people feel they can violate the law in land matters, and because they know that they have their way with some courts, they will do so and get away with it. And people do not have confidence in the courts because they feel when they go there and they are not resourced, they will not get justice. Mr. Speaker, this is a matter that engaged us extensively during the consideration of the nominations. And we urge the nominees, when they get to the court, being the leaders of the judiciary at the level of the Supreme Court, to find ways of building public trust and confidence in the judiciary so that we can deepen the rule of law. And we can benefit from what the rule of law does, which is people respecting the law and acting according to the law in all areas, in the management of spaces, in land management, in investment dispute resolution, every form of conflict. Mr. Speaker, people should have confidence in the judiciary and to go before them to seek justice. Mr. Speaker, they gave us all the assurances. We hope when they get there, they will do whatever it takes to be able to get us to improve upon the performance of the justice system in this country. Just because we found no reason not to recommend them for approval by this House. I therefore join my colleagues who have spoken already to urge colleagues to approve the nomination of these 3 Court of Appeal judges who have been nominated to serve on our Supreme Court. On that, Mr. Speaker, I thank you very much.
Minister for Communications.
Thank you, Mr. Speaker, for the opportunity to contribute to this discussion on the report of the Appointments Committee on the nomination of 3 judges to the Supreme Court. Mr. Speaker, one interesting observation I made was that all the 3 judges were asked about the perception of corruption in the judicial service. And even though they were not privy to the answers given by the others, they all gave similar responses that it is a perception. There may be bad nuts in the judicial service, but not all judges are but very few judges could be so categorized, and that there is a misconception that the judicial service and the judiciary are all the same. And it's interesting that when anyone who has anything at all to do with the administration of justice is accused of untoward behavior, the assumption is that it is a reference, they're all lumped together, and the assumption is that it is a reference to the corruption of judges. They also mentioned that the judiciary itself has put in place the necessary mechanisms for anybody who has any cause to complain to do so, and actually complain about any behavior that is not in consonance with their training or their ethics at the bench. And so there's a complaints unit, and once a complaint is made, the issue is investigated and culpable persons are dealt with in accordance with the law. And it is not just judges, but litigants and judicial service staff who can also be hauled before this complaints unit. And they urge everyone to take advantage of that process and ensure that we all work together to sanitize the administration of justice in this country and improve the perception of corruption in the judiciary. They also mentioned the annual Chief Justice's public forum, which enables the judiciary to have direct engagement with the public and help address some of these perceptions. Mr. Speaker, all the nominees were also asked about the introduction of technology as an aid to improve the output of the judiciary. And they all agreed that it was a useful tool and more resources should be put into enhancing the e-justice program and making it national in character. As at now, it is only available in selected high courts in the capital, in Accra. Mr. Speaker, on artificial intelligence as well, they indicated that more training should be given to the judges to know how to utilize these tools and more contemporary approaches to adjudication, and that the judiciary is applying ICT, but a lot more can be done, and that they cannot move ahead of the advances of technology and innovate, but would be willing to work in tandem with the advances in technology and also be giving more opportunities to be educated on these advances in technology, which I thought was interesting. Mr. Speaker, looking at the diverse backgrounds of the nominees, their expertise can only enrich the outcome of the court, and we're looking forward to a more robust Supreme Court, which is abreast with the developments, contemporary developments, and with judgments soundly grounded in the law. Because when asked about their legal philosophies, and some nominees were asked about conflicts between the law and religion and how he would interpret situations like that, he insisted that he's sworn an oath to apply the law, and so he would do that, and no other considerations should also be taken into consideration in his quest to apply the law without fear or favor. Mr. Speaker, their ages also indicate they are going to be on the bench for quite some time, and so that can only enrich their experience as they grow in their work on the bench. Now, Mr. Speaker, the Honourable Minority Chief Whip was Minority Whip was complaining about a decision of the court, but there are processes within which to overturn or seek to overturn in the court. So no amount of passion in advocating for a position on the floor of the House or in the media can do anything to change a decision of the court. So I'll urge anyone who feels aggrieved with a decision of the court to utilize the processes that are enshrined in our law to overturn or to seek to overturn those decisions, or to get the court to take another look at the decisions that they take. No amount of passion exhibited on the floors would do anything at all to change what is now part of the settled law of the land. And that also feeds into the perception that maybe our judges are not acting in or applying the law the way they should. And I don't think it's good for the two different arms of government to be at loggerheads with each other on decisions when there are settled processes for overturning decisions of the court. Mr. Speaker, when asked about when Justice, beg your pardon. Justice Kofi was asked about what he would do to protect the rights of the young, of the challenges of the young generation. I thought his response was interesting, and whether he would be willing to lead reforms in the court to reflect the demands and thinking of the young generation. He stated clearly that judges do not make law. They apply the law as made by us. But however, they make recommendations to the Law Reform Commission and the lawmakers. And since society is dynamic and constantly evolving, we need to take some of these contemporary developments also into consideration when crafting our laws, so that they stand the test of time and can also move with the dynamic changes that are occurring. So I thought it was useful that the judges could also make recommendations to the Law Reform Commission and bring their attention to some contemporary developments and make contributions towards the advancement of our law. Mr. Speaker, it's also instructive that all of the nominees received the unanimous approval of the committee, and that shows the manner in which they comported themselves, their demeanor, the responses that they gave to the committee, which was commendable and acceptable to all members of the committee. So I can only add my voice to those who've spoken before me and urge the House to approve their nomination. I thank you, Mr. Speaker.
Let's listen to Honorable Suhini.
Thank you very much, Right Honorable Speaker, for the opportunity to contribute to the request by the chairman of the Appointments Committee to approve the President's nominations for appointments as justices to the Supreme Court. The Speaker, I wish to make two corrections. One on page 4, on the background of Justice Henry Anthony Kofi. Mr. Speaker, when he appeared before the committee, the spelling of his hometown, Ainasi, the A is immediately followed by an I before NY. So, Mr. Speaker, I will urge the table office to take note and correct the spelling of Ainasi on page 4 of the report. Mr. Speaker, on page 23 as well, under the subtitle Perceived Political Appointment of Judges, line 5, I think that the word there should be prerequisite and not perquisite. Yes. I think it should be prerequisite and not perquisite. The Speaker, having said so, I wish to note that these nominees are going to the Supreme Court, if approved by this House, at a time that the public image of the judiciary is nothing home to write home about. Mr. Speaker, corruption or the perception of it is what is associated with the image of the judiciary. Mr. Speaker, political influence, especially in the determination of which cases are heard or in the rulings that are given, is another issue that is hanging around the image of the judiciary. Mr. Speaker, the public are also of the view that justice is expensive to procure, given the number of fees that are sometimes required and the number of processes that are filed. Some are of the view, and research has shown, that they find the justice system quite expensive to use to resolve grievances. Again, Mr. Speaker, the issue of delayed cases is something that is not positive. And these are the issues that they will be confronted with when they are approved by this House to serve as members of the Supreme Court. Mr. Speaker, some are within their control. For example, the issue of corruption or the perception of it, it's something that they can, by the way they conduct themselves, help improve. Mr. Speaker, the issue of political interference came up strongly during the vetting. And when one of them was asked about whether or not the appointment of people who are known to be politically active onto the bench has any influence on the outcome of their judgment, the Speaker, the answer that was given was to the effect that once they satisfy the constitutional requirement, we should expect them to apply themselves to the law in the discharge of their duty as judges. But Mr. Speaker, that is not how the public perceive these things. For example, there was criticism of the former president when he appointed from another party the secretary of the People's National Convention. And there is recent example also of the current president not appointing from a party that is not his party, but actually a party that he belongs to, where the judge had served as regional chairman of his party and later as a candidate for parliamentary candidate of his party in the region. The Speaker, some of these things we can explain them away by saying that they do not conflict with the provisions of the Constitution, but they conflict with the perception of the people who seek justice. And when that happens, there's a need for it to be addressed. We understand, however, that because of the workload as already espoused by speakers before me, there's a need for us to go beyond the constitutional minimum of 9. But there seems to be an agreement also that there is no capping and there shouldn't be capping. But Mr. Speaker, we are speaking in terms of our expectation that our government and our president will be reasonable and will apply common sense. However, only recently, when the president nominated these three, the president made the point that he was nominating the three to bring to the number which in his words was a full complement of the Supreme Court. Mr. Speaker, during the vetting, I had cause to raise the issue of what the full complement of the Supreme Court is. Because as things stand now, all we know is the minimum of not less than 9. But I think in the mind of the President, the full complement is 15. But we all have suggested that there's no cap. And so a full complement of the Supreme Court hasn't been determined yet. And if there's the argument that the workload is such that we should either terminate some of our cases so that they do not get to the Supreme Court, or we should appoint more, then it means that we have not yet come to what should be the full complement of the Supreme Court. And so, Mr. Speaker, I want us to be guided by the arguments that we make today, especially as they will lead to influence decisions that will be taken in future. But I just will also share in the submission of my colleagues before me that the nominees conducted themselves well, discharged themselves before the committee meritoriously, and I join my colleagues to invite the House to approve the nominees to become members of the Supreme Court. Thank you very much for the opportunity.
Yes, Honorable Joe Gatti.
Thank you, Mr. Speaker. Mr. Speaker, it became clear by the time the 3 nominees appeared before the committee that these were people who had a judicial temperament. They had the qualification, they had the judicial temperament, they had what it took to be members of the Supreme Court. Mr. Speaker, I'll come to all of them individually, but I just want to say from the word-go that one of the nominees was a classmate of mine. The nominee who was a classmate of mine was from the class of 1988. Mr. Speaker, the interesting thing that happened in the committee meeting was that as I got up to as I took the opportunity to congratulate the nominee, I made the point that the class of 88 from the law school is a class that has distinguished itself, maybe is a class that has distinguished itself more than any other class. I mentioned the fact that that class had produced 2 attorney generals and had produced 2 Supreme Court judges. Mr. Speaker, I was reported fiercely by my colleague opposite, the learned President Aboka, who said that his class of 1978 was the best class because they had produced 4 Supreme Court judges, and Mr. Speaker, it came to attorney generals, and he said they had produced Bati Hamidu, but he, Honorable President Aboka, even though he was not an attorney general, he was more than an attorney general because at a certain point he was a wise man. Mr. Speaker, I didn't know that the wise men are more than attorney generals. Mr. Speaker, perhaps even that position is bigger than the position of Speaker. You are in a position to determine, having been a minister, having been an MP, having been a wise man, and now a Speaker. But Mr. Speaker, the interesting thing about the nominees is that 2 of them have a background in maritime law. There's a certain assumption that law is once you come out of the law school, you know every area of law. Mr. Speaker, that is not the case. Law has specializations. And indeed, as more appointments are made to the Supreme Court, care must be taken to ensure that people who have certain relevant specializations are being appointed to the Supreme Court. That is why I'm exceptionally happy that 2 of our judges have a maritime background. One has practiced, one has the Tema Court, and both of them are trained in Malta. Mr. Speaker, the judges also are people who have a background in human rights. Indeed, the first nominee, Mr. Speaker, Justice Anthony Kofi, has worked at the Commission of Human and People's Rights before. A human rights background is important to the administration of justice. As you shout, a human rights background, can you hear me now? A a human rights background is important to the administration of justice, and I'm exceptionally glad that at least one of the judges has this background. Mr. Speaker, as far as the question of the number of judges of the Supreme Court are concerned, it's a well-flawed horse, and I don't want to repeat it. Suffice it to say that the comparisons that are made between Ghana and America are not comparisons that should be made, because there's completely different jurisdiction. As we were told, in America, every state has a court right up to the Supreme Court. And the Federal Supreme Court, if I can call it as such, is a court which has a special jurisdiction, which decides what case must come before it. Unfortunately for us, in our constitution, we decided that once you start in a high court, you can end in our constitution, we decided that once you start in a high court, you can end in the Supreme Court. But the point has been made that in election petitions for parliamentary elections, we have by law restricted it to the Court of Appeal. So therefore, Mr. Speaker, we can by law also start looking at certain cases that must not go higher than the Court of Appeal. And that will allow the Supreme Court some space to operate, raise this question of more and more Supreme Court judges. Mr. Speaker, Justice Richard Ajay-Frimpong was asked about custodial sentencing. Mr. Speaker, this question of custodial sentencing and the type of sentencing that must be done is also another well-flawed course. We seem to be coming back to the same issue time and time again. Somebody steals a mobile phone, he's in prison. Somebody doesn't have, steals a plantain, he's in prison. And Mr. Speaker, that is what led me, when I was Attorney General in 2006, to start Justice for All. But Mr. Speaker, Justice for All was not just about remand prisoners. Justice for All was also about custodial sentences. Justice for All was also about training of prosecutors. Mr. Speaker, somebody goes into the police because he's a good athlete. Before we know what is happening, the person is now sent to the division of the police that prosecute in court. Because the Attorney General has given this general authority to the police to prosecute, that man who is a first-class detective maybe, who is also a first-class athlete, finds himself as a prosecutor. The Attorney General does not reserve the right to withdraw the power of particular policemen to prosecute. What Attorney General, he doesn't have that power. It is only the IGP who can do it. But if the Attorney General gives the power to policemen and to immigration officers and so on to prosecute, the Attorney General must retain the power to withdraw a particular person. And to say that, Kwesi Mensah, you can no longer prosecute for me because you are not acting as an officer of the court. The Attorney General must train the people and certify them. And that will all help us in the administration of justice. This question of custodial sentencing is the matter that we must look at. We must look at the possibility of giving non-custodial sentences to minor crimes. In America, in some of the states, when you steal something which is insignificant, what they let you wear something on your chest and stand in front of a shop that I stole a phone or something like that. Mr. Speaker, these are not few words. I've spoken for a while, but I think that this is not a controversial issue. As every speaker has said before me, these three gentlemen acquitted themselves very well. In fact, there are only three people who have shown more than these three gentlemen are the three wise men who came in Jesus' time and the three wise men who were in this chamber. Apart from them, the next three wise men are these three gentlemen. And Mr. Speaker, I pray that we all support them. Thank you very much.
Yes, Honorable Clayton Saboka.
Thank you, Mr. Speaker. Mr. Speaker, I want to urge my colleagues to approve of this motion for the promotion of these three gentlemen to the Supreme Court. Mr. Speaker, as a ranking member of the Judicial Committee, I managed to join the Appointments Committee for the virtue of these judges. And by courtesy of the chairman of the committee, the first deputy speaker, he gave me audience. Mr. Speaker, the first point I want to make is a prayer to you and the leadership of this August House that in the future, if we are going to vet nominations to the Supreme Court, then may be advisable that we add the leadership of the Judicial Committee to the Appointments Committee for this purpose. Mr. Speaker will recall that the U.S. experience is that it's the Judicial Committee that vets Supreme Court judges. But we haven't risen to that stage yet. We have an Appointments Committee, but I think that it will not be out of place if we add the leadership of the Judicial Committee to the Appointments Committee for the purpose of vetting nominees to the Supreme Court. That will make it very holistic and then rich. My other observation, Mr. Speaker, I want to make is that these three nominees, I had the opportunity of getting copies of their CVs. I had the opportunity of listening to them, and I'm very confident that they qualify and are suitable for promotion to this high office of Supreme Court judges. The three of them are qualified and competent and suitable for the positions for which they have been vetted for. That is why I'm urging my colleagues in this August House to approve of the motion to promote them to the Supreme Court. Mr. Speaker, one critical issue that came up during the vetting was this question of accessibility and affordability of justice. Accessibility and then affordability to justice is contained at page 23 of the report when they asked one of the nominees what he thought about this principle, and his answer was very critical. Mr. Speaker, he said, on what proposals can be adopted to ensure the affordability of justice for Ghanaians, the nominee stated that access to justice is a constitutional imperative, that access to justice is very important, that it is a constitutional right, that Ghanaians have access to justice, that is affordable means of accessing justice. And that is a comment that I want to make briefly before I take my seat. Mr. Speaker, against this background, the vision of the judiciary is accessibility and affordability to justice. That is why, for some time now, the Chief Justice had opened up appeal court locations in some parts of the country to be able for people to access justice and to be able to afford justice. We had an appeal court sitting in Tamale, we had one in Ho, Cape Coast and Kofodua. Unfortunately, Mr. Speaker, in February this year, before Justice Enim went on retirement, he closed all those courts. So if all the 10 regions, the 5 regions in the north, plus the 3 in Bono, and then even Western North, they have to come all the way to Kumasi, Ashanti region for an appeal case. Certainly, this does not augur well for accessibility to justice, and this is not consistent with affordability to justice. Mr. Speaker, will appreciate that given the pervasive poverty of our people, it's difficult for a client to sponsor a lawyer all the way from Oti region to come to Accra, or Upper East or Upper West, etc., to come to Kumasi for a case and then go back. Only for him to come and they adjourn the case, he has to go back and come another week or so. So that militates against accessibility and affordability to justice. So I want to use this forum. The Supreme Court judges just a few days ago said that in fact it is a constitutional right, it is a constitutional imperative that Ghanaians must have access to justice and affordable justice. If that is so, and also in concept with the principle of decentralization, I want to urge that the Supreme Court, the Chief Justice, tries to review and make sure that there are people sitting in the 4 other regions so that you have accessibility and affordable justice in the system. Secondly, Mr. Speaker, we have courthouses and then accommodation that is completed, but we do not have the personnel to manage them or to make use of them. During the budget hearing, we got to know that 73 courthouses are ready, plus accommodation are ready, but we do not have magistrates to occupy them. The current position is that you must be a lawyer of 3 years standing at the bar to be able to qualify to become a district magistrate. And we are informed that many lawyers do not want to accept this appointment because of the poor conditions of service. One critical area is means of transport. The budget that the judicial presented to the president was to be able to buy vehicles, at least cars, for the judges or the circuit court judges and magistrates. But that budget was cut by half or more than half by His Excellency the President. So there is no motivation for a young lawyer to go to a rural area and then be a magistrate or a judge when you have no means of transport going to the court. And it is very embarrassing that a judge will have to stand by the roadside looking for a means of transport to go to court. Mr. Speaker, where one judge stood by the roadside and somebody came with a car and picked him. Then when he got to the court, the first case they called and the gentleman got up, accused person got up, was the fellow who had given the judge a lift to the court. So everybody in the court was surprised, said, but this man is the one who brought the magistrate to court. What justice are we going to get from him? That is very embarrassing, and that undermines the independence and the integrity of the judicial service or the judiciary. I think that we must call a spade, and then make sure that the Ministry of Finance and His Excellency the President take note of this, and make sure that the judiciary, that's the third arm of the judiciary that is in charge of settling disputes between us and making sure there's harmony in the country or in the society, are taken care of so that we do not undermine justice and the insecurity in the country. Mr. Speaker, on this advice, I want to urge my colleagues to try to support the 3 judges. I have said I've looked at their CVs and they are very competent and they're qualified. But Mr. Speaker, on a very light note, while we were there, my very good friend Joe Gatti, former Attorney General, was there, and we were excited that one of the nominees was his mate, was his call-mate, and said that they are the best batch of the law school, and that they have had 2 Attorney Generals and then 2 of them in the Supreme Court. I had to set the record straight, and I said in the 1978 batch, he boasted that they are 35 years at the bar, and I said we are 45 years at the bar, 10 years ahead of he and his colleagues. And I said that we have also boasted of 2 Attorney Generals, Martin Amidu and Betimol Idrisu, and we have boasted of 4 or 5 Supreme Court justices, Justice Doche, Justice Ayubi, then Justice Julius Ansah, and Professor Kote. They are all my call-mates to the Supreme Court, and there he conceded. And I said that even though I didn't go to the bench, I had occupied 4 ministries and I became leader here and a wise man. Yes. This one, he considered defeat, Mr. Speaker, and I want to draw your attention to because you are also a former wise man. And if I once a wise man, always a wise man. Thank you very much, Mr. Speaker. And these are the references.
Honorable members, I take the last contributor. Honorable, after that, I put the question.
Speaker, gratitude for the opportunity to add my voice to the call on the House for the report ably presented by the chairman of the committee for the 3 nominees by the President for appointment to the Supreme Court be adopted. Mr. Speaker, in doing so, let me draw the House attention to paragraph 16 of the report. Under the head notes, background to Justice Yahwa Sari. Mr. Speaker, at line 6 of that report, we are informed that the nominee then proceeded to the University of Ghana to earn a Bachelor of Arts in Law in 1986. And then 2 lines below that, we are again informed that he proceeded to the Ghana School of Law and obtained a professional certificate in law in 1986. So I think that there's some clerical error there. The table office should verify the appropriate dates and make the correct, or chairman of the committee, if we can look at the appropriate date to be fixed. And then also, Mr. Speaker, when you proceed from the Faculty of Law with a Bachelor of Arts in Law, you do not proceed to the Ghana School of Law immediately to obtain a professional certificate in law. Then what you obtain will be a certificate in the course we call Preliminary Law Course 1 and 2. It is when you qualify that you proceed to the so there has to be some correction of the records regarding his background there. Mr. Speaker, let me anchor my substantive submission on Article 128 of the Constitution. Mr. Speaker, with your permission, may I read? Article 128 plus 1 states that the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. Mr. Speaker, what this simply says is that the Supreme Court, as presently constituted, has no vacancy. So when we are told that the present appointment by His Excellency the President of these 3 justices from the Court of Appeal to be elevated to the Supreme Court, and as it were to go and fill up some vacancies, Mr. Speaker, constitutionally speaking, there is no vacancy as we speak at the Supreme Court. There are 12 existing judges at the Supreme Court, and so the court is properly constituted for its work. If the President is exercising his powers under the Constitution to make additional appointments to the Supreme Court, that has to be properly said. And don't let the record reflect that these 3 nominees that are being elevated from the Court of Appeal to the Supreme Court are going to fill up some vacancy, because there's no vacancy. The arguments have been variously made.
Honourable members, Second Deputy Speaker to take the chair.
Speaker, thank you. Mr. Speaker, let me again refer the House to Article 133 of the Constitution. Mr. Speaker, with your permission, it reads, the Supreme Court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by rules of court. Mr. Speaker, Article 134 is to the effect that a single justice of the Supreme Court may exercise power vested in the Supreme Court, not involving the decisions of the cause or matter before the Supreme Court, except that A, in criminal matters, where that justice refuses or grants an application in the exercise of any such powers, a person affected by it is entitled to have application determined by the Supreme Court constituted by 3 judges of the Supreme Court, and B, in civil matters, any other direction or decision made or given under this article may be varied, discharged or reversed by the Supreme Court constituted by 3 justices of the Supreme Court. Mr. Speaker, the point I'm trying to emphasize is that even under the Constitution, the Supreme Court is constituted for its work, but under these circumstances, in both criminal and civil matters, and where a party is aggrieved by the decision of the single judge of the court, the matter is referred to the court constituted by 3 justices. So this issue that the court presently is constituted by or is composed by 12 justices, and therefore they are inundated with work and all that. We just consider the budget by the judiciary. We've seen the number of cases they have determined for this year, and we've seen the number of cases they intend to determine next year. So I am making the point that tomorrow the criteria for even elevating and appointing justices to the Supreme Court is not even known. Mr. Speaker, there are Court of Appeal judges that have spent 15 years on the Court of Appeal panel. They have not been elevated. Some justices have been appointed to the Court of Appeal. Within a matter of 3 years, Mr. Speaker, they are elevated to the Supreme Court. So clearly, there are considerations. That is why the public perception that it appears that there are political considerations for appointing people to the Supreme Court is well founded. Because if a justice serves as a high court judge for 12 years, is elevated to the Court of Appeal and spends 15 years and is still at the Court of Appeal, and colleagues are overtaking him or overtaking them, Mr. Speaker, it gives fodder for people to feed on and feel the perception that yes, indeed, people are being overlooked even though they possess the quality and the prerequisites to be able to be elevated to the Supreme Court. Mr. Speaker, the other matter that came before the appointment committee considering these matters and as contained in the report is the issue of access to justice. Mr. Speaker, a year ago, the Judiciary Committee was impressed upon to approve an enhanced budget for the judiciary for the added consideration that the court will be sitting in other regional capitals at the appellate level at the Court of Appeal. Mr. Speaker, as soon as the 2023 budget was passed in December 2022, the Chief Justice issued a fiat in January this year to discontinue to direct that the Court of Appeal sittings at Ho, at Tamale, at Sunani, and at Cape Coast be discontinued, and that all cases pending before this court be transferred to the Court of Appeal Registry at Greater Accra in Accra or to Kumasi. And Mr. Speaker, I think that directive constricted the policy on creating further access to justice, because as the elected representative of the people, our policy underpinning in approving budgets is to ensure that justice is made easy and accessible to the people at close proximity. So if I'm a resident in Wa or Boga and I have a matter before the Court of Appeal, I am supposed to come before the Court of Appeal in Kumasi to prosecute my appeal, when hitherto I could have simply traveled from Wa or Boga to Tamale to do so. These policy considerations ought to find favor with persons who are being elevated to the Supreme Court to be able to bring to bear on the work of the bench and as well as the work of the Chief Justice in ensuring that access to justice is made easier for the people. Mr. Speaker, let me conclude by saying that we are saying that the Supreme Court is the final court of the land. And we are saying that when persons are elevated, the tendency to exhibit political coloration must be completely shed, so that the court, when it enters decisions and orders are emanating from their decisions, Mr. Speaker, it will find favor with the generality of the people. Mr. Speaker, with these words, I support the call that the 3 nominees be approved and appointed subsequently to the Supreme Court. I thank you for the opportunity.
Yes. Honorable. So, Honorable.
Thank you very much, Mr. Speaker. Mr. Speaker, actually, it's a privilege to be able to contribute to the debate on this matter. And the reason why my colleagues would listen to me, my colleagues would listen. There's a lot of talking going on. Calm down and listen. Mr. Speaker, the reason why it's a privilege is that, let me put it on record, one of the three who have been fortunate enough to be elevated to the apex court of this country, the Speaker happens to have been in the same classroom with me. Speaker, our group left the University of Ghana, Legon, in 86. And then we continued to the law school and completed in 88. Incidentally, I had by that time left, and so I didn't complete with my colleagues. But they went on, and one of them, Mr. Speaker, it's now His Lordship Justice Yao Dako Asari. Mr. Speaker, let's put it on record. It has been a particularly privileged class of 86 and 88. You talk about many of the private practitioners in the country, Mr. Speaker, my colleagues are there. I'm going to take the opportunity to mention names. Mr. Speaker, we have produced the likes of Dogate, Attorney General. We have produced the likes of Benjamin Kumbo, Attorney General. Mr. Speaker, we have produced the likes of Puaman, Lord Justice. We called him Scott. Did we add law to it at the time?
Honorable KT, please address it.
Mr. Speaker, one Nkoswari is talking, and the speaker, and Mr. Speaker, I think the speaker wants you to identify him. You know, I have been particularly privileged. I've always been in a very good company. He, the first deputy speaker, Mr. Speaker, let me put it on record. He was a young man who, in the early mornings of the 70s, 77, 78, would have to get up early in the morning to make sure that my water was ready in the bathroom for me, Mr. Speaker, to have my bath, to be able to get to classes for lectures. That's it. He made sure my food was always available. If I didn't go to the dining hall, my food was right there in my room. That is him. That is when I knew he was going to be a wise man, he was going to be a great man, so I made sure that he was named Joe Wise, Joseph Wise. I made sure that he was named as son. So there we are. The class of 88 law school, the speaker, have been particularly privileged. The Puamai I talk about is sitting in the Supreme Court, and he's going to have the comfort of sitting on the bench with his own classmate, who is now, I take it that my colleagues are all agreed, and so Mr. Speaker, we're going to agree on the motions to make sure that he has the privilege of sitting on that bench. I'm so sure when the history of the legal profession, Mr. Speaker, comes to be written, the intake of 1982 and who completed in 86 and then completed in 88, Mr. Speaker, we will not just be mentioned in dispatches, we would occupy prominent space in such recording. Mr. Speaker, the Honorable Deputy Speaker and Deputy Minority Leader here was talking about he's the chief whip. The deputy leader is Honorable Kofi Bua. So chief whip,
Mr. Speaker, the chief whip apparently has not been happy with a particular judgment of the Supreme Court, which was uttered by His Lordship, Mr. Justice Cote, who talked about some certificates and birth certificates and others, and he wasn't impressed. Here, the Constitution is so good. The Constitution is crafted such that if you are not happy with the bench, the first bench, you go for review. If you didn't take the opportunity to go for review, Mr. Speaker, you sit down, you keep quiet, you don't go about talking about a particular judgment. So that is the judgment that we have, and so you should be happy with it. Mr. Speaker, the one thing that is troubling me most about decisions of the Supreme Court, and I'm wondering if there's anything they can do about it, Mr. Speaker, is that it is the highest court of the land. Mr. Speaker, in fact, I was actually going to help. Maybe annoying me, so I will not sit down. I will filibuster and keep on filibustering. I will talk to tomorrow. All right, last sentence. I'll throw the last sentence. Look at, it's important. Let's put this on record. Speaker, I am pleading with the Apex Court, if it is possible. We always expect clarity in the law, Mr. Speaker, from that level of the judiciary. Mr. Speaker, you tend to have a decision which is 3-2. You tend to have a decision which is 5-4. There are matters that create difficulties for practitioners. I mean, if at that level, your lordships decide on 3-2, you go to Edina or you go to Elmina. Of course, by the nature of the decision taking process, what is this parliamentary? 3 will be majority now. All I say by way of conclusion is that on this particular matter, I am appealing to their lordships. It's important that there's always the kind of finality to the law. So this 3-2, 3-4-5 kind of very tiny majorities, but it's all helpful to those at the bar. And so there was a time that I knew that some judges who had opposing views, but did not press it to dissenting judgment. We now have dissenting judgment, and then there is literally a split. I am pleading with my colleague who is now going.
Honorable member.
So, Mr. Speaker, all right, everybody's pleading with me. All right, in conclusion, I congratulate all the 3 of them, particularly classmates. My classmate, as I congratulate him. Nogate, Benkumwa, mentioned the names. Joe Wise, my junior. Well, no, those of us who congratulate them. On behalf of all of them, I congratulate him. I congratulate the others, Mr. Justice Kofi, and the rest. We congratulate all of them. Thank you very much, Mr. Speaker, for the opportunity to contribute.
Honorable members, at the conclusion of the debate, the question is, all those in favor of the motion say aye. All those against say no. Honorable members, the ayes have it. The motion is carried. And that this House has accordingly approved His Excellency the President's nomination of Justice Henry Anthony Kofi, Justice Yao Dako Asari, and Justice Richard Ejefrimpong for appointment as Justice to the Supreme Court of Ghana. Honourable members, on behalf of the House, I would like to extend our congratulations to the newly approved justices.
Speaker, shall we proceed to page 19 and start off with item 35? Page 19, item 35.
Honourable members, let's turn to page 19, item listed 35.
Speaker, may I further seek your leave for it to be taken by the Deputy Minister of Finance?
So, Honourable Deputy Minister, you may do so on behalf of your minister. Yes.
Mr. Speaker.
Honourable Deputy Minister, hold on.
Mr. Speaker, we don't know. No, I mean, if you say it was shared long ago, you are moving a bill, you say it shared long ago. When? Mr. Speaker, we don't have even a copy here. Not one copy here.
If my colleague don't have a copy now, I can understand that, and we can get you copies. But you can't dispute the fact that it was shared yesterday. Personally, I was involved in the distribution of this report. But if you want further copies, we can get you that. We should proceed.
Mr. Speaker, I don't need an extra copy. I said I don't have a copy. So if he says we should proceed, why would we proceed if we don't have copies?
Very well. Honourable Deputy Minister, you may move the motion now.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the motion captured as item 35.
Yes, Honourable Deputy Minister.
Mr. Speaker, I beg to move that the motion captured as item 35 on page 19 of today's order paper be moved today. Thank you, Mr. Speaker.
Honourable members, the motion has been moved. Let's invite the chairman of the committee to second the motion.
I second the motion.
Honourable members, this is procedural motion. I'll put the question, and the question is all those in favour of the procedural motion listed 35 in today's order paper, say aye. All those against say no. Honourable members, it's obvious the ayes have it. The procedural motion listed 35 in today's order paper is carried. Yes. Are we going to 36?
Yes, certainly. 36.
Yes. Honourable Deputy Minister.
Mr. Speaker, I beg to move that the Customs Amendment Bill 2023 be now read the second time. Thank you, Mr. Speaker.
Yes, Honourable Chairman, you may second and present the committee's report.
Thank you, Mr. Speaker. I rise to second the motion, and in the process, Mr. Speaker, I rise to speak to the motion, and in the process, submit your committee's report. The Speaker, as the Deputy Minister indicated, it's a bill to amend the Customs Act to achieve primarily two things: to rename some of the lines within the HS code, and also to provide relief for raw material imports for the manufacture of sanitary towels. So, Speaker, I respectfully urge the Handler Department to capture the entire content whilst I go to the conclusion. There were no amendments to the bill.
and the committee considered that it will be helpful for this House to pass this bill into law. Respectfully,
honorable members, there are a lot of yes, honorable chairman, let's hear you.
Yeah, Mr. Speaker, there were no committee amendments and there are no advertised amendments. The committee recommends to this House to pass this bill into law. Respectfully submitted, I so move, Mr. Speaker.
Yes, honorable members, the motion has been moved and it has been seconded. It is before the House for consideration. Yes, honorable member, honorable ranking member.
Yes, Mr. Speaker, the amendment being sought is emanating from Ghana's obligation to harmonize our various customs and our legal regime to comply with the convergence criteria for almost all the African countries. We are made to understand that this will not lead to any increases in import duties at the port, but that it will help Ghana to realign with its colleagues in conformity with our international obligations. As a result, Mr. Speaker, we have no objection to this amendment and we call on this House to approve it as recommended. Thank you very much, Mr. Speaker.
Thank you very much. Yes, honorable Richard Champo.
Mr. Speaker, thank you very much to speak to the motion on the floor. Mr. Speaker, I think this is a straightforward argument because we were told at the committee that they are adding 431 tariff lines to the harmonized tax administration or regime. Mr. Speaker, what it means is that, for example, yesterday, if you go to the code, you will see malt and the others. And there's a code for malt and the taxes will be applied. But this time, they want to allocate a special code for malt. So it's not like we are introducing a new item or a new tariff.
Honorable members, please, let's have some order.
What the heck can I say?
The movement is too much.
So, Mr. Speaker, we need to be clear in our mind. We are not introducing any new taxes. We are trying to do segregation because for example, I import malt. It is classified under others, and we are giving people the discretion to apply any tax code, charge any fees. But this time, when you talk about malt, there's a code for malt, there's another tax administration or tax line for malt. So there's no discretion. So introducing 431 tax lines, it doesn't mean we are increasing taxes or we are introducing more taxes. So members must understand this. It's not like we are supporting introduction of new taxes. It's just a code, tariff lines, and we are giving definitions to where every item will belong to. It's as simple as that. So with this observation, I think we urge our members to support this report. Yeah.
Thank you. Honourable members, at the conclusion of the debate, all those in favour of the motion listed 37 today's order paper say aye. All those against say no. Honourable members, the ayes have it. The motion listed 37 in today's order paper is carried. We move to consideration. Item list 38. Leader, 38. Show consideration. we begin from the Procedural 37. So, the Minister, Deputy Minister, 37.
Mr. Speaker, I beg to move that the motion captured as item 37 be moved today. I'll be taken to the ISO move, Mr. Speaker.
Thank you, the Chairman.
Mr. Speaker, I second the motion.
Honorable members, this procedural motion, the question is all those in favor of the procedural motion, say aye. All those against, say no. Honorable members, the ayes have it. The procedural motion listed 37 in today's order paper is hereby carried. We now move to 38, the consideration stage. That is Customs Amendment Bill 2023 at consideration stage.
No advertise, nothing.
Yes. At the consideration stage, Chairman, any amendment?
No. There are no advertised amendments and there are no committee amendments, Mr. Speaker.
So we'll start from clause 1.
First schedule to Act 891 amended.
Honorable members, there's no amendment. So all those in favor that clause 1 stands part of the bill say aye. All those against say no. Honorable members, the ayes have it. Clause 1 stands part of the bill. Clause 2. So, honorable members, I think there's only one clause, so long title.
An act to amend the first schedule to the Customs Act 2015, Act 891, to add 431 tariff lines to the customs tariff and to provide a waiver for the importation of raw materials for the manufacturing of sanitary towels and for related matters.
Chairman, is there any proposed amendment to the long title?
There are no amendments to the long title.
Honorable members, there's no proposed amendment to the long title. So the question is, all those in favor that the long title stands part of the bill says aye. All those against say no. Honorable members, the long title stands part of the bill. End of the consideration. Honorable members, we've brought consideration stage to a close. So we turn to motion 39. Minister.
Mr. Speaker, I beg to move that the motion captured as 39 be moved today. Thank you, Mr. Speaker.
Honorable members, the motion has been moved. The chairman of the committee.
Mr. Speaker, I second the motion.
Honorable members, this procedural motion. The question is all those in favor of the procedural motion listed 39 in today's order paper say aye. All those against say no. Honorable members, the ayes have it. The procedural motion listed 39 in today's order paper is hereby carried. We turn to motion 40. Yes, the minister.
Mr. Speaker, I beg to move that the Customs Amendment Bill 2023 be now read the third time. I so move, Mr. Speaker.
I second the motion, Mr. Speaker.
Honourable members, the motion has been moved and it has been seconded. It is before the House for consideration. Honourable members, at the close of the debate, the question is, all those in favor of the motion listed for to say aye. All those against say no. Honourable members, the ayes have it. The motion is carried.
An act to amend the fare schedule to the Customs Act 2015, Act 891, to add 431 tariff lines to the customs tariff and to provide a waiver for the importation of raw materials for the manufacturing of sanitary towels and for related matters.
Honourable members, the Customs Amendment Bill 2023 duly read the third time and passed. Yes, Leader.
Speaker, on same page 20, item 41.
Honourable members, come with me to page 20. Page 20, item listed 41. Motion by the Minister for Finance.
Mr. Speaker, I beg to move that the motion captured as item. Mr. Speaker, I beg to move that the motion captured as item 41 be moved today. Thank you, Mr. Speaker.
Yes, honourable members, the motion has been moved. The chairman of the committee.
Mr. Speaker, I second the motion.
Honourable members, this is procedural motion. I'll put the question. This is procedural. Yes.
Mr. Speaker, the chairman must inform us why he's suspending the orders. There should be a reason why. And so he should indicate to us the reason why he's asking us to suspend the orders. Mr. Speaker, so that we can understand. And if we have to agree with him, we can agree with him. But he has to first inform us why he's asking us to suspend the orders.
Yes. Mr. Speaker, I have not moved any procedural motion in this House, and I am shocked. But if the person that moved it is not required to explain.
Yes, honourable members, the question is, all those in favour of the procedural motion say aye. All those against say no. Honourable members, this procedural motion, the ayes have it, and the procedural motion is carried. We now move to 42, the substantive motion. Yes, Honourable.
Mr. Speaker, I beg to move that the Value Added Tax Amendment Bill 2023 be now read a second time. I so move, Mr. Speaker.
Yes, Honourable Chairman, you may second the motion and present the committee's report.
Mr. Speaker, I rise to speak to the motion and to present the committee's report. I request the Hansa Department to capture the entire content whilst I take the highlights. Mr. Speaker, the committee reviewed the bill and considered that the reasons stated by the sponsors for the bill were valid, and therefore recommends to this House to pass this into law. So, Mr. Speaker, it will be important to indicate that the entire minority on the committee took a position against this bill and declined to recommend this to the House for approval. So by majority decision, the committee recommends this bill to the House for passage into law.
Thank you, Mr. Speaker.
Yes, honourable members, the motion has been moved and it has been seconded. It is before the House for consideration. Yes, honourable member for Yape Kusugu.
This Value-Added Tax Amendment Act, if allowed to go through, would only end up imposing misery, suffering on the already impoverished Ghanaian. Mr. Speaker, this amendment is not pro-poor. At best, what this amendment seeks to do is to make housing more expensive. Even though, more so, Mr. Speaker, this amendment seeks to raise a colossal amount of 3 billion Ghana cedi this year alone. Mr. Speaker, it is obvious that this government has lost its way. It is obvious that this economy is being run by boys from the Bretton Woods institutions. It is obvious that this economy is now on autopilot. All what we are seeking to do is to meet conditionalities under the IMF program, but nothing else. Mr. Speaker, this is Christmas. This is December. Today is 22nd December. Today, members are here. Does this resemble the normal Christmas? No. Mr. Speaker, this is the driest Christmas I've ever seen in my life. If you drive out there, you would even not believe that it is Christmas. Mr. Speaker, government having borrowed its way into bankruptcy, instead of thinking of innovative ways to plug the holes, innovative ways to deal with the situation, what they are seeking to do, Mr. Speaker, is to impose hardship on the ordinary Ghanaian, is to impose pain on the ordinary Ghanaian, is to impose agony on the ordinary Ghanaian. Mr. Speaker, I therefore call on this House not just rejecting this amendment, but to jettison it. We must jettison this amendment. I therefore want to call on all of us to stand firm with the people of Ghana, to stand shoulder to shoulder, eyeball to eyeball, chest to chest, looking into each other's face, and tell the Ministry of Finance that enough of the taxation. Mr. Speaker, we are this government. Money. We are not talking of resources. Money running into hundreds of millions of cedis. Hundreds of millions of cedis. And if you read the report from the Finance Minister on the Energy Sector Levies Act, we handed over about 300 million cedis to this government. Mr. Speaker, today the national purse is not only empty. The national purse is not only empty. The national purse is gone through the hole. This government has not only emptied the national purse, the national purse itself is under attack. You've emptied the national purse. As if that is not enough, mandibular termites are agitating the national purse to its core. Mr. Speaker, on this very sorrowful and melancholic note, I wish to call on members of the minority, led by the able Atufosi, a finance guru, Dr. Atufosi, to say no to this VAT amendment today, tomorrow, and the day after. Mr. Speaker, on this note, let me promise them that there will be a showdown whether you like it or not. Thank you very much. Right on the Speaker.
Yes. Minister, let me listen to.
Mr. Speaker, it is very
interesting that even today, without all the factual numbers, without what we are going through as a globe, and what this government is doing progressively to get this economy back to where before the world was plunged into this chaotic situation, our brothers, as a result of politics, they are pushing everything aside as if what is happening today has never occurred. Mr. Speaker, I never knew that taxing your own people to develop the same environment that will benefit the poor and everyone along the social stratification defines an ailing economy. Mr. Speaker, have they forgotten that between 2014 to 2016, their own budget statement, tax components or items that they added or introduced amounted to 26 taxes. It's never occurred in the economic history of this country.
1, 2, 3.
Mr. Speaker, we were not going through these challenges. The world's taxes and the world inflation rate and the world supply chain have not gone that bad as we are experiencing today. The same people that actually planned this country in a very chaotic situation, that even we had to go through power outage for about 4 years and the companies collapsed under them. They are saying all these things about ailing economy. Mr. Speaker, if we get to know the economy that we all experienced right after the COVID are now doing so much well, I'm expecting them to bring the figures. What is happening in terms of inflation rate today? What is happening in terms of even our debt to GDP? From almost 84% to 67.4%, which is even better than what they left 2014 and 2015. So, Mr. Speaker, I think they are trying to just trick Ghanaians because of political capital. But I am telling them today, the economy that we are having today, we are recovering, we are restoring. The economy is now better. People are seeing Ghana as taking time and bold steps to ensure that we consolidate our fiscal policy for the betterment of the good people of this country. They don't care about the future. They don't care about the next generation. We care. We are doing our best as the best managers of the economy on the continent of Africa to recover so fast. Because to compare all the taxes to all the growth, they left 2.4 economic growth. What is it today? They just grew the economy right from 15% to 3.4. What is happening today? So they cannot even create the impression that our government is not doing well. Even when the world was growing negative 0.3, we were growing 0.4. Mr. Speaker, I don't want to bother the world. They know Ghanaians grow. Clearly the difference between them and us. Okada's economy. I'm asking the last question. Somebody from the other side should tell us they are NSP or capitalistic, because they don't do free for anybody. Technically, so what else? Have they forgotten about the fact that we are import-driven economy, and even base rate has been increased about 1,800%, and that even the supply chain has gone west apart from first world. So what are they talking about? Government has the good people of Ghana at heart, and that we are taking the right decision in terms of consolidating this very economy for the Ghanaian. Mr. Speaker, I want to say that we are borrowing even when we need Europe. We have debt to GDP under them 2,153%. Never occurred in the history of this country. So, Mr. Speaker, they should stop doing politics, have Ghanaians at heart, and know that the time in which we are, we need them on our side to define a new point of convergence and move this country forward. Mr. Speaker, thank you very much.
Yes, Honorable Member for Bolga, Tanga Central.
Mr. Speaker, at this time of the night is 9:30 p.m. Ghanaians are finding it difficult to sleep because under this government, on the night of rising of every budget cycle, they know that they will wake up and hear taxes upon taxes. Today, we are still sitting here at this time, not because we have any good news for the people of Ghana, but that we are still here because this inept government is calling on the Parliament of Ghana to impose further hardships on the people of Ghana. Mr. Speaker, only a few years ago they came and they were saying they were moving from taxation to production. Mr. Speaker, I thank God that I didn't die. Otherwise, if anybody had told me today we will be imposing taxes on Ghanaians under this government, I would have said the person is a liar. Mr. Speaker, the only hope for the people of Ghana is that the NDC or the minority is the only group of people in this parliament at this moment in time that can prevent the people of Ghana from further taxes and further hardships. And we are going to do exactly that. Mr. Speaker, we oppose the imposition of any new taxes. Mr. Speaker, this amendment that they are proposing is going to increase the premium that we pay on our insurance for our vehicles. The taxi driver, if we approve this, will pay more for insurance. The GPRTU have already presented a petition to say that the approval of these taxes will lead to increase in the rate that they are paying for insurance for their vehicle, and as a result, they will have to increase transfer fares of Ghanaian commuters. Mr. Speaker, Ghanaians are struggling to pay for their rent. What this is going to do is that if you decide to buy a house or rent a house from a real estate developer, you are going to pay further taxes, and that will worsen your situation. Mr. Speaker, this bill envisages that Ghanaians will have to pay 3.7 billion Ghana cedis in taxes. Mr. Speaker, I would like to ask their own economic wizard, Dr. Mahmoud Baumia, when he said he was moving from taxation to production, is that what he meant? That he would rather be imposing more taxes on the people of Ghana. As we have already indicated at committee, the people of Ghana are tired of the taxes. I want to call on my colleague that this is a house of records. If he cannot mention those 26 taxes, he should stop misleading the people of Ghana. The NDC did not impose any 26 new taxes.
It's a figment of his own imagination.
It is a figment of somebody's imagination. If you cannot stop imposing taxes, don't equalize by pretending that there were some 26 taxes. Mr. Speaker, we did not impose any 26 taxes on the people of Ghana, and that is a fact. When the minister presented the budget in this house, the minister said that between January and June, the economy was growing at 3.2%. Today, 2%. The third quarter growth is 2%.
Lower than last year's growth.
Lower than 2.7% of last year.
So where's the improvement?
Meanwhile, last year we said was worse than this year, and yet last year's growth was better than this year's growth. What type of corner is that? How can you turn a corner when you are worse than where you came from?
When you progress.
You are coming from from 2.7% that you said was worse, you went to IMF. You have turned the corner, you are now 2%. In conclusion, you have put the economy in reverse gear. The only thing you know is how to put the economy in reverse gear. When you came, you were complaining that debt to GDP was 54%. You say you have never heard that before. Today, there is no even debt to GDP to discuss. Because the debt is, we say we can't pay. So, we have moved away from the conversation on debt to GDP because you have destroyed the debt. Mr. Speaker, you came here and said that the rate of debt accumulation was 26% and you have never heard that before. Today we don't have rate of debt accumulation. So the only thing you know is mismanage the economy, deterioration of life of Ghanaians, put the economy in reverse gear, and ask us to join you in punishing the people of Ghana. Mr. Speaker, we refuse to be part of the punishment you want to impose on the people of Ghana. Mr. Speaker, I want to tell my people to be bold and stand on the side of Ghanaians. Be bold and run away from Akufo-Addo and Bawumia and stand on the side of Ghanaians. Be bold and join us to defend the poor people of Ghana. Be bold and join the people of Ghana to celebrate a new phase of economic management. Ghanaians are awake at this time because when they close their eyes, you will impose more taxes. Mr. Speaker, I am surprised that my brother Kennedy Japon is not a flag bearer. At least we have had a difficulty in finding a campaign against him. How about the man who is sitting there now? We will move the economy from taxation to production. When the fundamentals of the economy are weak, the exchange rate will expose you. How about this man? We will build 32 toilets. We will come and evict you so that we don't need to build the toilets anymore. How about this big man? When he tells you that he will get Ghanaians, every Ghanaian will have a bank account, he will collapse the bank so he can't even open the bank account. How about this man? When he tells you that in 18 months no Ghanaian will have a toilet or water problem, that is even you become thirsty. Mr. Speaker, Ghanaians are not ready. Ghanaians are not ready to fall for scam anymore. And if you think that we will join you to punish the people of Ghana, we want to assure you that tonight we will not be part of this punishment. Mr. Speaker, the people of Ghana are counting on us that the suffering is too much. Mr. Speaker, I'm not sure when you buy fuel to your hometown, you will get there and you are happy. Mr. Speaker, most of you sitting here, you are struggling to buy fuel and go and fight. We want to help you to reduce the burden so that tomorrow you can go to your constituency and hold your chest high. Mr. Speaker, my brother is here shouting across the aisle. You were trying to impose an airline to ban imports when you can't produce them. You can't even produce rice and you are banning rice. You can't produce sugar and you are banning sugar. Mr. Speaker, we will fight these people until the people of Ghana take a decision. And in December 2024, inshallah, Ghanaians will speak and they will speak loudly. But remember that tonight, you are chewing wrong meat. You won't get any taxes from this side. Thank you very much, Mr. Speaker.
Yes. Honourable members, let me come to leadership. Minister, you want to say something? Yes. Yeah, Minister, let's hear you.
Thank you very much, Mr. Speaker. Mr. Speaker, I remember very well during the budget debate, our friends on the other side brought all kinds of materials here to tell us that the price of sanitary towels are so expensive that even the girls cannot buy it, so they end up using unhygienic things. This is a tax that is going to waive taxes on sanitary towels, and you are complaining. This is a tax that is going to give relief to locally manufactured textile prints in this country to enable them compete with other international prints that we import into this country. Are you for the local business to thrive, or you want to collapse local businesses, Mr. Speaker? This amendment seeks to give relief to sanitary towel producers. This is something that our friends on the other side, day and night, keep talking about. Now we are coming up with a solution, and you are running away from the solution. The people of Ghana know those who are telling us the truth. Mr. Speaker, the people of Ghana know those who are telling us the truth. Mr. Speaker, this is very, very important because we need to allow our ladies to be able to afford maternity towels, and that's right in this tax. Mr. Speaker, again, government is saying that locally manufactured vehicles are also going to be zero rated, and we need to amend this bill to enable that happen. We are for the industrialization of this country, and that is why we want to support businesses in that regard. Mr. Speaker, again, what government is also seeking to do with this amendment is to make sure we make compliance easy for everybody. And so government is saying that instead of paying the 15% on commercial premises, government is now moving into a flat rate of 5%. And so these are the things that we want to do to make sure people comply with their taxes, Mr. Speaker. Mr. Speaker, enough of the sensationalism. People of Ghana want some tax reliefs, and we believe that in this bill, we will have those tax reliefs to enable businesses to thrive. You cannot come and sit here and talk about sanitary towels and how expensive they are. Government says, I'm bringing relief, and you say, I don't understand, I don't support it. Mr. Speaker, we need to support this to allow the local businesses to thrive. We need to support this to encourage compliance. We need to support this to raise revenue to enable this government to see the kind of developments we all want to see. It is not just saying it with our mouth, but also putting it into action for the people of Ghana to know that clearly we are all serious and we want this nation to move forward. Mr. Speaker, I want to urge my people on the other side, enough of the politics. Let us be serious. Let us care for the nation and make sure that we push this thing through, because at the end of it all, it is to make our nation better and stronger, to be able to raise more revenue, and also to give relief back to these companies, to enable these companies also survive. Thank you very much, Mr. Speaker.
Now I'll come to leadership.
Mr.
Yes.
Speaker, the understanding is that 4 people will speak from each side. So I'm the third person speaking from our side.
Understanding with who?
Yes. Oh, with leadership. Mr. Speaker, it is 9:45. I just want to tell you that today is 22nd December. Tomorrow is Saturday, but my salary has not been paid. Your salary has not been paid. This is the reflection of the economy. Mr. Speaker, I am saying the reason we are here is simply because the government has run down the economy. Mr. Speaker, not too long ago, a day similar like this, our colleagues looking at us told us that if e-levy is passed, it is the mother and father of all taxes in this country, and all our problems will be solved. Mr. Speaker, on a day like this, they told us if e-levy is approved, that will be the end of taxation. That tax will solve all our problems. E-levy has been passed. Today, some of the tax handlers are supposed to raise less than 50 cedi. This government has been able to cancel a contract which has led to the loss of $140 million
Mr. Speaker, you actually managed to lose a case in the court that you and I are supposed to pay $130 million, and you are imposing tax. Did I hear you say that this bill is only about sanitary part? No, you are actually trying to put tax on the Uber driver because you are going to put tax on the insurance. Even Aboboya will have to pay more tax. What are you talking about that you want to lessen anything on anybody? Today, Mr. Speaker, building houses are already expensive. Renting houses are already expensive. You want to impose more taxes on that, and you are telling us that that is better? The flat rate is more expensive for people. So don't bother. This is not all about sanitary tax. Mr. Speaker, this tax would make the cost of renting houses expensive. This tax will make building of houses expensive. Because under this government, cement has moved from 28 cities to almost 100 cities in part of the country. This is how bad we created a situation. In fact, one of the best businessmen in this country is sitting here, Mr. Showdown. He had got to say that the cost of doing business, yes, you didn't vote for him, I know, but you don't worry. He had got to complain that he does business. He's here, he can tell me that he didn't say that. The cost of doing business makes him not competitive. He's sitting behind you. And you sit here telling anybody that what you are doing is advancing businesses. His business is suffering. He's behind you there. The example of how you are collapsing businesses, the example is sitting behind you. Canada, Japan. You understand? So the example is there with you. So please, we are saying that the only reason you are bringing this upon us is because you have run down the economy of our country. And as if that is enough, Mr. Speaker, we are seeing a situation where this same government will go and sign a contract under the Ministry of Finance to dole out $100 million willy-nilly to a company doing nothing. What kind of wickedness is this? And you want to tax Aboboya saying that we should support our country? If this is the way you define patriotism, then it's very bad. Honorable Abna, are you aware? Honorable Abna, sorry, Deputy Minister, are you aware that your ministry signed a contract to dole out $100 million? Deputy Minister, Deputy Minister, are you aware that the same ministry which is bringing the taxes has doled out $100 million? Oh yes, we are.
Honorable members, Honorable Chum, please. Just listen to him. Afterwards, you get the point.
So I'm asking the Deputy Minister, why to bring the taxes to impoverish poor people? Are you aware that your ministry have signed a contract to dole out $100 million for a company for doing nothing? No, this is not right. Our side will support the element that supports sanitary parts. But we are saying that what you are doing will not adhere to anything. Not too long ago you came here. You said luxury vehicle tax. You came back to withdraw it. Of course, you are doing this because IMF is watching us. They told you that if you don't pass this, they will punish you more. So you are doing it. But our side will guarantee you, we shall oppose it today as JJ said. We shall oppose it tomorrow. We shall always oppose it. So get ready for it. We shall stand with the people. You are standing with yourselves. We stand with the people to defend Ghanaians. I urge my colleagues, including yourselves, please, for the sake of your constituents, of which you are going to in January to get their vote at the promise, for the sake of them, for the sake of your constituents, your delegates, at the end of January, for the sake of your delegates, oppose this tax. Otherwise, they may punish you during the You may never know. With these few words, I encourage you to save yourself by opposing this so you don't get any reaction during your promise. Thank you very much, Mr. Speaker.
Yes, Leader.
Mr. Speaker, thank you for the space to add my voice to this debate. Mr. Speaker, I heard the submissions of Honorable Adongo and also listened attentively to the submissions by Honorable Kwame Agbodja. It is clear to me from the two submissions that these respected colleagues have not read the memorandum accompanying the amendment. Indeed, the submission by Honorable Agbodja was to the effect that Honorable Koneje Japan has complained about Ghanaian businesses, including his business. I heard him. This is an answer to the complaint. This bill is seeking to give more space to Ghanaian businesses. Now, for the avoidance of doubt, let me read the memorandum to you. You've not read, and you are talking about imposition of taxes. Listen, what brought this bill here? I read, the object of the bill is to extend the zero rate on locally manufactured African print and locally assembled vehicles. Introduce a zero rate on locally produced sanitary towels. Waive the value added tax on the import of electric vehicles for public transportation. Introduce a flat rate of 5% for the rental of commercial premises and the sale of immovable property by an estate developer, and remove exemption from tax on selected products. Now, you were talking about Honorable Kennedy complaining about how local businesses are unable to compete. Now, if somebody imports and is to pay tax, and somebody manufactures locally and is paying the same tax, is there an incentive for locally manufacturing? No. And that is why this waiver is there. So don't talk about this imposing a tax. Don't talk about imposition of tax. Don't talk about imposition of tax. If you've not read, don't just comment because you want to enjoy the liberties of opposition to attack government. Honorable Agbodja, Honorable Adongo, your contention was with the fact that Uber drivers are going to suffer. Are you saying that we shouldn't encourage local manufacture of cars? Have you read this memorandum, Mr. Speaker? It is clear that these same gentlemen who could not manage the economy,
Honorable members, when Honorable Kwame Agbodja was talking, I deliberately decided not to allow anybody to interrupt. People were up on their feet, but I just decided that we should allow the debate to flow. Honorable, when Kwame Agbodja was speaking, he mentioned Kennedy Japan's name. You could have also got up to intervene. Please, I am not entertaining interruptions. You will get the opportunity, then you address whatever you think it is not represented. Honorable Deputy Leader, just move on.
Mr. Speaker, I've said here time without number that our colleagues cannot take punches. They give us all the punches, we take it. When it's our turn, then they are getting up. You can't take it, sit down. You can't take it. You can't take it, sit down. You are not a Democrat, you can't take it, sit down. Mr. Speaker, if you read the paragraph 2 of the memorandum, it again reads that existing concessions of value added tax rate of 0 on locally manufactured African print textiles and locally assembled vehicles are being extended for 2 years to continue supporting manufacturers of locally produced textiles.
Honorable Leader.
Mr. Speaker, you are not granting him any dispensation. He kept quiet, we sat down and listened to them. Mr. Speaker, we listen to them.
Honorable Leader.
They must listen. There is no point of order. Mr. Speaker, they must have that patience.
Will you listen to me?
Patience to listen. We kept
quiet for them. Why are you interrupting? When you were on your feet, we kept quiet. We listened. However painful it was, we listened. Why are you not sitting down to listen? You don't want to take it? You don't want to take that bitter pill? You will take it.
Honorable Leader, as I'm saying, I wouldn't entertain any interruptions. They are saying you have abused them. So Honorable Leader, please. Honorable Leader, please. I want the debate to be moving on, but let's make sure we don't bring any language that will cause others to just come on their feet. Please, just make sure. Honorable Minister, please. Yes. Yes, Honorable Leader.
Mr. Speaker,
I haven't called you. Honorable, if you have anything, pass it on to your leader so that you address it. Honorable Leader, please continue. Yes. Honorable, will you resume your seat? Yes.
Mr. Speaker, with respect, I agree that we want to allow the debate to flow. However, Mr. Speaker, the Honorable Deputy Majority Leader mentioned the name of the Honorable Adongo and made direct allegations that he has not read personal allegations that he has not read the value-added tax amendment bill. And Mr. Speaker, that is the reason why the Honorable Adongo stood up. And it is only right that you allow the Honorable Adongo to at least, because he made statement personally to him. So it is only right that you allow him to make some point and collect the records, because the Speaker is important. It is important. And so I don't think he's done anything, you've done anything wrong, the Speaker, but I'm concerned. I'm concerned because the Speaker, my brother Afenyo Makin seems to attack you. Because the Speaker, I've been monitoring his body language towards you. And the Speaker, I don't think it's fair. I don't think it's fair. The Speaker, as we speak, he has turned his back to you. He has turned his back to you. The Speaker, and this is against the rules of this House. This is against the rules of this House. So the Speaker, I urge you to ask the Honorable MP Futu to sit properly and call him to order. Because he has turned his back to you, Mr. Speaker. It's important to do that. Thank you, Mr. Speaker.
Yes, Honorable Leader, I've heard you. But equally, when Honorable Kwame Buja was speaking, kept mentioning Honorable Kennedy Japan. Honorable members, please. Is it not the case that Honorable Kwame Buja made a lot of reference to Kennedy Japan? So, well, Very well. Very well. Honorable Adongo, let's hear you.
Mr. Speaker, ordinarily I will not rise on my feet when my leader is speaking. And Honorable Alex Afeyamakins is my leader in this house. But when he makes attributions to me that are false, it is only proper that I clear my name. Most especially when he makes the point that I have not read the memo. As the ranking member at committee, this report is signed by the chairman of the committee, Honorable Okukwadi. And the minority took a position are reiterated in this house. I don't know whether my honorable colleague is implying that we did not read the memo. Honorable Okukwadi did not read the memo, but he agreed with the position of the minority and reported it as such. Mr. Speaker, point 6.2. Mr. Speaker, 6.6.2. The position of the minority.
So are your point of order has been made?
My point is that I want to read to you what this report stated about the minority after we read the memo. And then he must go and apologize to me because I read the memo and took a position with the rest of the minority.
Honorable member.
So he cannot end up saying that I did not read.
Honorable member,
this is after reading the memo.
We've heard you read it. You read it. Honorable Chama, you want to say something?
The Speaker, it's important we correct the record that I supported a minority position. I have never done that anywhere. Even at the committee level, we tried to prevail on the minority to see the point of this bill and to support it. I am surprised. I don't know where in this report it is indicated that any of us supported a minority position. It's not too late. We still urge the minority to support this bill so we can pass it into law so that people can have the benefit that this law will bring. I thank you, Mr. Speaker.
Very well. Honorable Deputy Majority Leader, let's continue.
Mr. Speaker, I shall, for the avoidance of doubt, read aloud the memorandum accompanying this bill. Mr. Speaker, for emphasis, I shall repeat paragraphs 1, 2, and 3. To re-echo the earlier submission, that indeed all submissions earlier made aimed at telling Ghanaians that this bill is imposing taxation is untrue. It will mean that the person or persons who made such submission have not read, and indeed they have not read. Mr. Speaker, the object of the bill is to the extent that zero rate on locally manufactured African free and locally assembled vehicles, introduce a zero rate on locally produced sanitary towels.
Honorable members, it's now 10 o'clock. It's better we listen to ourselves, we cooperate to ourselves, so that we can finish what we have to do. Honourable members, please resume your seat. Resume your seat. Yes.
Please, Mr. Speaker, I must thank you for giving me this opportunity. But Mr. Speaker, I am unfit just to seek your guidance and that of leadership, and for leadership to appreciate the role of the Speaker in maintaining order. Mr. Speaker, when the Honourable Ranking Member on Finance was on his feet, Mr. Speaker, beside the member giving his rendition on the floor before the Ranking Member on Finance was on his feet, Mr. Speaker, most at times the Ranking Member on Finance is our spokesperson on finance and on this specific report, and that was the more reason why he was on his feet. So, Mr. Speaker, when you gave that directive that you wanted the debate to flow, the leadership must take you. And Mr. Speaker, sitting here, I was not happy the way the deputy majority leader reacted towards you. And Mr. Speaker, you are in government, and where we are ready to support you to prosecute your business. But if you are speaking as if you are a minority ranking member on privileges or ranking member on this, Mr. Speaker, government bench must behave like government bench, and we must take you from the leader of the house. When the leader is giving a cue, we must take that sense. So, Mr. Speaker, where we are, you have indicated that the Speaker is almost 10 o'clock. Mr. Speaker, we have been there before, and the common majority leader is here. Mr. Speaker, where we are, I remember sometimes we used to be told that let them have their pay and let them have our way. But now, the way the leader treated you, if he will not listen to you, should we also listen to you? Mr. Speaker, we must all listen to you in reason. This is why you were guiding him, and he must take a cue from you. You are the Speaker and the Presider of the House, and we must give you 100% respect. But when we do this to you, and presidents are learning that, Mr. Speaker, can we accuse them? They are copying the deputy majority leader. Mr. Speaker, we must not copy.
Yes, please, resume your seat. No, resume your seat. Yes, leader.
Mr. Speaker, I think we have had enough of the distractions. Mr. Speaker, time already is not on our side. And I believe after the deputy majority leader, the next person in line is supposed to be the minority leader. Mr. Speaker, let us listen to the minority leader or the deputy leader to conclude this, to enable the minority leader to make his intervention. Now we'll take it from there. And Mr. Speaker, we should all learn, and we should learn to accord respect to one another. There has been an instance, it was just yesterday, when the majority leader, the leader of the House, got up to make an intervention, and the Speaker refused to acknowledge him, and instead shouted on him to sit down. You have seen this in this House. Mr. Speaker, two wrongs don't make a right. Let's move on, and I believe that because we have I guess 3 more bills to deal with before the appropriation bill. And just to sound that whatever happens, we'll deal with the 3 financial bills before the appropriations bill. But let's maybe manage the time, because as I said, we'll deal with the bills before the appropriations bill. So let's listen to the conclusion of the deputy leader's intervention. The minority leader, as I said, we'll take it from there. But Mr. Speaker, I will appeal to you that let's manage the time. Allocations two members who get up to talk. From now on, any bill, the Speaker, whoever gets up to talk, may not be accorded more than 5 minutes, apart from the leaders. So we make advance quickly and then move on. Thank you.
Thank you very much. So, Honorable, please resume your seat. Please. Honorable Afenyomakins, please conclude.
Mr. Speaker, nothing more to add. Nothing more to add.
Very well. So let's come to Minority Leader.
Mr. Speaker, it is dangerous to read and not to understand. It's very dangerous to read and not to understand. Mr. Speaker, who on earth claims to review taxation downwards and yet project to get 3,725,000,000 additional revenue? Who does that? Mr. Speaker, value-added tax is a very technical area. And if you don't understand value-added tax, don't veer into areas you don't understand. Mr. Speaker, let me take my time and take you through this very tax. It looks as if those who claim that they have read don't understand the value-added tax before us. Mr. Speaker, the fact remains that any time a tax is exempted from value-added tax, then it means you are not paying VAT. And anytime you rope them in, you are paying VAT on those items. So it is an imposition of tax. So Speaker, first, this tax seeks to do a number of things. But let me first take you through some of the things that this tax seeks to do. First, this proposal before us is seeking to introduce a VAT flat rate on the sale of rare estate. So Speaker, and rare estate has been defined to include individuals that engage in the business of construction or renovation. So Speaker, this simply means that if you are an individual and you are in the business of building, including renovation, that bill must be accompanied by a value-added tax. So Speaker, going forward, if this bill goes through, anytime you buy a house, be ready to pay VAT on the house. That is what it is. So Speaker, anytime you rent a house, including kiosks, any commercial property, including kiosks, the Speaker, you will renting kiosks. That is what the law is trying to say. The Speaker, anytime you rent any form of commercial property in the Republic of Ghana, the Speaker, this bill is telling us that you will pay value-added tax. The Speaker, that is not a relief. The Speaker, aside that, this bill is telling us that going forward, they are imposing taxes on the following: textbooks, exercise books, newspapers, publications, charts, architectural plans and similar plans, drawings, scientific and technical works, periodicals, magazines, Mr. Speaker, trade catalogs, price lists, calendars, diaries and stationaries, and other printing materials. And this is in the bill before us, Mr. Speaker. I'm reading to you the
Hold on. Honorable Deputy Majority Leader.
Mr. Speaker, I rise to correct him on two things. He is misreading the memo. Mr. Speaker, it is the reference he made is in respect of imported. Imported. Mr. Speaker, it is in respect of imported. Please, please. And again, you had an issue with somebody saying that you have not read. But you said somebody doesn't understand. Is that right? If you disagree, say you disagree. Don't say the minister does not understand. I don't go to offense to saying he has not read. For the avoidance of that. Mr. Speaker, this is what the bill is saying. Mr. Speaker, the person who introduced it doesn't. Mr. Speaker, the person who introduced the bill, you are claiming that he doesn't understand. So you are going to educate him, follow other tax. Mr. Speaker, local businesses are being protected by this law. This is for local businesses, local manufacturing. And you, as a minority leader, you are misleading Ghanaians by saying what? By saying what? Why are you not talking about the waivers? Why are you not talking about waivers? Mr. Speaker, the relief being given to local manufacturing. Why are you not referring to that? Mr. Speaker, please. I mean the market. Let me finish.
Honorable Kwame Muja, resume your seat. Resume your seat. Honorable Deputy Majority Leader, bring your point of order to a close. Honorable Muja, please resume your seat. He's doing another presentation. As soon as his presentation, he do another one. He's a speaker. Allow him to do another presentation. It's okay. It's okay. Honorable Afenyo, please conclude your.
Mr. Speaker, so what he was trying to tell Ghanaians. Mr. Speaker, let me read it. Mr. Speaker, he said that the exemption is subparagraph 1 does not apply to imported textbooks. Mr. Speaker, we are talking about imported exercise books, newspapers, publications, and chat. So it is in respect of importation.
Very well.
Read it.
Very well. Very well. Honorable Minority Leader, let's hear you.
What kind of nonsense is this? You want to go and take over? Where is your bullet? What?
Mr. Speaker, I will say it again that value added tax is a technical area. It's a technical area, and if you don't understand, don't be in.
Honorable.
Shame!
Yes, leader.
A deputy minority leader has just used very offensive language. I want to believe that it was inadvertent. I want to believe that it was inadvertent. Let him withdraw. I want to believe that it was inadvertent. When he said that, what kind of nonsense is this? I want to believe that it was inadvertent. Let him withdraw so that we make progress. He's going to withdraw.
Mr. Speaker.
Sit down.
Yes, Minority Leader. Let's hear. Let's hear you.
Mr. Speaker, to repeat my point again, this very tax before us is doing a number of things
to the extent that the government intends to use this bill to raise 3.7 billion Ghana cedis additional revenue. 3.7 billion Ghana cedis. The Speaker, put this amount in proper perspective. Last year alone, infractions from the Auditor General's report alone was 17 billion Ghana cedis. 17 billion. Not long ago, Mr. Speaker, we heard about a new contract that has been signed at the Ministry of Finance called SLL. That contract alone, every year they pay the contractor apparently for no work done 24 million Ghana cedis a month since 2018. The Speaker, year to date, since the contract was awarded to date, they paid the contractor almost 2 billion Ghana cedis. The Speaker, again they've awarded another contract worth $100 million a year. The Speaker, as if that is not enough, tax exemptions before the Finance Committee alone is 5.4 billion Ghana cedis. 5.4 billion Ghana cedis. Yet they are asking us to burden the ordinary Ghanaian with new taxes. With new taxes. To the extent that they raise additional revenue worth 3.7 billion. But Mr. Speaker, let me tell you what they are seeking to do. Let me take you through what they are seeking to do. For the first time in the history of the world, this MPP government has set another world record. The first country in the world to introduce insurance, a VAT on insurance products of the world. I challenge you to show me one country in the world that charges VAT on insurance products. For the first time in the history of the world, Mr. Speaker, I say this on authority as a tax practitioner. No country in the world, Mr. Speaker, as we speak, if you are going to buy insurance for your building, you pay VAT on it, 21%. If you are to buy insurance or car insurance for your vehicle, Mr. Speaker, you will pay insurance 21%, in VAT 21%. Mr. Speaker, the VAT we are talking about here, this law, if we allow it to go through in its form, comprehensive insurance, fire insurance, employers insurance, all insurance, building insurance, every insurance apart from life insurance, Mr. Speaker, is going to go up. It's going to go up. And the GPRTU they have already warned that if this bill goes through, they will increase their lorry fares. Mr. Speaker, and I heard someone saying that this is not a tax. This is a tax. So please, don't go there if you are not too sure about what you are saying. Mr. Speaker, aside that, they are telling us that they are going to introduce VAT on a number of items. Mr. Speaker, and I repeat them: textbooks, exercise books, newspapers, Mr. Speaker, publications, charts, architectural plan, drawings, scientific and technical works, periodicals, magazines, Mr. Speaker, trade catalogs, price list, armaments, calendars. Mr. Speaker, who imports a calendar? Mr. Speaker, there is a stationery. Mr. Speaker, let them tell us. Mr. Speaker, stationaries, even the pen that your son or your daughter is going to use, you are going to tax it. Mr. Speaker, papers are included. Mr. Speaker, rulers and pencils, they are going to tax it. You have lost the way. You have run out of ideas. That is why you have resorted in taxing stationery. The Speaker, including eraser, they are taxing eraser. The Speaker, who taxes eraser? The Speaker, you are taxing erasers, pencils, pens. The Speaker, pins, these pins, they are taxing them. Very soon, you will tax air.
That is where you are going. You are completely lost of ideas. And this is where we are going. So, Speaker, that is why we are saying that where the country is going now, we can't support them to impose taxes on school children. School children that uses e-razors. You are imposing taxes on e-razors. And then you say that including sharpness. Even sharpness as part of stationery, you are taxing sharpness. And you are telling us this is not a tax. To the extent that even crayon, you are taxing crayons. Crayons. I won't give you any more. The Speaker, these are serious issues. These are serious issues. We don't want to tax crayons. We don't want to tax pens. We don't want to tax erasers. And that is why we will support this. So, Speaker, if this tax is allowed to go through, office bills will suffer VAT. And then the insurance, the Speaker, I'm particularly concerned. I am particularly concerned because, Mr. Speaker, Ghana, once again, under this administration, will be the first country in the world to tax insurance products. Nobody does that. Nobody does that. You are the first country in the world to tax savings. First country in the world. As if that is not enough. You were taxing people's wallet. They took the wallet. The Speaker, that is what it is. That is what, and that is why, Mr. Speaker, we have said that this particular batch, we will vote against it today, we will vote against it tomorrow, and we will vote against it anytime it comes here. Mr. Speaker, that is our position. Mr. Speaker, the chairman, the ranking member of the Finance Committee spoke on this matter. The Committee on Finance, when they met, our side of the committee opposed it. They called for a head count. And every member of the NDC, that is a member of the Finance Committee, voted against this. So, Speaker, it is for that reason that we in the NDC insist that this tax should not be allowed to go through. This should not be allowed to go through. Thank you very much, Mr. Speaker.
Thank you. Leader, I think the Minister of State would like to say something. And then
Mr. Speaker, thank you. Mr. Speaker, I'm coming on point of order. I think that the minority leader is providing wrong information as far as taxes on insurance products are concerned. Mr. Speaker, South Africa has taxes on insurance products, and so the records have to be corrected. That Ghana is not the only country in the whole world that imposes taxes on insurance products. South Africa has taxes on insurance products, so the records must be corrected. And thank you, Mr. Speaker.
Yes, Majority Leader. Yes, Majority Leader.
Mr. Speaker, I rise to support
Leader, it's now 10:30. Please. Okay. Yes, Leader, let's hear you. Let's hear what.
Mr. Speaker, the bill before us is the value-added tax amendment bill. We debated the value-added amendment bill.
and not income tax or any other tax. Mr. Speaker, the references I made here are value-added tax references. So for him to stand up to say that I have said something other than VAT, Mr. Speaker, he needs to come again. Because my references relate to VAT.
Well.
VAT, not any other tax.
We hear you. Yes, Honorable Majority Leader.
Mr. Speaker, even though we are debating the Tax Amendment Act, he made a categorical statement that there is no country in the world that charges taxes on insurance. That's what he said. I think he gave it a taxes.
Honorable Minister, you have to catch my eye before you speak. So, Honorable Majority Leader, please, let's hear you.
Mr. Speaker, let me correct a factual inexactitude on the part of the minority leader. Clearly, Mr. Speaker, he got the description wrong. Mr. Speaker, first he said to us that there is no VAT on insurance anywhere in the world. Mr. Speaker, South Africa. Mr. Speaker, that is, let me read it. Is the section 2.1 Roman number 1 of the value added tax number 89 of 1991. Please, Mr. Speaker, I'm giving you the source. It is not for me, I'm giving you the source. I have given you the source. Mr. Speaker, you started by saying that there's no way in the West.
Honorable members, Honorable Minority Leader.
Give you the law,
please.
And you're telling me
let's allow him to speak so that we can. I mean,
please. So, if you have not read, don't arrogate yourself that competence which you don't have in this matter. You don't have it. Mr. Speaker, now he also gets the rendition totally wrong. What is here provides the exemption in paragraph 1 does not apply to imported textbooks. You say it's textbooks. Not totally wrong. Imported textbooks, imported exercise books, imported newspapers, imported publications, imported charts. The Speaker, again, it refers to architectural plans and similar plans. The question is talking about the application of these things. The Speaker, drawings, scientific and technical works, periodicals, magazines, all of them that he mentioned. They are imported stuff. You want to throw dust into the eyes of Ghanaians. You are the minority leader. Speak to the truth. Mr. Speaker, now the remit of this is it intends to extend zero rate on locally manufactured African prints. Mr. Speaker, it is about import substitution. Again, locally assembled vehicles, locally produced sanitary towels. It's about import substitution. The Speaker, electric vehicles for public transportation. The Speaker, then 5% on rental and commercial premises and the sale of immovable property by an estate developer and also selected products. The Speaker, that is the remit of the bill. The Speaker, this VAT, we have a government in this country which imposed taxes, VAT, on cutlasses. It was under their watch. At a time when this country was suffering from AIDS, you imposed VAT on condoms. VAT on condoms.
Leader.
You are the deputy Minister for Finance. At the time of the height of AIDS, HIV/AIDS, you imposed tax on condoms.
Leader, please let me. Your colleague is.
I have so much.
We don't need it.
I will not use it.
Leader, I'm doing that because he's a minority leader. So
he says he's coming up point of information. Mr. Speaker, I will not yield to him.
Yes, minority leader.
Point of information, I will not yield to you. Mr. Speaker, they impose taxes on Kayaye. They impose taxes on Kayaye.
Leader, can you allow your colleague to?
Mr. Speaker, I come on point of order. Mr. Speaker, the Honorable Majority Leader is misleading us. Mr. Speaker, he made reference.
Point of order.
He made reference.
Honorable Leader. Honorable Leader, I ask you to speak, but once you say you are coming on point of order, then let's hear.
Order 91. Mr. Speaker, the Honorable Majority Leader said that South Africa imposes VAT on insurance products. Mr. Speaker, it is not correct. Mr. Speaker, I have the legislation before me. Mr. Speaker, let me read the legislation to you. Mr. Speaker, I did not just come here to speak. I have done my research. Mr. Speaker, please. He said that in terms of Section 211I of the Value Added Tax Act number 89 of 1991, premiums paid under a long-term insurance policy are regarded as financial service as defined in the Act and therefore exempt from VAT. Mr. Speaker, what is there is an exemption.
Leader,
exempted from VAT.
You've made your point. It's okay.
Mr. Speaker, I'm making the point.
You have made your point.
Mr. Speaker, I'm not done.
You've made your point.
I am ending, Mr. Speaker. Mr. Speaker, the point is that it is true that VAT, South Africa imposes VAT. It is rather exempted.
Leader,
premiums are exempted.
That is all right. That is all right. Yes, Majority Leader.
Mr. Speaker, it's clear that my colleague is lost in the wilderness. You are lost in the wilderness. Mr. Speaker, you quote Section 211I. I quoted Section 211I. Mr. Speaker, he's lost. He's lost. You see how he's going there. I quote something. You can't wrong. Read your own. Mr. Speaker, so you see, you even got it wrong. And all the person speaks. You think it's wrong. I know how to satisfy your ignorance. I will not satisfy your ignorance. I will not satisfy your ignorance. Go and read. Mr. Speaker, our orders provide. If you care to know, we are member of Parliament, that if any relevant information is contained in an official publication, you must appreciate it. You can't even appreciate the import of your own salary orders. You don't even understand because you don't read the salary orders. It's not for me to read it. It's not for me to read it. It's your responsibility. You can't even appreciate your own salary orders. Mr. Speaker, so with respect, these shenanigans much ado about nothing. And I will invite you, Mr. Speaker, to put the question. I will make progress. I thank you very much.
Honourable members, at the conclusion of the debate, the question is, all those in favour of the motion listed 42 in today's order paper, say aye. All those against, say no. Honourable members, again. those against say no. I think the ayes have it. Yes, I think the ayes have it and ayes have it.
Madam Speaker, respectfully, I rise on order 1132 to challenge your ruling and to ask for head count because I believe the nays have it. Madam Speaker, I rise on order 1132 to challenge your ruling and to call for a head count because I believe the nays have it. Thank you.
Yes, Majority Leader.
Mr. Speaker, you have called, at the conclusion of the debate, you have called for a voice vote. And my colleague, after the determination that you have made, goes up to say that is challenging your ruling. Mr. Speaker, you have not made any ruling. You have not made any ruling. You have made a decision. If you don't understand the orders that operate in this office, in this house, please go and read. There's no ruling. There's no ruling. If you want to challenge whatever, come properly. Otherwise, Mr. Speaker, we move on. Mr. Speaker, challenge
when the voice vote was taken, Mr. Speaker, I noticed you couldn't clearly determine which one had it. So he said, I think. Mr. Speaker, at that time, the deputy minority leader was on his seat. You ignored him and said, I have it. Mr. Speaker, that is wrong. You ignored him because now the majority leader is standing on that saying that you give it, Mr. Speaker. If this one stays, the next time we get up, Mr. Speaker, please watch us. Please watch us because it is not true. The case that you were clear. He said, I think. It means that you were not even sure. Mr. Speaker, this should not be a strategy to just bulldoze your way through for the sake of order in the house.
Mr. Speaker, it is clear that the front bench of the minority don't even understand the issue that I raised. What it is, what our orders provide, if I should read to you, is that a member may call for a head count, which is what he is doing. He has the right to call for a head count. I'm not disputing that. But he premised it on a statement that he's challenging the ruling of the Speaker. And I'm telling you that there's no ruling by the chair. If you don't understand what I said, that is what I said. That is all. Let's move on, Mr. Speaker, because there's nothing before you. You have not made any ruling, and so we can move on. Mr. Speaker, let's move on.
Madam Speaker, for the avoidance of doubt, I rose on order 113 and let me read it. A member may call for head count or division if, in the opinion of the Speaker, on the voice vote is challenged. Mr. Speaker, that's exactly what I mean. So, your opinion is what I rose to challenge because I believe
You are calling for head count.
So it was his opinion that I challenged. I have told you that it was his opinion that I challenged.
So, Honorable Deputy Majority Leader, it means you are challenging my...
Rightly so. Right on.
Honourable members, per our standing orders 1132, if a member challenge the ruling of a speaker and is asking for head count, very well. So, honourable members, in order that we will do the head count very quickly, I will ask that we will restrict ourselves from moving around so that the clerk can do the counting as quick as possible. Honourable members, please, let's help ourselves. It's almost 11 o'clock. So, very well. Leadership. Are we mentioning names?
Mr. Speaker, the order is very clear. The fact that a wrong precedent has been set doesn't mean that we should go with it. Mr. Speaker, the order provides that a member may call for head count or division if the opinion of Mr. Speaker on the voice vote is challenged. Now, 3 provides, in the case of head count, Mr. Speaker shall take the vote of the House by calling upon members who support or oppose his decision successively to rise in their place. Mr. Speaker, this means it's just a validation of your decision. It's just a validation of your decision. What was done the other time was totally wrong. And alien to our standing orders. Mr. Speaker, what this means commonsensically is that you have made a decision. And you require members. Commonsensically is unparliamentary. It's commonsensically unparliamentary. If it is, I will draw. If to you it's unparliamentary, I will draw. Mr. Speaker, my colleague, the way he got up, as if he was possessed. So let me withdraw the word, so that we move on smoothly. Mr. Speaker, I'm saying that what this means, 3 means is that you have made a decision. And those who support the decision, you have said that the ayes have it. Those who support that decision should rise up and be counted. And then after that, those who are opposed to the Speaker's decision would also rise up and be counted. That is the import of Order 1133. You may shake your head and disagree with me. I totally disagree with you. What was done the other time was out of sync with our rules.
Yes.
We make the laws. First of all, let me establish that here in Parliament, we make the laws. So any serious member of Parliament will understand and appreciate the laws better than whoever trained professionally to try to understand what Parliament has done.
Yes, honourable member for Boko Central.
Mr. Speaker, Order 113 deals with several issues. Please, Ahmed, please. Ahmed. Mr. Speaker, Order 113 deals with a number of issues. Sequence. 1131 deals with voice voting and how to declare the results. 2 deals with a situation where a member may challenge Mr. Speaker's decision.
Honorable. Let's hear you.
Two is the clause. Two is the clause. Two is the clause that deals with challenging the decision of Mr. Speaker and then necessitating a head count. 3 now deals with the process of a head count. And it was 3 that the Speaker ruled the other time that successively rising in their place, in his opinion as Speaker, means that he is going to get everybody who sides with one position on the matter that was voted upon to get up successively in their seat so that he will count them. Unlike in the past when we all will rise as a block and then they will count us, he wanted us to be mentioned individually, successively in our seats. And that is what he did the last time. So we are simply saying that as we speak, the ruling of the Speaker is that he is going to mention our names individually and successively in our seats we will rise up and indicate whether we are voting for or against the matter. That is the position now, Mr. Speaker.
Let me give opportunity to the First Deputy Speaker.
I thank you, Mr. Speaker. Mr. Speaker, your responsibility now is in 1133 is head count, and it says that in the case of head count, Mr. Speaker shall take the vote of the House by calling upon members who support or oppose. Note this: support or oppose. His decision successively to rise in their places. So the successively refers to support or oppose. One comes, the next one supports. That's right. As for the rule of head count, there is no challenge. It has been the practice. And I don't think that Mr. Speaker has changed the rule. Effectively in the head count,
Honorable members, indulge me to see the seat to the right honorable Speaker.
Honorable members, I see the First Deputy Speaker on his feet. Yes, please.
Thank you, Mr. Speaker. Mr. Speaker, I'm reading the rules. The Speaker, I recall I referred to some people as disruptors. He said I should not call them that. They are leaving that out. Mr. Speaker. We're engaged in discussing the process of head count as prescribed in Order 1133. And the Speaker, my argument is that the rule is clear that because members are being asked to show their vote in support or opposed to the ruling of Mr. Speaker, the subsection there refers to who comes after who. And it doesn't refer to names being called out as you stand in your place and your name is called. The succession here refers to supporting or opposing the decision made by Mr. Speaker, and that should guide the interpretation of Order 133 in this case. I thank you, Mr. Speaker.
Honorable members, we cannot on daily basis go over the same standing orders because we disagree. A speaker gave a ruling on it and I stand by that ruling. Honorable members, please, we will use the list and the hairs will be counted. Please, don't. Please, table office, take the list and let's count the hairs.
Abatas Samuel Erickson. Abanga Abdullahi. Abdullahi Jacob Idris. Abdulatif Jan. Abdul Salam Adams. Ablagba Samuel Kujeto. Abaji George Kwame. Abaji Kwajo Yampon. Abdul Larba Zura.
Members, please, honorable members, we are taking note. We are taking note of everything. Please, we are watching. You are not the people doing the count. Honorable members, please, the order says, in the case of head count, Mr. Speaker shall take the vote of the House by calling upon members who support or oppose his decision successively to rise in their places. So it's the Speaker who is taking the vote, not the members. I have delegated my authority to the table to do so on my behalf. So you members don't take the vote, I do. So please, keep quiet. Abdullah Bazuera. Please resume your seats. Yes, the lady is at the back there. Move on.
Achampon Brian.
Achampon Brown.
Achampon Charles. Achampon Richard. Kwaku Sophia Karen Adam. Akwa Alexander Akwesi. Adam Hamza Prof. Adam Mohammed Amin Doctor. Adam Kofi Idi Tani Saforo. Yao Ado Frimpong. Eje Akwesi Boatin. Adom Frederick Obi. Adumaku Mensa Alex Doctor. Adumaku Mensa Collins. Adongo Isaac. Adu Johnson Kweku. Adu Chum Yao Osei Doctor. Afenyo Martin Alexander Famina. Afu Eric. Afifa Mensa Akwesi Owusu. Every year Nana you Doctor. Every year Kwaku Doctor. Agaga James. Agbebe Charles. Agboja Kwame Govins. Japon Ken Ohini. Ajari Alexander. Ejekum Emmanuel Kwajo. Ajima Manu Kwaku. Ajima Rollins Zanato. Ejeni Mbwati Kwaku. Ajima Kingsley Talos. Ajima Frederick Yao. Ayi Samson. I have for Bernard. Eddie William Oreku. Akando Kwabena Minta. Akambarba Lydia Lamisi. Achia Samuel Ata. Alazuga Albert Akuka. Alasan Abdullah Idi. Alasan Bashir Husseini Alaji. Alasan Lydia Seiran. Alasan Saibu Suwini. Aliu Muhammad Umar Farouk. Alaute Angelo Furuwa. Amankwa Nicholas. Amankwa Manu Kofi. Amawu John Peter. Ami Altreme Kwesi. Ama Osaibo Nsu. Ama Stephen Doctor. Ama Kwandre Siama. Ama Kwata Kwesi. Ampem Thomas Nyaku. Ampo Futumesi Kwame. Ampratum Sapon Kwaku, Andre Emmanuel J. Any NSCL, any Moses, another Brad Frank, Andrew Eugene Boachi, any Madu Andrew Kwame, Apa Clement Abbas, Doctor, Apia Patricia, Apia Kubi Andy Kwame, Ama Prince Hamidu, Doctor, Asama Vincent Opon, Asante Kwajo, Asante Kwati Kwaku, Asante Kwati Francis, Asiama Isaac Kwame, Asiama Kwabna Amankwa, Asiama J. Nana Amadukua, Asafwa Vincent Ako, Atambo Samuel, Abeji James Uche, Avoka Ewa Ignatius Bafo, Awuni Teresa Ladi, Ayamba Ladi, Ayaga Mama, Aiku Benjamin Atu, Aini Dominic, Doctor, Ocheri, Baba Benson Tongo, Malik Bright Bachi Yalvera, Doctor, Bandim Azuma Abednego, Doctor, Bano Patrick, Mata Osila, Bawa Everett, Bedrai Emmanuel Kosi, Binto Joseph, Blanson Alex, Wachi Henry Yadon, Wachi Yadon Patrick, Doctor, Wati Okasida Akun, Wati Amakoma, Wati Joseph Apia, Bobie Evans Opoku, Bobie Evans Opoku, go to Daniel, Brahma Muhammadu Bawa, Boa Emmanuel Amakofi, Wakari Joseph Dipo, Shana Hamidu Isaac, Shraji Samson Tangubu, Chiwate Andrew Darren, Chiwate Andrew Darren, Prince Abeku, Kujo Comfort Kujo Joseph, Kujo Robert Wisdom, the Fiona Roxin, Dalu Thomas Adam, Kapila Kletu Seidu,
Daku Daniel Ohini. Daku Mensa Kwabna Ochiri. Dauda Collins. Dawini Abukari. Larry Ambrose. Jonogwa Alex Tete. Donko Elvis Morris. Donko Kwabna, Doctor. Duka George Miriku. Iyana Fojo John Ntim, Reverend. Forsin Kessel Atu Ba, Doctor. Frimpon Joseph. Gape Kwame Jujoli. George Samuenati. That's our last and Kobna. That's a Jew. Gilisu wisdom. Gomado Yao. Gomashi Abdullah Jifa. James Emmanuel Kwesi. James Emmanuel Kwesi. John Alexander, John Mensa Richard, Hammond Kobnata Head, Hansen Norte Ives, Haruna Seidu, Fordophilia Mensa, Otoji Alexander Roosevelt, Ibrahim Ahmed, Ibrahim Mutala Muhammad, Ibrahim Zuera Muhammad, Idrisu Habib, Isifu Seidu, Jabbar John Bernard, Jaja Yusuf Isaka, Jalula Stephen Kambi. Yes, I mentioned your name. Idrisu Haruna.
Please, honorable members, sit down. Please.
Jalula Stephen Pambim. Joshua Godfrey Seidu, Doctor. Jinapot John Abdullahi. Jinapot Samuel Abdullahi. Kinney Jeffrey. Kisi Dixon Adumako, Doctor. Kunadu Akwesi. Kumsim Mavis Howard, Kosa Martin Kwaku Ajay Mensa, Kodo Benjamin Komna, Kumbe Beleza Kudu, Kuma John Ampotwa, Kuma Joseph Kwame, Kuyon Solomon, Pachia Kapita Yao, Kwati Kwajima, Kofi Festus Ewa Doctor, J. Mensabus Osei, Chairman Nelson, Labi Oscar Ofori, Lati Agnes Namumu, Iwa Oscar, Mama Asai Sehini, Mama Nasa Turi, Manu Adaba Francis, Mafu Emmanuel Doctor, Mafu Kofi Ahinkra, Bomba Thomas, Mensa Betty Nana Ifwa Crosby, Mensa Francisca Otin, Mensa Isaac Ajay, Mensa Joseph Akwesi, Mensa Tina Gifty Na Ayele, Mercy Andrew Kofi Ejapa, Cynthia Morrison Mamley, Muntaka Muhammad Mubarak, Musa Abdulaziz, Nanja Sanja, Napari Dominic, Nawani Mark, okay. Human Dakwan, Itu Dominic, Nkaza Boadu Mavis, Nokwe Kofi Apple, Nobu Ernest Henry, Nochukoto Peter, Ntim Adelaide, Ntim Augustine Collins, Ntosu Helen Ajua, Nyakote Albert Tete, Doctor, Nyaku Bismarck Tete, Nyaku Kingsley Prof, Nyaku Kwamina Minta Doctor, Obin Techi George Kwabina, Obin Boati Alfred, Okrulinda Obini Wakili, Dante Isaac Ashia, Ofosu Ajari Elizabeth, Okofo Data Williams, Achirajeku Kofi, Obogu Davis Ansan, Opoku Eric, Opoku Isaac Yao Doctor, Opon Kuma Kojo, Osai John Frimpong, Osai Kennedy Nyaku, Osai Asari Abnan, Osewusu Joseph, Oti John Kabna Bless, Oti Christian Colete, Owusubio Benito, Owusu Ekufu Esla, paid to death on the graft. Taku Abdul Rashid Hassan, Doctor. Grandpa Frida Kusua, Doctor. Grandpa Matthew Poku, Doctor. Walter Henry. Quincy James Jachi. Ramadan Muhammad Adamu. Ricketts Hagen George Kweku. Safo Sarah Ajua. Standard Sebastian. Sanil Suleiman Adamu. Suleiman Adamu. Sani John Kwabena Aban Abua. Sani Soya Queensta Mahami Pokua. Sefe Richard Kwame. Sefe Benjamin Ibua, Doctor. Sosu Francis. Sowa Dela Ajua. Sowa Rita Na Odole. Upar Adams Muhammad. Suleiman Adam. Suleiman Alhassan Tampul. Suleiman Yusuf. Suma Anthony. Tahiru Abdul Razak. Tevia Augustine, Doctor. Tevia Augustine. Tevia Augustine. Tel Aviv Uklete. Tata Joyce. Tata Sylvester. Tata Abu Buzela. Tata Joseph Akwete. Tofi Dorcas. Obi Peter Lanseni. Tufari Muhammad Hadi. Chuma Pafu Gifty. Chumba Emma Poa Kweku. Yusuf Mustafa. Vanderpool Alfred Okowo. Vanderpool Ebony Lante. Gondi David. Opal Daniel Insala. Weku Brobe Bright. Where me Kwabena Mensa. Where me Kwabena Mensa. Ziedim Beat and 1,000 more.
Honourable members, declaration of the results. Ayes 137, noes 134. The ayes have it. Honorable members, you are all leaders. You are all leaders. A little bit of discipline will make our work easy.
Mr. Speaker, with respect, Mr. Speaker, shall we proceed? Shall we proceed and take item 40?
Please resume your seats. Honourable members, please. I have presided over this house all this time. I will never disappoint myself. It doesn't necessarily mean that if a member is present, the member is obliged to vote. I heard you talking about everybody is present. The rule, please. You will come and preside and take your decisions. every day, how many of you are here when we take decisions? How many? But we take the decisions because of the national interest. It's the same national interest I'm protecting. If you even read our standing orders, Order 1135, it's clear there. A member is not obliged to vote. So a member can be... Honorable Howard Yakubu. Kumsing. Honorable Howard Kumsing. Please, will you sit down? Please. Sit down. All members, those who either showed their hands or stood up were counted. They were counted, and I personally was observing if those who watched me. I kept on moving to see. I am taking the vote, not you. Well, keep on. You want to nullify, we can nullify and start all over. I have no problem. If you are challenging the head count, do so. Then we'll take the vote again. I have no problem. Challenge the head count, we'll take the vote again. Honourable members, the ayes have it. The motion is carried.
An act to amend the Value Added Tax Act 2013 at 870 to provide for a flat rate of tax on the rental of commercial premises other than commercial rental establishments, to provide for a flat rate of tax on the supply of property by an estate developer, to extend the zero tax rate for locally manufactured textiles and locally manufactured vehicles, to introduce a zero tax rate for locally manufactured sanitary towels, to waive the tax on electric vehicle transportation, to review the exemptions for specified goods and services, and provide for related matters.
Honourable members, the Value Added Tax Amendment Bill 2023 is deemed to have been read a second time. We now move to item 43. Motion. Minister for Finance. Yes, Majority Chief Whip.
Speaker, may I seek your leave?
No, kindly proceed. Proceed.
Okay.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the motion captured as item 43 on today's order paper be taken now. I so move, Mr. Speaker.
Any seconder?
Speaker, I second the motion.
Motion moved and seconded is for the consideration of the House. Being a procedural motion, I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. We move to item 44. Value Added Tax Amendment Bill 2023 at the consideration stage. Honorable members, clause 1.
Section 3 of Act 870 amended.
No amendment has been proposed on this clause. Clause 2.
Section 47 of Act 870 amended.
Clause 3.
Section 48 of Act 870 amended.
Clause 4.
First schedule to Act 870 amended.
Clause 5.
Second schedule to Act 870 amended.
Is that clause 5? Yes, Honorable Member.
I propose in
the amendment you are proposing is to clause 5.
Yes, Mr. Speaker.
Okay, let me put the question on the other clauses before we take your proposed amendment. Honorable members, the question is that clauses 1, 2, 3, and 4 of the bill. Those in favor of the clauses being part of the bill say aye. Those against say no. The ayes have it. Honorable members, clauses 1, 2, 3, and 4 of the Value Added Tax Amendment Bill 2023 are ordered to stand part of the bill. Clause 5. Yes, please.
The majority leader is saying there's no clause 5. I encourage you to read the report. Mr. Speaker, the schedule.
Honorable leaders, please, you have to assist the Speaker to maintain the order in the House. But you are always leading the disorder.
I'm just going to make a proposal to the schedule.
Please, leaders. Yes, Majority Leader.
Mr. Speaker, I'm sitting in my somewhere. I've not spoken.
What do you mean by you are sitting here somewhere?
As you have been telling me, Mr. Speaker. He makes an attribution to me that I've said that there's no clause 5. When I have not spoken. Lying about me. Mr. Speaker, that is what I was drawing his attention to. I have not spoken. If he wants any amendment, let him so proffer.
Honorable members, the rule is that Once a member has not spoken into the mic, he has not spoken. Don't refer to people whispering in your contributions. Please, that's not part of the official report. Honorable Member, you may now move your proposed amendment. Minority Chief Whip.
Mr. Speaker, clause 5, delete the entire amendment proposed. Delete the entire clause 5.
Honorable Member, give us reasons for your proposed amendment.
Because we are opposed to that we are opposed to that clause, we want it complete from the bill, Mr. Speaker. So I propose delete clause 5 from the bill. Only clause 5.
I just want you to convince people to support you. Why are you asking that clause?
Mr. Speaker, I have every support from our side. I don't need any support from. So, Mr. Speaker, once again, I propose, amendment proposed, delete clause 5.
Honorable members. Yes. Any seconder?
I rise to second the proposed amendment ably moved by the Chief Whip. Indeed, Mr. Speaker, no clause 5. The clause 5, as stated in the bill, is not only inimical, but it is dangerous. And destructive. On that note, Mr. Speaker, clause 5 is not good at all.
Honorable members, there is no proposed amendment to clause 5. Honorable Haruna Idrisu, you are proposing an amendment.
Yes, Mr. Speaker.
Yes, please.
Mr. Speaker, clause 5B, the sponsors of the bill must relook at that. If you read 5B, it reads, Mr. Speaker, with your indulgence. So, with your leave, a supply of locally assembled vehicles under the Ghana Automotive Development Program, Mr. Speaker, the emphasis now is mine, from 1st September 2022 to 31st December 2025, offends the principle of retroactivity. You can't say that as at 1st September, when you had your automotive policy, there was no legislation. Our constitution in Article 107 frowns upon retroactive legislation. So you can amend it by just changing the date. Don't emphasize 1st September 2022, because at the time, Mr. Speaker, the law cannot work in a reverse gear. What they are seeking to do is to let the law work back in September 2022.
Mr. Speaker, may I quote? So it can stay, but the date, Article 107B, Parliament shall have no power. Parliament shall have no power to pass any law. This is the VAT amendment law we are going to pass, which imposes retroactively to impose. This is retroactive. You can't walk back. When you chose to read South African law, Mr. Speaker, when you chose to read South African law, did you read all? Mr. Speaker, I'm not against. I'm just saying the date, not the principle. You see, if you were smart, you should have just said assemble vehicles under Ghana Automotive Development Program, then be silent on 1st September 2022 and leave it at 31st. But with this in this law, Mr. Speaker, strongly, it offends Article 107 of the Constitution. It will be played retroactively. We are going to say that as of September 2022, there was no law. The law cannot walk back. If there was, then you are seeking an amendment to it. Say so. And quote which law existed. Quote it and give us the act number. Other than that, Mr. Speaker, I maintain strongly that the principle of retroactivity is a very important principle of constitutional law. Other than that, Mr. Speaker, if in a society incest was permissible, then once upon a time you go and pass a law and say that 10 years back incest was unlawful. Where is it going to take effect from? So mine is the date. You can leave it, but just delete the words 1st September 2022. Then it can stand, Mr. Speaker. I so submit. Thank you.
Any seconder to the proposed amendment? Yes, Minority Chief Whip.
Mr. Speaker, I second the proposal for amendment.
Honourable members, the proposed amendment is for the consideration of the House. Yes, Chairman, Finance Committee.
Yeah, thank you, Mr. Speaker. Mr. Speaker, the amendment as proposed by my colleague and seconded is actually unnecessary. Unnecessary because there is an existing provision that creates, it's a relief to start with. It creates this relief up to the close of this year. So what this amendment is looking to do is to extend it up to 2025. So there is no retroactivity. The existing legislation caters for that part of the period that would have made this retroactive. So, Mr. Speaker, this amendment is the current VAT Act. The current VAT Act.
I don't have my VAC here.
I should do what?
Leader says you shouldn't respond to Kasia Mary.
Yes, Honourable K.T. Hammond.
Mr. Speaker, I think we need to put into perspective and let's get it right. Our colleague, the former deputy, the former leader of the minority, Mr. Speaker, waxed lyrical about the retrospectivity of Article 107. Mr. Speaker, he is wrong about that. Mr. Speaker, look at the wording, degradation of Article 107. The retrospectivity of Article 107 is completely limited and constrained. It is constrained to the extent that you are imposing a liability, you are imposing
let's get to what is there, which operates, Mr. Speaker, retrospectively, and then he goes on to impose limitations adversely affecting the personal rights, the liberty of any person, or to impose a burden, obligation, Mr. Speaker, or liability on any person. Mr. Speaker, that is not what is happening here. It's actually granting a relief. It's granting a relief. It's giving a zero sum. That is not imposition of any liability, not on anybody's liability, anybody's right. We keep on talking about the prospectivity of Article 107 without looking at the actual wording of 107. It doesn't apply in this context, Mr. Speaker. It's wrong, Mr. Speaker. Thank you, Mr. Speaker.
Yes, Honorable Dafiamapo.
Mr. Speaker, thank you for the opportunity. Mr. Speaker, legislations give rise to rights, and the point being made by the Honorable Haruna Idrisu is that you are urging this House to enact this bill into a law that will give rise to a right which did not exist at the date you are indicating in the bill. So please. So if you insist that there is a legislation in existence, the practice of this House is that you subject the current provision to that, to bring clarity to it. Not doing so will suggest that there is no law in place. So once there's a law in place, in order to cure this mischief, you have to reference the current provision as it is in the bill to the existing law. Humbly submitted, Mr. Speaker.
Yes, please. Are you no longer going to contribute?
Yes, Mr. Speaker. Mr. Speaker, I wanted to buttress the point earlier on espoused by Honorable K.T. Hammond. Mr. Speaker, the Constitution in Article 107 specifically places the retrospectivity of the law on liability, and to the extent that it affects the personal rights of a person. Mr. Speaker, with your permission, I would like to quote, "Parliament shall have no power to pass any law, B, which operates retrospectively to impose any limitations or to adversely affect the personal rights, obligation or liability on any person, except in the case of law enacted under Articles 178 and 182. And 178 relates to the Consolidated Fund and other matters. So, Mr. Speaker, the law that is currently being amended, to the extent that it does not operate retrospectively to affect the personal liability of any person, Mr. Speaker, the principle of retrospectivity cannot be. And so I strongly believe that the amendment that is being proposed by the former leader, Honorable Haruna Idrisu, should be withdrawn so that we can move on with the business of the House. I thank you, Mr. Speaker.
Mr. Speaker, they sound a better argument, but mine is just the difficulty of the word September. I wish I get a superior argument on 107. You are saying that it is not conferring a liability, but conferring a benefit. But must you necessarily put in this legislation that you want to start from 1st September 2022? I would have thought that it is still neater to do away with 1st September 2022 and just leave it to 31st December 2025. But I withdraw it, Mr. Speaker. Thank you.
Honorable members, please read the clause again. It says, the principal enactment is amended in second schedule by B, the substitution. So the old law is being substituted with this clause. And so I don't think there's anything wrong with doing that. It's just replacing it. And so starting from 1st September 2022 is not a wrong thing to do. It's just a substitution. So if you insist, I'll put the question. But if you withdraw, then you do the proper thing.
Amendment withdrawn, Mr. Speaker.
Thank you so much. Honorable members, I now put the question on clause 5. Those in favor of clause 5, standing part of the bill, say aye. Aye. Those against, say no. The ayes have it. Honorable members, clause 5 is ordered to stand part of the bill. We now will take the long title.
An Act to amend the Value Added Tax Act 2013 Act 870 to provide for a flat rate of tax on the rental of commercial premises other than commercial rental establishments, to provide for a flat rate of tax on the supply of immovable property by an estate developer, to extend the zero tax rate for locally manufactured textiles and locally manufactured vehicles, to introduce a zero tax rate for locally manufactured sanitary towels, to waive the tax on electric vehicles for public transportation, to review the exemptions for specified goods and services, and provide for related matters.
Honorable members, those in favor of the long title standing part of the bill, say aye. Aye. Those against, say no. The ayes have it. The long title is ordered to stand part of the bill. Honorable members, this brings us to the end of the consideration stage of the Value Added Tax Amendment Bill 2023. May we now take item 45, motion, Minister for Finance.
Mr. Speaker, I beg to move that the motion captured as item 45 be moved today. Thank you, Mr. Speaker.
Any seconder?
Mr. Speaker, I second the motion.
Motion moved and seconded is for the consideration of the House. Being a procedural motion, I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. We go to item 46. Motion, Minister for Finance.
Mr. Speaker, I beg to move that the Value Added Tax Amendment Bill 2023 be now read the third time. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Honorable members, the motion has been moved. It's for the consideration of the House. There being no further consideration, I put the question. And the question is that the Value Added Tax Amendment Bill 2023 be now read the third time. Those in favor say aye. Aye. Those against say no. The ayes have it.
An act to amend the Value Added Tax Act 2013, Act 870, to provide for a flat rate of tax on the rental of commercial premises other than commercial rental establishment, to provide for a flat rate of tax on the supply of immovable property by an estate developer, to extend the zero tax rate for locally manufactured textiles and locally manufactured vehicles, to introduce a zero tax rate for locally manufactured sanitary towels, to waive the tax on electric vehicles for public transportation, to review the exemptions for specified goods and services, and provide for related matters.
Honorable members, the Value Added Tax Amendment Bill 2023 is deemed to have been read the third time and passed. Yes, Majority Chief Whip.
Speaker, may we now proceed to page 21 and take item 47. Item 47 on page 21.
Honorable members, item 47 at page 21 of the order paper. Motion, Minister for Finance.
Mr. Speaker, I beg motion captured as item 47 on today's order paper be moved now. Thank you, Mr. Speaker.
Any seconder?
Mr. Speaker, I second the motion.
Motion moved and seconded for the consideration of the House. It's also a procedural motion, so I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. We move to item 48. Motion, Minister for Finance.
Mr. Speaker, I beg to move that the Excise Duty Amendment Number 2 Bill 2023 be now read a second time. I so move, Mr. Speaker.
Thank you, Mr. Speaker. I rise to speak to the motion and in the process present the committee's report. The object of the Excise Duty Amendment Number 2 Bill 2023 is to amend the Excise Duty Act 2025 Act 878 to increase excise duty rate on 2015, Speaker. The object of the bill is to amend the Excise Duty Act 2015 Act 878 to increase the excise duty rate on cider beer to align with the excise duty rate on beer, reduce the excise duty on plastics, and to expand the coverage of the excise duty on plastics to cover imported plastic packaging. Mr. Speaker, the impact is some 540 million US Ghana cedis. I hand the department to capture the entire content of the report once I take the recommendation. Mr. Speaker, the committee the committee recommends to this House to pass this into law. But, Mr. Speaker, before I submit this report, it's important to indicate that the minority took a position against this, and therefore it is by a majority decision. Respectfully submitted, Mr. Speaker.
Honorable members, motion moved and seconded is for the consideration of the House.
Mr. Speaker, the original bill that was submitted to this House, the Excise Duty Amendment Bill, included the emission tax Mr. Speaker, at the time that the committee considered the bill, the emission levy was embedded in the excise duty amendment bill. For that reason, the minority took a decision that we will not support the emission tax or emission levy. Mr. Speaker, subsequently, the Ministry of Finance presented a separate bill on the emission levy. And so the Finance Committee sat and considered the emission levy. And our position was made clear that we do not support the emission levy. So, Mr. Speaker, the bill before us excludes the emission levy. On that basis, the emission levy. On that basis, because, Mr. Speaker, we have the emission levy as a separate bill that we are going to consider. So, on that basis, Mr. Speaker, we have no issue on this. But our issue relates to the emission levy bill 2023. Thank you, Mr. Speaker.
Honorable members, there being no further consideration, I put the question. Those in favor of the motion number 48 at page 21 of the order paper, say aye. Those against, say no. Honorable members, the ayes have it.
An act to amend the Excise Duty Act 2015, Act 878, to increase the excise duty rate on cider beer to align with the excise duty rate on beer, reduce the excise duty on plastics, and expand the coverage of the excise duty on plastics to cover imported plastic packaging, introduce an emission tax on carbon dioxide by companies and from vehicles, and for related matters.
Honorable members, the Excise Duty Amendment number 2 Bill 2023 is deemed read a second time. May we now take item 49.
Mr. Speaker, I beg to move that the motion captured as item 49 on today's order paper be moved now. I so move, Mr. Speaker.
Yes, second
the motion.
Procedural motion moved and seconded is for the consideration of the House. I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is accordingly adopted. May we now take item 50. Item 50, Excise Duty Amendment number 2 Bill 2023 at the consideration stage. Honorable members, the bill is only amending the first schedule. Those in favor? Yes, please.
Mr. Speaker, we came to an agreement with the
sponsoring ministry that there ought to be, as the minority leader indicated, there ought to be a separate bill for these two lines. Accordingly, the committee has amendments to delete those two lines and also to consequentially amend the long title. We will seek your leave, Mr. Speaker, to do so.
Which two lines are you referring to?
Number 10 and then number 11. So number 10, delete. Number 11, line 10, delete. That is industrial emissions, delete. And then line 11, internal combustion engine vehicles, delete.
Honorable members, we have proposed amendment to the schedule. Number 10, which is referred to as line 10, and 11, delete. Those of the deletion, say aye. Those against, say no. Honorable members, the ayes have it. I put the question on the entire first schedule. And the question is that the first schedule as amended stands part of the bill. Those in favor say aye. Those against say no. Honorable members, the ayes have it. The first schedule is accordingly ordered to stand part of the bill. Now, the long title.
An Act to amend the Excise Duty Act 2015 Act 878 to increase the excise duty rates on cider beer to align with the excise duty rate on beer, reduce the excise duty on plastics, and expand the coverage of the excise duty on plastics to cover imported plastic packaging. Introduce an emission tax on carbon dioxide emissions by companies and from vehicles, and for related matters.
Honorable members, any proposed amendment to the long title? Yes, Chairman.
Yeah, Mr. Speaker, as I earlier indicated, the committee consequentially proposes an amendment to this long title as follows. Delete, introduce an emission tax, lines 4 and 5. Lines 4 and 5, delete, introduce an emission tax on carbon dioxide emissions by companies and from vehicles. Mr. Speaker, if you permit me, I'll therefore read what the new rendition is. An Act to amend the Excise Duty Act 2015 Act 878 to increase the excise duty rate on cider beer to align with the excise duty rate on beer, reduce the excise duty on plastics, and expand the coverage of the excise duty on plastics to cover imported plastic packaging and for related matters. That's the amendment, Mr. Speaker.
Honorable members, the amendment has been moved is for the consideration of the House. Yes, please.
Mr. Speaker, I rise to seek your guidance. The order paper before us is yesterday's order paper, and the date reflects yesterday. I seek your guidance whether we can amend the date to reflect today. Thank you, Mr. Speaker.
Honorable Member Yakumada, we are dealing with a clause in the bill now. Honorable members, those in favor of the proposed amendment? Yes, Majority Leader.
Mr. Speaker, I think it's a small amendment, which I guess we can leave with the drafters, because it doesn't mean that we should also delete the comma after the packaging. The comma after the packaging. But we can leave that to the drafters.
I haven't heard anything at all.
The Speaker, the chairman sought to delete the words introduce an emission tax on carbon dioxide emissions by companies and from vehicles. Now he took that after the word packaging with the comma. And I'm saying that there shouldn't then be any comma there, so that it will just link up. There will be a contract, packaging and for related matters.
Honourable members, the majority leader is just fine-tuning the proposed amendment. So it's not ending at packaging, but it continues to the and for related matters. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. I put the question on the long title, and the question is that the long title stands part of the bill. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The long title is ordered to stand part of the bill. Honourable members, we have come to the end of the consideration stage of the excise duty amendment number 2 bill 2023. May we now take item 51?
Speaker, yes, so.
Item 51, motion, Minister for Finance.
Mr. Speaker, I beg to move that the motion captured as item 51 on today's order paper, be moved now. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Procedural motion moved and seconded is for the consideration of the House. I put the question. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The motion is carried. We move to item 52. Motion, Minister for Finance.
Mr. Speaker, I beg to move that the excise duty amendment number 2 bill 2023 be now read the third time. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Motion moved and seconded is for the consideration of the House. Honourable members, there being no consideration, I put the question. Those in favor of the excise duty amendment number 2 bill being read the third time, say aye. Those against, say no. The ayes have it.
An act to amend the Excise Duty Act 2015, Act 878, to increase the excise duty on cider beer to align with the excise duty on beer. Reduce the excise duty on plastics and expand the coverage of the excise duty on plastics to cover imported plastic packaging and for related matters.
Honourable members, the excise duty amendment number 2 bill 20 is deemed to have been read the third time and passed. Yes, please.
Speaker, same page 22, item 53.
Item 5.3.
Mr. Speaker, before I move motion number 53, I seek your leave and the leave of the House to correct an error on the other paper. The excise stamp should read stamp duty.
It should read excise.
No, the excise stamp should read stamp duty and not excise stamp.
So we delete excise.
Yes. Excise stamp. Delete excise stamp and replace with stamp duty.
So it now reads Stamp Duty Bill 2023.
Stamp Duty Amendment Bill 2023.
Honourable members, it now reads Stamp Duty Amendment Bill 2023.
Mr. Speaker, by this amendment, we want to also do a consequential amendment for motion 54 to 58. Wherever we have excise stamp, it should be deleted and replaced with stamp duty. Stamp Duty Amendment Bill 2023.
Yes, you may go on.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the motion captured as item 2 days order paper be moved now. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Motion moved and seconded is for the consideration of the House. Procedural motion, I put the question. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The motion is carried. We move to item 5.4.
Mr. Speaker, I beg to move that the Stamp Duty Amendment Bill 2023 be now read a second time. I so move, Mr. Speaker.
Yes, any seconder.
Thank you, Mr. Speaker. I rise to speak to the motion and in the process present the committee's report. Mr. Speaker, the object of the bill is to amend the Stamp Duty Act 2005 Act 689 to review the rates of stamp duty on specified instruments, submit Thank you, Mr. Speaker. The object of the bill is to amend the Stamp Duty Act 2005 Act 689 to review the rates of stamp duty on specified instruments. Mr. Speaker, I request the Hansard Department to capture the entire content whilst I take the conclusion. Mr. Speaker, it was by majority decision and it's a recommendation to this House to pass this bill into law. Respectfully submitted, Mr. Speaker.
Honourable members, the motion on the Stamp Duty Amendment Bill 2023 has been moved. It's for the consideration of the House. Let me listen to the Honourable Member for Bole.
Mr. Speaker, I'm grateful for the opportunity to contribute to the report submitted by the Chairman of the Finance Committee. The Chairman, my first observation is that paragraph 1(1) that has to do with agency of the bill is inconsistent with the position of the minority as captured under paragraph 6(3). Mr. Speaker, under paragraph 1, and with your permission I read, it says that the committee determined and hereby satisfies that the bill is of an urgent nature. This is not consistent with the position of the minority. The minority do not agree with the whole bill, not to talk of accepting it under a certificate of urgency. And so there's the need for this to be corrected. The second issue, Mr. Speaker, is that we are told that this is to revise the stamp duty. The question I ask is, what are the current rates? There is no any schedule attached to this, so that we know the current rates and now decide that this is where we are taking it. And so we are not certain as to what we are approving. So why should we approve something that we do not do? And so, Mr. Speaker, I think that the report is incomplete, and so we cannot approve it. Mr. Speaker, we are also told that the impact of the revision is going to give us an amount of 653 million Ghana cedis. Mr. Speaker, what they are failing in telling us is the impact of this on businesses. Yes. They are failing in telling us the impact of this on the businesses that we have in this country. A negative impact. Definitely, it is going to be a negative impact. And I'm not the one saying it. Mr. Speaker, AGI in their reports have consistently complained about high rates of taxes. They have complained about multiplicity of taxes. And I thought that as a government that have promised this people, the people of Ghana, an economy that is going to be based on production, will not turn up imposing such draconian taxes on the people. Killing the business. Mr. Speaker, clearly we have all realized that businesses in this country are collapsing. And this is a fact. Mr. Speaker, what I think my colleague on the other side to know is that nobody is against revenue mobilization through taxation. What we are against is the lack of skill to balance the effect of revenue mobilization on the impact of it on our businesses. And this is where the problem is. I thought that you will take into consideration basic principles of taxation as espoused by Adam in 1777. The Speaker, he says that for you to be able to tax and run an effective tax administration, you must take into consideration what we call equity. Equity is lacking in the way we impose taxes on our people. Again, he spoke about certainty. We are talking about imposing tax on our people when they don't know how much they are going to pay. Like I have just asked, what is the rate? What is the current rate? And what is the rate that we are moving into? We don't know. So these are the basic things that when we are imposing tax on our people, we should take into consideration. Mr. Speaker, with these few words, I want to call on this side to reject this tax, and that they should go and come another time. Thank you, Mr. Speaker.
Yes, Minority Chief Whip.
Mr. Speaker, I thank you for the opportunity to make few comments about this bill. Mr. Speaker, stamp duty is a common kind of tax under many jurisdictions, and is attached to mainly land transactions. And yes, many countries see it as a way of raising revenue when land transactions are done. But Mr. Speaker, in jurisdictions where stamp duty tax works, the land transaction itself is structured. For instance, in those jurisdictions, you cannot do land transaction without a conveyancer. So I cannot just sell my house to you, Mr. Speaker. It is not possible. You need a conveyancer. So, in fact, you cannot even pay directly. You pay the money to the conveyancer to transfer the money to somewhere before so it is well structured. Once again, we see a government desperate to raise revenue, just copy something from somewhere and projecting they are going to make some money. We were here, Mr. Speaker, when all of them told us e-levy will raise 7 billion Ghana cedi. How much have you been raising? When we told them that it doesn't add up because you are just making based on a certain number of transactions which are not even traceable. Once again, you are talking about stamp duty to raise 650 million Ghana cedi. If you ask them, does the minister actually have a record of how many land transactions take place in a year? You don't, because people are selling houses to each other from bags. People carry money in their bag to buy and then give the key to the guy. That is what they are doing. So what you should be curing first is to structure landed property transaction. You haven't done that. And you are projecting that. So today, if my grandfather left a house, which my grandmother lives in, I want to now borrow money on that house to look after my grandmother. You are saying that I should go first and do stamp the document for that house, which I haven't even seen yet, before I can go take that to a financial institution to borrow money. Mr. Chairman, I know we are doing budget, so you are in a hurry. This report is less than skeleton. You talk about things, I mean, the rates, nothing in this report guides any colleague to make any informed decision about. You understand? Look, where the rates, at least say something about the rate. I know you are not supposed to put the schedule in. You didn't say anything about it. So the thing, like you say, it's so scanty that it's for who? Who? You know, you unless you deliberately made a report like this so that colleagues will not understand what you are saying. You know, so Mr. Speaker, for instance, paragraph 4, he said the object of the bill is to amend the Stamp Duty Act 2005 and to review the rates. You didn't even have to give us any inclination about what you are trying to do. So, Mr. Speaker, whilst I agree that stamp duty can be a good source of raising revenue, my point is that our country's systems of landed property transaction is not just structured. So it is unpredictable as to what you can measure in terms of what you can get, because people are doing landed transaction without any record. So be guided that your projection is like the e-levy projection. So once again, you haven't provided anything that shows that you are just trying to please IMF. That, oh yes, we went to Parliament at 1 a.m. We went yesterday, we closed today, 1 a.m. we passed something. Give us our $650 million. That's what we are trying to do. Once again, you fail on this one as well, because the record is not there. Otherwise, show me the. Oh no, we told you so. E-levy, you didn't listen. You know, if e-levy worked, we shouldn't be adding another tax. Mr. Speaker, you see, this is exactly the attitude they put up during the e-levy. And you said e-levy, where's the road minister? E-levy, because of e-levy, you cancel the road toll. You told us that e-levy will make sure that all our roads will be fixed, all our schools will be fixed, all our hospitals will be fixed. In fact, as I sit here now, the government haven't even paid me my salary. You couldn't find money to pay salary. Once again, you are bringing something, and I'm telling you that this projection is not founded on any data. It's on top of your head. It's on top of your head. That is why it is not realistic. You can decide to take it or say, Kwame Agoja, I mean, whatever. But mark it. Your projection is not founded on anything. I wish the data was there so that we can accurately, at least, be around the ballpark of that figure. But as of now, there's nothing around. Mr. Speaker, indeed, because of this, I can't support it. Thank you very much, Mr. Speaker.
Honourable members, any further contribution? Honourable members, I put the question. Those in favour of motion number 54 at page 23 of the order paper say aye. Those against say no. The ayes have it. The motion is carried.
An act to amend the Stamp Duty Act 2005 at 689 to provide for an increase in the rates of stamp duties and for related matters.
Honourable members, the Stamp Duty Amendment Bill 2023 is deemed to have been read a second time. Item 55, motion, Minister for Finance.
Mr. Speaker, I beg to move that the motion captured as item 55. Mr. Speaker, I beg to move that the motion captured as item 55 be taken now. I so move, Mr. Speaker.
Any seconder?
Mr. Speaker, I second the motion.
Motion moved and seconded. It's a procedural motion. I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. We now move to item 56, which is the Stamp Duty Amendment Bill 2023 at the consideration stage. Honourable members, the bill is only one clause. It's meant to amend the first schedule to Act 689. So I put the question on the clause.
First schedule to Act 689 amended.
There be no proposed amendment to the clause. I put the question. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The amendment is carried. Sorry. The ayes have it. The motion is carried. I now put the question on the clause. And the question is that the clause stands part of the bill. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The clause is ordered to stand part of the bill. We now move to the long title of the bill.
An Act to amend the Stamp Duty Act 2005 Act 689 to provide for an increase in the rates of stamp duties and for related matters.
Honourable members, there being no proposed amendment to a long title, I put the question. Those in favour of the long title standing part of the bill, say aye. Aye. Those against, say no. The ayes have it. Honourable members, I now put the question on the whole long title, and the question is that the long title stands part of the bill. Those in favour say aye. Those against say no. The ayes have it. The long title is ordered to stand part of the bill. Honourable members, we have come to the end of the consideration stage of the Stamp Duty Amendment Bill 2023. We now move to item 5.7. Motion, Minister for Finance.
Mr. Speaker, I beg to move that the motion captured as item 57 on today's order paper be moved now. I so move, Mr. Speaker.
So Speaker, second the motion.
Procedural motion moved and seconded for the consideration of the House. I put the question. Those in favour say aye. Those against say no. The ayes have it. Honourable members, we move to item 5.8. Motion, Minister for Finance.
Mr. Speaker, I beg to move that the Stamp Duties Amendment Bill 2023 be now read a third time. I so move, Mr. Speaker.
Yes.
I second the motion.
Motion that the SI Stamp Amendment Bill 2023 be now read the third time. Moved and seconded for the consideration of the House. There be no consideration, I put the question. Those in charge of the motion say aye. Those against say no. The ayes have it.
An act to amend the Stamp Duty Act 2005 Act 689 to provide for an increase in the rates of stamp duties and for related matters.
Honourable members, the Stamp Duty Amendment Bill 2023 is deemed to have been read the third time and passed. Honourable members, first Deputy Speaker to take the chair. We can be taking item 5.9. Item 5.9.
Mr. Speaker, I beg to move that the motion captured as item 59 on today's order paper be moved now. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Motion moved and seconded for the consideration of the House. Yes, please.
Mr. Speaker, I rise to seek your guidance as a former Minister of Health. Mr. Speaker, we've been sitting for so long, and on health and safety grounds, I seek your guidance whether we should not be allowed to stretch our legs for a while in order to protect our health. I seek your guidance, Mr. Speaker.
For guidance on health, I'm not a health expert. I can't guide you on that matter. If it has to deal with rules of the House, I'll be able to guide you. But on health, I don't qualify to guide you on health matters. Yes.
Mr. Speaker, what he is trying to say is that we do have colleagues, a few of them who have been visiting the clinic currently because of the unnecessary lengthy sitting we've been having since yesterday. Because, Mr. Speaker, you notice last week we've been coming here with the majority side not getting us business to do. And now they are stretching us, Mr. Speaker, as a matter of fact, what we are doing here, we could have done in a better way. It doesn't add any value to anything when we work for what? 24 hours continuously. For no reason. The country is not at peril. What are we doing here, Mr. Speaker? I was going to think that my colleague will go as far as saying that we can adjourn, Mr. Speaker. We can adjourn. Ghana is not, the economy is already collapsed. If we do the budget next, in January, it won't change anything. So, Mr. Speaker, as for the health, the thing, we are in your hands. In fact, because we are in the chair, we are here. So,
are you sure you are in my hands?
Yes, Mr. Speaker. Mr. Speaker, if you adjourn us now, we'll go home. We are only here because you are here. So we are in your hands.
I know that in the morning when we had the pre-sitting meeting, the understanding was that we will not take the tax bills. When you later discussed and agreed to take the tax bills, you proceeded. That time I was having not a health break. I was having a short rest. And so I came in to continue what the second deputy speaker had commenced. And so once we started, let's proceed and complete. So first deputy speaker, please take the chair.
Yes, Honorable Deputy Leader.
Right, Honorable Speaker, just for the record, we on this side have never agreed to take the tax bill. In fact, we find it very unnecessary. So for the record, yes, the majority side really have insisted they wanted to take the tax bill. But we on this side have never agreed to take the bill. For the record, please.
Item 59, procedural motion.
So that 59 was moved.
The motion has been taken already. Very well. Other members have put a question. All in favor of adopting the procedural motion, say aye. All against, say no. The ayes have it. The motion is carried. Item 60. Motion by the Minister for Finance. Yes.
Mr. Speaker, I beg to move that the Exemptions Amendment Bill 2023 be now read the second time. I so move, Mr. Speaker.
Yes, any secondment.
Mr. Speaker, I second the motion.
Are you presenting the report after seconding it?
Conclusion.
Thank you, Mr. Speaker. I rise to speak to the motion and in the process present the committee's report. The object of the bill is to provide a waiver of customs duties and custom taxes in respect of the importation of fishing gear and agricultural inputs originally. Mr. Speaker, there are amendments which we would propose when we come to the consideration stage. I urge the Hazard Department to capture the entire content once I take the conclusion. Mr. Speaker, the conclusion of your committee is that we should pass this bill into law. Respectfully submitted, Mr. Speaker.
Yes, Honourable Ranking Member.
Mr. Speaker, the amendment to the exemption bill essentially is to cater for exemption to be provided for fishing gear and agricultural inputs, but particularly with emphasis on the planting for food and jobs and its related equipment. Mr. Speaker, we think that this will boost agriculture and we have no objection to this. Thank you very much, Mr. Speaker.
Honourable members, all in favour of the House adopting the motion, say aye. All against, say no. The ayes have it, the motion is carried.
An act to amend the Exemptions Act 2022 at 1083 to provide a waiver of customs duties and customs taxes in respect of the importation of fishing gear, seeds and fertilizer for the Planting for Food and Jobs Program Phase 2 for agricultural purposes and for related matters.
Honourable members, the Exemptions Amendment Bill is now read the second time. Item 62, the Exemptions Amendment Bill, no, 61 first, sorry, the procedural motion, yes.
Mr. Speaker, I beg to move that the item 61 be taken today. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
All in favour of the House adopting the motion, say aye. All against, say no. The ayes have it, the motion is carried. Item 62, Exemptions Amendment Bill 2023 at the consideration stage. Yes, clause 1.
Head notes before section 17 amended.
Amendment proposed, yes.
Clause 1, Mr. Speaker, amendment proposed. Line 3, delete equipment, fishing gear, seeds and fertilizer and insert equipment for trial and fishing gear. I so move.
All in favour of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now, I'll put the question on clause 1 as amended. The question is clause 1 as amended shall stand part of the bill. All in favour, say aye. All against, say no. The ayes have it. Clause 1 as amended in order to stand part of the bill. Clause 2.
Section 19A inserted.
Amendment proposed. Chairman.
Amendment proposed, section 19A, opening phrase and paragraph A, delete and insert the following. 19A, fishing gear that are imported for agricultural purposes, and A, certified by the minister responsible for fisheries and aquaculture development, and I so move, Mr. Speaker.
Yes, Honourable Minister for Energy.
Mr. Speaker,
the chairman of the Finance Committee should explain fishing gear for agriculture. If it's fishing gear, it should be fishing gear. What is fishing gear for agriculture? And then you are creating a situation where someone will have to go to a minister to get the permission and say because it's coming to use it for agriculture. And that, I don't think it's right. If it's fishing gear, say fishing gear.
Yes, Honorable Chairman, is there a difference between...
Mr. Speaker, this matter came up at the committee deliberations, and the sponsoring ministry explained that it is not the intention to provide exemptions to cover all fishing gear, and that it was specifically for a particular program, and that the Minister for Agriculture would have to look at the circumstances of the import and determine whether you qualify, and then the Minister for Finance would also confirm this from this exemption. So there's a clear attempt to restrict it to that particular program. Speaker.
Yes, Honorable.
Mr. Speaker, we fish sometimes for agricultural purposes. Mr. Speaker, sometimes we fish for leisure. Some fish as a form of hobby. The exemption they are asking us to approve is for agricultural purposes. And so if you are to fish for hobby or any form of fishing that is not agriculture related, we are not granting the exemption. That's it. And that is the intent. So you can't grant exemptions across all forms of fishing, the gear that you will be using. So we are restricting it to fishing for agriculture.
Very well, I'll put a question. Yes.
Mr. Speaker, there's even a minister for fisheries. There's a minister for fisheries and aquaculture. Why aren't we going to the minister and going to the Minister of Agri? And again, Mr. Speaker, you are creating an incentive where those who have large trolleys, fishing trolleys, 40-meter fishing trolleys, we are going to say that we are exempting them. And then artisanal fishers, they are killing the artisanal fishers. So let us be careful of what we are. If it's for canoe fishermen or it is for artisanal fishermen, let us say so. Because I don't think we should support a system where the trolleys that are coming from China and Europe and things to fish in our seas, we are creating a situation where when they come and buy fishing nets, they won't even pay those things. So I do support it, but we have to be careful and define. The Minister for Fisheries. Thank you.
Well, if you look at the 19AA, certified by the Minister responsible for Fisheries and Aquaculture Development. So it's also certified bill. No, what is here is 19AA, certified by the Minister responsible for Fisheries and Aquaculture Development. Is there? So I'll put a question. All in favor of the House adopting the proposed amendment, say aye. Yes.
Speaker, this amendment is not even clear. When you say fishing gear for agricultural purposes, what are you talking about? The Ministry of Fisheries has a gear policy, and the policy is that you can fish with a prescribed fishing gear, because the intention is to protect the juveniles. And so it should be under the Ministry of Fisheries and Aquaculture. So as it stands, I think it is okay. The amendment being proposed does not even make sense. That you fishing gear for agricultural purposes. What agricultural purposes are you talking about? It is meant for fishing.
Honorable Member, have you read the 19A again? It delete and insert the following. 19A. Fishing gear that are imported for the agricultural purposes, and A, certified by the minister responsible for fisheries and aquaculture development. So you can import it for whatever. First, you must demonstrate that you're going to use for agricultural purposes, and B, it must be certified by the Minister for Fisheries and Aquaculture Development. That is what the amendment is introducing, unless there's some other means gleanable.
So I was saying that fishing gear, that is imported for purposes. Fishing, not agriculture.
Yes, Chairman, they said delete agricultural purposes and insert fishing purposes. I don't get it.
Well, Mr. Speaker, I think in our deliberation we considered fishing and all those related activities to come under agriculture. But I'm happy to be guided by Minister for Fisheries or the Minister for Agriculture.
Honorable Deputy Minister for Fisheries. Honorable Deputy Minister for Fisheries, are you able to guide us in this respect? There's controversy about the word imported for agricultural purposes.
Thank you, Mr. Speaker. Mr. Speaker, if we want to be very specific, then the agricultural purposes should be aquaculture purposes. Because we have the capture fisheries. We have the capture fisheries, which are for those in the wild. Let's say the marine space and the rivers. Okay. So if we are bringing in agriculture, then maybe we may have to differentiate those in the capture fisheries and then the aquaculture. But the moment you mention fishing gear that are agricultural purposes, then it is not too clear. Yeah.
Let me listen to Keta. Yes.
Thank you, Mr. Speaker. Mr. Speaker, for the fishing gear cannot be under the Ministry of Agri because they are separate ministry. So imported gear for fishery purposes, that's how it should be captured. Imported gear for fishery purposes.
Honorable Chairman, there's a proposal suggested to me. Let me read it to you. So you delete and insert the new one. Fishing gear certified by the minister responsible for fisheries and aquaculture development.
Yes. Mr. Speaker, the phrasing you have just provided would not sit comfortably in the existing act.
Right.
Because of the structure of that
Where is the act?
But Mr. Speaker, I think it's safer. I'm coming to be convinced that the word agriculture is problematic because fishing gear cannot be used for agriculture, and I'm being advised that agriculture has to do strictly with cultivation of land. So,
Nobody says so. It's farming.
That's what Mr. Speaker, so I was looking to make the point that if we can replace agriculture by farming,
yes,
and that brings clarity, we probably should do some proceedings.
I don't get you. Fishing gear.
That are imported for farming purposes.
Yes. Fish farming. That is better. Fish farming.
Yes.
Speaker, I think horticulture is a subset of agriculture. So agriculture does not only relate to farming. Fishing is part of agriculture. Or fish farming is part of agriculture. And so I don't see anything wrong with it. I don't see anything wrong. It's only a subset.
Well, let me try this again. 19A. Imported fishing gear certified by the minister. Are you paying attention, Chairman? Imported fishing gear. We are giving exemptions. This bill is about exemptions. So 19A, imported fishing gear certified by the minister responsible for fisheries and aquaculture development. I haven't given you the floor yet, please.
The word imported is what I want to draw your attention. If there's a company here that manufactures fishing nets and things like that, aren't we exempting them as well? So if it's fishing gear for agriculture, for farming purposes.
Yes, the film.
Speaker, thank you for the opportunity. Speaker, in my humble view, I wish to propose that the provision be read this way. Imported fishing gear for agricultural purposes, including aquaculture, and A, certified by the minister responsible for fisheries and aquaculture development, and B, approved by the minister, so that the existence of the agricultural purposes will sit with the memorandum accompanying the bill, the purpose, because of the planting for food and just program. Then aquaculture, because we are thinking of the benefits that this will be for individuals and entities that are actively engaged in artificial fish farming and both inland and marine.
Yes, Chairman. Honorable Minister for Environment, are you on your feet? Yes.
Mr. Speaker, the use of the word for agricultural purposes in this context is very, very problematic. Fishing is not, I'm on the net now, fishing is not generally considered a form of agriculture in its truest sense of the word. But farming added to it is a term of art. So we can say fish farming, but it does not extend to say that fish is an agricultural activity. So we should have a different terminology in this sense. Thank you.
Yes,
Mr. Speaker, I think it is safer to just have two things: fishing gear and the certification of fishing gear by the minister. Otherwise, I will bring fishing gear into the country and I'll tell you that my fishing gear is not for agricultural purposes. And if I tell them my fishing gear is not for agricultural purposes, it means that I don't fall within the category of fishing gear that you are seeking to regulate, even though obviously it is fishing gear. So it is safer to leave it as fishing gear. If you choose to bring in fishing gear into the country, you have to have it certified by the Minister for Agriculture. And then
I think what we are seeking to do is to grant exemption for those bringing in fishing gear for purposes of fishing. Now the word that is causing the problem here is for agricultural purposes. So that is becoming the challenge. Yes, Honorable Deputy Minister, let me hear you again.
I think we can cure it by fishing gear that are imported for fisheries purposes. Yes, fisheries purposes. For fisheries is for fisheries.
Fishing gear that are imported for fisheries. Is that sufficient?
No, for fisheries that are imported for fisheries.
Yes, a great committee ranking.
Mr. Speaker, when you say fishing gear, we are referring to a particular gear that is used for fishing. And so the proposal you made was excellent. Imported fishing gear certified by the Minister for Fisheries and Aquaculture. Imported fishing.
The only problem is that they said somebody may manufacture it locally. If the person manufactures it locally, will that person not be entitled to exemption? That is why imported became an issue. But if you leave out imported and you say fishing gear certified by the minister responsible for fisheries, I thought that should simplify it. Yes.
Mr. Speaker, I respectfully request members to go to the committee's report. The committee's report. And on page 6, that is where the original phrasing of the amendment is captured. We probably should move away from what is advertised on the other paper and stick with what is in the report. Now, this was in the report. Clause 2, amendment proposed, delete and insert the following. 19A, fishing gear that are imported for agricultural purposes and A, certified by the minister responsible for fisheries and aquaculture development, and B, approved by the minister, are exempt from customs duties and customs taxes. This 19A is new, completely new section we are inserting in the existing act. So Mr. Speaker,
what I have before me is 19A, fishing gear, seeds and fertilizer, specified in the second schedule that are imported for agricultural purposes.
Yes, and at the committee, together with the sponsoring ministry, we deleted what is there as 19A. We just deleted the whole thing and inserted what is advertised in the committee's report, namely fishing gear that are imported for agricultural purposes and A, certified by the minister responsible for fisheries, and B, approved by the minister, which is the minister for finance, are exempt from customs duties and customs taxes. So if there is anything, Mr. Speaker, if there is anything to be corrected, it is the word agricultural. Once we correct that, I think we should go by the amendment as stated in the committee's report rather than what is on the other paper.
Kindly repeat it for the record so that we put a question on it.
So clause 2, amendment proposed, delete and insert the following. 19A, fishing gear that are imported for agricultural purposes and A, certified by the minister responsible for fisheries and aquaculture development, and B, approved by the minister, are exempt from customs duties and customs taxes. So, Mr. Speaker, if I may add that the technical people that worked on this are advising that we stick with this phrasing, and I respectfully request the House that we do so.
So I'll put a question. You non-fishing people, let me listen to the beach people. Yes.
Speaker, thank you very much. Speaker, we no longer draft in the plural. that are. So we should take away that are. So it reads fishing gear imported. We take away that are. We no longer draft like that. So thank you.
Okay. So fishing gear imported for agricultural purposes, and A, certified by Minister responsible for Food and Agriculture or Minister responsible for and then approved by the Minister. Yes, Leader.
Mr. Speaker, mine is 19A and B. Why don't we want to marry the word certified and approved? Why do you want to have an A and a sub B? It's not elegant enough. And in any case, when you say certified, how distinct is certified from approved? Convince us. When you say certified, what is the minister? When a minister certifies, what does that mean? It's approved. So you either marry the two words or you choose one. You cannot say certified, then after certifying, approved. We are just using language and abusing language. What is certified and what is approved? Then explain. Thank you, Mr. Speaker.
Yes, Mr. Speaker, this phrasing is seen not just in respect of agriculture, but also education and care and all that. This is what it means. The certified, because we're saying that it has to be for agricultural purposes, the minister responsible for that area must certify that this is indeed for the purpose. But it being exemption, the only minister that has the authority under the law to approve exemptions is the Minister for Finance. And the minister here refers to the Minister for Finance. So this certification by the Minister of the sector and approval by the Finance Minister is what we have in all our laws.
Yes, Thomas West.
Mr. Speaker, I believe this is a matter of drafting. And if we would allow, let's leave this to the drafters so we can move on. Because everybody seems to be saying the same thing and it's hovering around the same meaning. If Mr. Speaker will indulge the House, I would plead that you allow the drafters do this after we have agreed on the text. Thank you.
Yes, Greg.
Mr. Speaker, we are witnessing dwindling stocks of our fisheries. And the arrangement is that there should be a gear policy which has been formulated by the Ministry of Fisheries and Aquaculture. And the policy is that a specific fishing gear must be used by our fishers so that we can protect the juveniles. Otherwise, when they have the net, they catch everything, including the fingerlings. And that is the reason why we are depleting our resources. So the standard arrangement is that there should be a prescribed fishing gear. So when we are importing, if it is for purposes of, then it should be certified by the minister. And that is why the rendition should be imported fishing gear certified. Because if it is fishing gear, then it is meant for fishing. And fishing is an aspect of agriculture. So why are we saying that it should be fishing gear imported that are imported for agriculture? Fishing gear, imported fishing gear certified by the minister. Because the minister has a specific fishing gear that has been approved by the ministry, and they want all fishers in this country to use that fishing gear.
Yes,
Mr. Speaker, we need to be careful. We need to be careful how we capture this. When we say fishing gear certified by the minister, do we mean that in every case where an importer imports fishing gear, that he now goes to the Ministry of Agriculture
and obtains a certificate for that gear in order to now have the revenue authorities to exempt that particular shipment of fishing gear. If we do it that way, have we considered the administrative cost of going to obtain the certification? You may be saving him the tax cost, but you may also be creating cost in terms of administratively pursuing the personnel at the Ministry of Agriculture and going through the process of certification. If it's the minister, maybe the minister has to assign the certificates, and that might actually end up being even more expensive porter than actually just paying some taxes and then taking his items out of the port. And that is how we make it difficult for business. So do we mean certification or prescribed? Because what I hear the ranking for agriculture indicating is that there is a gear policy, and the gear policy will define the gear. And if the gear policy defines the gear, anybody who is importing that gear is deemed to be importing fishing gear which fits the category that should enjoy the exemption. So let's render it properly so that we don't appear to be helping the importers, but in the end creating administrative hurdle that will even make it more expensive for them.
Yes, Minister for Interior.
Right, Honourable Speaker, would it make any difference if we said fishing gear with specifications certified by the minister? Then the minister satisfies the specifications. When you import and it falls within that specification, you qualify. I think that would be a better.
Honorable Committee on Finance, are you shepherding the bill?
Yes, Mr. Speaker, I'm paying attention to what is happening.
You're distracting him, that's why.
And the sense I'm getting from the sponsors is that the amendment is entirely okay.
The amendment, which amendment? There are about 3 different ones proposed before me.
The amendment by the committee. The amendment by the committee is okay. If we are minded to change agriculture to farming, we will not stand in the way. But beyond that, I respectfully request that we keep.
All right, I'm going to put a question. Fishing gear, cultural purposes, and A, certified by 2 ministries, Food and Agriculture and Aquaculture. That is what is here. Do you need the 2 ministries? Chairman, let me. Do you need the 2 ministries to certify it?
Mr. Speaker, the discussion as to whether these exemptions should be approved by just one minister, I think cannot be had right now. And I say that because if you go to 19, for instance, equipment, replacement parts and kits for production trials imported by a manufacturer or assembler of plants and machinery, including automobile. A, registered by the ministry responsible for trade and industry, recommended by the minister responsible for trade and industry, and approved by the minister. There appears to be throughout our legislation, whenever...
No, I'm talking about the fishing gear to be certified by the minister responsible for food and agriculture or responsible for fisheries and aqua development.
I think fisheries and aquaculture development, Mr. Speaker, is fine.
Very well. So I'm reading the final rendition out. Fishing gear imported for agricultural purposes and A, certified by the minister responsible for fisheries and aquaculture development, and B, approved by the minister, are exempt from customs duties and custom taxes. All in favor of the proposed amendment say yes.
Mr. Speaker, the sponsors of the bill, there is custom duties and custom taxes. do they want to insert the words payment? They are exempt from the payment of custom duties and custom taxes. It's a suggestion. The word payment, do you want to insert it before custom duties and custom taxes? No. Is what? Exempt from custom duties.
Yes, that's how technically it is referred to.
You don't use payment.
No, please.
So there will be no instance where there is an imposition, because custom duties will be imposed, custom taxes will be imposed, but we are granting a waiver. In granting the waiver, what are you granting? A waiver from the payment of these duties.
Yes, I get you, and I think you're right. But generally, in tax administration, we always say exempt from taxes, not exempt from the payment of taxes. It's exempt from taxes.
He is a great minister.
Mr. Speaker, you raise a very important point that I want us to avert our mind to. Parliament grants exemptions, not the finance minister. In this case, only Parliament that grants the exemption. Right. So in this case, why are we getting the finance minister to approve a recommendation or an approval of the Minister for Fisheries? We don't need a Minister for Fisheries approving and then the Minister for Finance approving again when Parliament is the one clothed with the responsibility of granting that exemption. So I think that the Minister for Finance in this case can be removed from the ability, should be removed.
Yes. Mr. Speaker, thank you for giving me the opportunity. I think it is the item supposed to be exempted must be certified and approved. That is what we are talking
before
about.
It is presented to Parliament to grant the exemption.
Yes.
That's right. Yes.
Mr. Speaker, this might be seen that we are laying things, but Mr. Speaker, this law, when we pass it, grants that exemption to that category of items. It's not the Minister of Finance, it's Parliament, and we have written it in law, and we are saying that before we evoke that part of the law, you have to get the certification from the Minister for Agri or Fish Farming. So what is the Minister for Finance going to approve again? Mr. Speaker, the reason why I'm saying that is that we lose sight of this, and then things get stuck in the Ministry of Finance, and we get into all sorts of messes. Once we have decided that we organize ourselves, our customs and everything through the Ministry of Finance, but once Parliament has already granted it, it is only the technical minister who should certify for the Minister of Finance to bring it into effect. For another approval in Finance Ministry,
Yes.
Because the exemptions bill is administered by the Ministry of Finance. Again, the exemptions, if approved, the fiscal impact will hit the Ministry of Finance and the macro fiscal. At the minimum, the minister responsible for finance must be made aware of what he is approving, because in the end, if you are to give those exemptions, the fiscal impact will not hit the Ministry of Agri, it will hit the Ministry of Finance.
Honourable members, let's be guided by the Constitution. Article 1742 says that where an act enacted in accordance with clause 1 of this article confers power on any person or authority to waive or vary a tax imposed by that act, the exercise of the power or waiver or variation in favor of any person or authority shall be subject to prior approval of Parliament by resolution. So notwithstanding what we put in the law, that approval should be brought here for Parliament to adopt it by resolution. That is why the minister may have to present it to Parliament for a resolution of Parliament. That's yes. Very well. So I'll put a question. All in favor of proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 2, as variously. Yes, leader.
Mr. Speaker, just to make assurances doubly sure, what have we approved? Just to make assurances doubly sure.
The proposed amendment, which has been approved under clause 2, reads, fishing gear imported for agricultural purposes and certified by the minister responsible for fisheries and aquaculture development and be approved by the minister are exempt from customs duties and customs taxes. That is the approved rendition. Now I'll move on to item III, clause 3.
Section 30 of Act 1083 amended.
Amendment proposed, delete. Clause 3, amendment proposed, delete.
Honourable members, all in favor of deleting clause 3, say aye. All against, say no. The ayes have it. The amendment is carried. Honourable member.
Section 34 of Act 1083 amended.
There is no proposed amendment to clause 4, so I'll put a question. All in favor of clause 4 being a part of the amendment of the being part of the bill, say aye. All against, say no. The ayes have it. Clause 4 is ordered to stand part of the bill. Clause 5.
Schedule to Act 1083 amended.
Clause 5, amendment proposed, delete. I so move.
All in favor of clause 5 being deleted from the bill, say aye. All against, say no. The ayes have it. Clause 5 is ordered to be deleted from the bill. Clause 6.
Second schedule inserted.
Amendment proposed. Chairman.
Clause 6, amendment proposed, delete. I'm sorry, Mr. Speaker.
All in favor of deleting clause 6, say aye. All against, say no. The ayes have it. Clause 6 is ordered to be deleted from the bill. Honourable members, that brings us to the end of the long title.
An Act to amend the Exemptions Act 2022, Act 1083, to provide the waiver of customs duties and custom taxes in respect of the importation of fishing gear, seeds, and fertilizer for the Planting for Food and Jobs Program, Phase 2, for agricultural purposes and for related matters.
All in favor of the long title being a part of the bill, say aye. All against, say no. The ayes have it. The long title is ordered to stand part of the bill. That brings us to the end of consideration of the Exemptions Amendment Bill 2023. Honourable members, I direct the draftspersons to delete seeds and fertilizer from the long title in reflection of the amendments than in the body of the bill. Item 63, motion.
Mr. Speaker, I beg to move that the motion captured as item 63 on today's order paper be moved now. I so move, Mr. Speaker.
Any second?
Mr. Speaker, I second the motion.
Honourable members, item 63 is a procedural motion. All in favour of the House adopting the motion, say aye.
Aye.
All against, say no. The ayes have it. The motion is carried. Item 64.
Mr. Speaker, I beg to move that the Exemptions Amendment Bill 2023 be now read the third time. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Honourable members, all in favour of adopting the motion number 64, say aye. All against, say no. The ayes have it. The motion is carried.
An Act to amend the Exemptions Act 2022, Act 1083, to provide the waiver of customs duties and customs taxes in respect of the importation of fishing gear for the Planting for Food and Jobs Program Phase 2 for agricultural purposes and related matters.
Honourable members, the Exemptions Amendment Bill 2023 is now read a third time and passed. Yes, Leader. What next?
Speaker, motion 65 on page 25.
Honourable members, item 65, motion by the Minister for Finance. Yes.
Mr. Speaker, I beg to move that the motion captured as item 65 on today's order paper be moved now. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Honourable members, the procedural motion has been moved and seconded. All in favour of the House adopting the motion, say aye. All against, say no. The ayes have it. The motion is carried. Item 66. Yes, Honourable Minister.
Mr. Speaker, I beg to move that the Income Tax Amendment number 2 Bill 2023 be now read a second time. I so move, Mr. Speaker.
Yes. Chairman.
Mr. Speaker, I rise to speak to the motion and in the process present your committee's report. It is the Income Tax Amendment number 2 Bill that looks to adjust the income tax bracket, one, to provide relief for minimum wage earners whose increased wages has now placed them in a bracket where they will be taxed, and therefore it is important to adjust the bands to ensure that minimum wage earners continue to enjoy a tax-free regime. But it is also to vary some of the brackets to rein in revenue for government. Again, the minority took a position against it. By a majority decision, the committee recommends it to this House to pass it into law. Respectfully submitted, Mr. Speaker.
Honourable members, the motion has been moved and seconded for the consideration of the House. I'll put the question. All in favour of the House adopting the motion, say aye. All against, say no. The ayes have it. The motion is carried.
An Act to amend the Income Tax Act 2015, Act 896, to revise the rates of income tax for individuals.
Honourable members, the Income Tax Amendment number 2 Bill is now read the second time. Now, I'll move to item number 67, procedural motion.
Mr. Speaker, I beg to move that the motion captured as item 67 on today's order paper be moved now. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
All in favor of the motion, say aye. All against, say no. The ayes have it. The motion is carried. Item 68, Income Tax Amendment Number 2 Bill 2023 at the consideration stage. Members, the clause.
First schedule to Act 896 amended.
All in favor of the clause being a part of the bill, say aye. All against, say no. The ayes have it. The clause is ordered to stand part of the bill. The long title.
To amend the Income Tax Act 2015, Act 896, to revise the rates of income tax for individuals.
All in favor of the long title being a part of the bill, say aye. All against, say no. The ayes have it. The long title is ordered to stand part of the bill. That brings us to the end of consideration of the Income Tax Amendment Number 2 Bill 2023. Item 69, Honorable Minister for Finance.
Mr. Speaker, I beg to move that the motion captured as item 69 on today's order paper be moved now. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Honorable members, the procedural motion. All in favor of the motion, say aye. All against, say no. The ayes have it. The motion is carried. Item 70. Minister.
Mr. Speaker, I beg to move that the Income Tax Amendments Number 2 Bill 2023 be now read a third time. I so move, Mr. Speaker.
I second the motion, Speaker.
Honorable members, all in favor of the House adopting the motion, say aye. All against, say no. The ayes have it. The motion is carried.
An act to amend the Income Tax Act 2015, Act 896, to revise the rates of income tax for individuals.
The Income Tax 2 Bill 2023 is now read a third time and passed. Yes.
Mr. Speaker, item 71 on page 27.
Very well. Honourable members, item 71, motion by the Minister for Finance.
Mr. Speaker, I beg to move that the motion captured as item 71 on today's order paper be moved now. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Yes. Honourable.
Honourable Speaker, this is a plea. Just looking at members and the condition that they are in, I am humbly pleading with you. What is really critical at this point is the appropriation bill. To be fair, all these taxes have been done. I will humbly submit that we stand down on the emission tax. Let's take the appropriation and call it a day. Please. That is really what is critical at this point. And to be fair, let's take the appropriation and end it. Members are not doing very well, and I'm very worried about it. Mr. Speaker, please, this is a plea. And I believe you are the leader of government business. Please listen to this kind plea. You are supposed to be interested in the health of members of this house, and you have to listen to what I'm telling you. So I'm humbly pleading, and the leader
who cares about members of this house, I'm sure will support it. So we'll take the appropriation and call it a day. It's 2 a.m.
Yes, Leader.
Speaker, it's just one motion. There's no amendment. It's just one motion, and then we take appropriation. Let's not waste time on this for want of an unnecessary debate. It's unnecessary. Let's go and take the motion, the last motion, and then we'll take appropriation, and then of course we can disperse. This thing about health is important. How long ago did you know our health is important? How long ago did you know that? We will take it. We will exhaust everything before we disperse.
Mr. Speaker, it is very interesting.
Just few hours ago,
my colleague on the other side is always walking around here pleading when his troops abandon him so that we work together. Today he got a number, so we will do it, Mr. Speaker. And the sad thing is that when your colleague said that on health ground, he said it's unnecessary. You mean the health of members of parliament is unnecessary? The health of members of parliament, talking about the health of MPs is unnecessary. I'm surprised. Unnecessary. The health of your colleagues is an unnecessary talk, and the leader is quiet. And the leader is not even he himself. I don't know about your health. I don't know about you yourself, your health. Mr. Speaker, it's a very important matter. Mr. Speaker, they had 7 issues on taxes, exemptions and other things. We've done 6. I mean, what is your priority? The appropriation bill is ready. Let's take it. He said we'll do all of it. Mr. Speaker, be guided. When you come back from your primaries, mark it. You will have to get your numbers to do everything. Every business. You will bring your number to do everything. Every business. You say you promise. The world has said it. You promise to bring your numbers before you do every business. We are happy. Okay. We've heard you.
Yes, Deputy Leader.
Mr. Speaker, we have a day or two to express. We are pleading. You let's finish. We are pleading. We are pleading with you. Mr. Speaker, we are pleading.
Mr. Speaker, my colleague, the deputy majority leader has intervened, and I think that we've traveled some distance. But with respect to what the minority chief whip is saying, Mr. Speaker, I want to remind him of Order 30L. That he cannot attempt to intimidate by threats. You cannot attempt to intimidate members by threats in the conduct of their duties. It's an offense.
Very well. I've listened to all sides. I think we have looked at the bill itself. There are no proposed amendments. If we allow ourselves, we shouldn't take less than anything more than 30 minutes to conclude. So let's conclude this quickly so we can deal with it. Yes, item number 71. Honorable Minister, please move your motion.
Mr. Speaker, I beg to move that the motion captured as item 71 be moved today. I so move, Mr. Speaker.
Mr. Speaker, I second the motion.
Members, the procedural motion has been moved and seconded. All in favor of the House adopting the motion, say aye. All against, say no. The ayes have it. The motion is carried. Item 72. Honorable Minister.
Mr. Speaker, I beg to move that the Emissions Levy Bill 2023 be now read a second time. I so move, Mr. Speaker.
Yes, Chairman of the committee.
Thank you, Mr. Speaker. I rise to speak to the motion and in the process submit your committee's report. I urge the Hansa Department to capture the entire content whilst I take the highlights. Mr. Speaker, this was also by majority decision. The committee had some amendments which I would move on the committee's behalf during consideration. But the conclusion is that we recommend to this House to pass this bill into law. Respectfully submitted, Mr. Speaker.
Yes, Honorable.
Mr. Speaker, quite clearly this government now has fallen short of taxing everything. For those of you who speak Akan, when you Musie, Musie tax. At 2 a.m. you are imposing taxes on smoke. Musie tax at 2 a.m. It appears you are now struggling to find something to impose the tax. Mr. Speaker, every available excuse has been exploited. Now, they say that if you are driving an internal combustion engine, you will pay 100 Ghana cedis. And this will yield about 540 million Ghana cedis. But shockingly, Mr. Speaker, this money which is supposed to assist us deal with climate change does not have any policy orientation whatsoever to tackle climate change. If our emphasis is really to deal with climate change, then we expect that this money should be invested in activities that will lead to the solution to climate change. But it is not. We found an excuse with Bola to tax sanitation. It didn't go into sanitation. Now we are taxing internal combustion engine to deal with climate change, but the money is not going into climate change. So what exactly are we taxing that money to do? Mr. Speaker, we understand that this will assist Ghanaians to make the switch from internal combustion engine to electric vehicles. For you to buy an electric vehicle into Ghana today, you will need to reconfigure the electrical systems in your house to charge that vehicle. Mr. Speaker, if you get out today and you drive your car and your gauge begin to show red, you look for the nearest filling station. Today, if you are driving an electric car and it is showing red, where will you drive it to? Will you drive it into a filling station and refuel, or you jump out of it and take an Okada and go? So clearly, you are only interested in taxing and taking the money, but you are not dealing with the issue of climate change. And the earlier we get serious with climate change and begin to reduce the climate situation in our country, the better. Mr. Speaker, just like the many other taxes, the minority made it very clear that we cannot support the imposition of this tax. And we hope that the government will listen and stop imposing taxes on the people of Ghana. Mr. Speaker, on this note, I call on my colleagues to reject this tax and save the people of Ghana further misery. Thank you very much, Mr. Speaker.
Yes, Honorable Deputy Minister.
Thank you, Mr. Speaker. Mr. Speaker, this bill is a very important one for our country. And not just for our country, but for the whole world. Because we are confronted with issues relating to climate change. And therefore, we need to be able to transition from high carbon equipment and vehicles to low carbon equipment and vehicles. This bill will create the enabling environment for us to attract investors into the development of the charging stations that the honorable member talked about. If you don't create the enabling environment, how do you attract the investors? And so by passing this bill into a law, we would have signaled to investors that it is about time they came to invest in the development of charging stations, in the manufacturing of electric vehicles, in the assembling of electric vehicles, and that is the kind of enabling environment this bill will create. Mr. Speaker, climate change is affecting our country so much, particularly through emissions. Since the 1960s, the World Bank estimates that average annual mean temperature in Ghana has increased by 1 degree Celsius. 1 degree Celsius is quite a disaster if we don't check it. Mr. Speaker, in addition to this, average number of hot days in Ghana has increased by 13%, and average number of hot nights in Ghana has increased by 20%. So it is here with us. The effects of climate change are here with us, and we must be able to check it. And this is one important measure government is introducing to discourage emissions and to attract investment into the development of low carbon technology so that we can be able to address issues relating to climate change. And so, Mr. Speaker, I want to appeal to our colleagues on the other side to vote for this, to approve this bill, so that we can set the stage for the transitioning of our economy from high carbon to low carbon technologies. And I thank you very much for the opportunity.
Yes. Thank you very much, Speaker. Speaker, this tax simply really creates the impression that we as a country are crying more than the bereaved. Now, Speaker, who are the big polluters of this world? And have we checked how much emission taxes are they imposing on their citizens? China, the United States, and others. How much emission taxes are there? What is the percentage of pollution of Ghana, a small country? I mean, why are we? There was a COP recent 2018 in Dubai. When the United States delegation was keen and focused, we sent almost 700 delegations. What did we go there to do? Madam Speaker, in countries who are serious about climate change and mitigation measures, they plan long-term planning. If you go to the United States, there's a way, the technology to check your vehicle's emission. As we speak, the Energy Commission is now working on a proposal and guidelines on even the so-called tax we are approving. We don't even have a document in place. They are working on this in the budget. So we are simply basically doing this because we want money. It is simply not any attempt at really addressing the issues of climate. Now, not even when you talk about electric vehicles, you tell me from Accra to Elembele, give me one charging station, and Chemeza, the majority leader, the honorable, my good friend, I'm going to say, hey, the leader of the house, who will very soon plan to drive electric vehicle, when you get to Kolongo, where are you going to charge your vehicle? I mean, let's be serious. We are not prepared, and there is no way of basically distinguishing between vehicles that are really polluting the environment and those vehicles that are not really giving us problems. Where is the technology to do the emission tests? So we are not ready.
This is simply an attempt to basically find money, more taxes, and burden the people of Ghana. And that is why we simply oppose this. It is unnecessary, the timing is wrong, and even countries that are polluting the environment, quite frankly, are not imposing this emission tax. So frankly, if you want money, find other avenues, not emission. We are not ready. I thank you, Mr. Speaker.
Honorable Minister for Environment.
Mr. Speaker, unfortunately, our colleagues from the other side are getting it all wrong. First of all, Ghana is not an island. There is a palpable movement towards use of clean energy, particularly in the transport sector. And here we are looking at electric vehicles, and even for the internal combustion engine, hydrogen fueled vehicles. Mr. Speaker, we need not lag behind the developed world. The developed world have their economies ossified, and I will use this technology. When I came from America in the late 90s, after my postgraduate studies, the penetration of telephone, mobile telephone, was higher in Ghana than in America. And Ghana and Kenya has advanced the use of telephones, even in mobile phones, even in rural settings, where our population are supposed to be illiterate. I submit that in the country we will jump the technology gap. So we don't have to follow the developed world. We have the potential to bypass them. And in fact, electrical vehicles are becoming even cheaper by the day. So we have a comparative advantage in that the paradox is that our backwardness paradoxically is our salvation, because we can jump quickly into this technology. And then of course, health. It is not only about emissions, but even inhalation of particulate matter. So the pneumoconiosis, the lung diseases and whatnot. If we transition to e-vehicles, we will prevent a lot of health issues, particularly with regard to And then with regard to where the charging stations, as I speak to you now, the Ministry of Transport, together with Mercy, we are piloting areas where there are e-vehicles running in Ghana now, particularly buses, and we have got a couple of charging places. So, Mr. Speaker, it's a catch-22 situation. If you jump into it, then that is when the others will follow. So you have to look forward to take advantage. This tax is a preventive tax. It has got all the advantages. We have to start from somewhere. And I recommend my colleagues to reconsider their positions and vote for the motion. Thank you very much, Mr. Speaker.
Yes, leader.
Mr. Speaker, the devil, they say, is in the details. The devil, they say, is in the detail. Mr. Speaker, what are they taxing? And that is critical. Mr. Speaker, what are they taxing? First, the tax has two legs. The first leg is a tax of 100 Ghana cedis on every vehicle that uses internal combustion engine. Mr. Speaker, this includes Okada, Prajia. Mr. Speaker, Okada, Prajia, Ubaka, Antiquator, every car, including Trotro, 100 Ghana cedis per annum, every year. Mr. Speaker, Mahama can do, they are all part of those. That is what it is. Mr. Speaker, so every car, as long as the car or the motor has been registered at the DVLA, you pay 100 Ghana cedis a year. Mr. Speaker, this is regressive. It is regressive in the sense that the person using V8 is paying the same 100 Ghana cedis as Okada, as the person using a motorbike or Okada. I mean, what sort of tax is this? What sort of tax is this? It's regressive. It's regressive because the person using a motorbike should not pay the same tax to the person using Lexus LX 570. The Speaker, so we should be careful what we are legislating on. The Speaker, aside that, the second leg is a tax on carbon dioxide equivalent emission from specific sectors. The Speaker, and these are the sectors. Construction sector. So if you have a construction company and you produce any form of what I don't go describe as smoke, smoke. The Speaker, one ton of smoke is 100 Ghana per annum. How are you going to measure that? Tell us, how are you going to measure 1 ton of smoke? The Speaker, 2 tons, 200 Ghana, 3 tons, 400 Ghana, 4 to 5 tons, 500 Ghana. So every ton, the Speaker, how do you measure it? Are you going to measure it by looking at the pets? The Speaker, they have to come again. The Speaker, not only that, manufacturing sector, oil and gas sector, and electricity and heating sector. So the Speaker, electricity and heat. The Speaker, that saddens me because if you are not lucky and there is light off and you produce, you buy generator and you use the generator to generate heating or light in your house, you'll be paying 100 Ghana of emission you transmit. 100 Ghana, the Speaker, for generators. The Speaker, let's be careful. The devil, they say, is in the detail. So how are you going to measure it? You are taxing Okada, you are taxing Dragia, you are taxing Uber cars, you are taxing Trotro, and you are also taxing Mahama Kandu. Mahama Kandu is not Dragia, it's not in Ghana. The Speaker, aside that, Mr. Speaker, now your generator in your house, if and Mr. Speaker, the devil they say is in the detail. I'm referring you to the schedule. Do you have a copy of the bill? The Speaker, so the details are here. Electricity and heating sector, you have not given any form of exemptions. Construction sector, so the contractors who are working, if you produce smoke, you will pay carbon dioxide tax, 100 Ghana cedis per ton. Be careful the kind of tax you introduce. The Speaker, this tax will not affect only the rich people. This tax will affect the lowest of our society, including the MPP food soldier. The Speaker, this tax is a Okada tax. It's a tax on motorbike. It's a tax on Pragia. Remember, you are going back to your delegates. Tell them about what you are introducing. The kind of tax you are introducing, Mr. Speaker. Let's be careful, Mr. Speaker, the kind of tax we introduce. Mr. Speaker, I believe that this tax is not properly thought through. The mechanism to assess the value or the tonnage of emission that one, based on the sectors, will emit. The Speaker, certainly I know that it is not available, and it's something that may generate some form of distortion. The Speaker, even if it's available, you cannot have it as much as possible, so much for you to be able to go around the country and assess the level of emission that they are actually emitting. The Speaker, they say they are going to rake in 540 million Ghana cedis. The Speaker, in fact, smoking is not part of this one. Smoking is not so the kind of Lucio you are talking about is even if you go and catch the hunter can be in trouble. The Speaker, let's be careful. The devil, they say, is in the detail.
this tax is a dangerous tax. Thank you, Mr. Speaker. Mr. Speaker, as for us, we oppose this Wusio tax because, Mr. Speaker, this tax will be a very dangerous tax. Thank you, Mr. Speaker.
Yes, Honorable Minister.
Mr. Speaker, I want to draw the Finance Committee's attention to, in attempting to break up that bill that was brought, has led to such arguments which is becoming uninformed. The whole bill encompasses the tax exemptions for electric vehicles and then a punitive tax for combustion engines.
Yes.
Mr. Speaker, by 2030, combustion engines will be outlawed in parts of Europe, where most of our cars come from. We will not get those combustion engines on spare parts to come and repair those cars here. And it will become extremely punitive and even more expensive to even bring such car parts. The whole world is moving. I was with you in COP28. And we all learned the fact that the world is moving. You were there. I was with you. I was in Bocha, Mr. Speaker. The climate change agenda, Mr. Speaker, was assented to on behalf of Ghanaians by President John Dramani Mahama. And Ghana made its contributions, and it included trying to minimize pollutants. Yes, before the climate warming. If you only even learn about what is happening in this world, no wonder we are where we are. You are talking about taxing generators. In whose tenure did Ghana become populated with generators? Thank you. So when you have my brothers on the opposite side, blowing both hot and cold, that's what we will have in this country. Under President Mahama, we signed the Paris Climate Accords, right? And we brought us...
Honorable Minister, hold on. Do you have a point of order? Yes, can I hear your point of order?
Thank you, Right Honourable Speaker. I just wanted to point out to my honourable colleague that we are not just brothers, they are sisters here as well, just to correct you.
What did she say? I didn't hear her.
He was making reference to his brothers on the other side, and I believe there are women here, so it's brothers and sisters, if you must be correct. Thank you.
The sisters are very well recognized.
I take my sister's comment. I missed her. I didn't think she was here, so my sisters are here. When you were practicing every Ghanaian had to buy a generator. Every Ghanaian had to buy, and my colleague, the minority leader, deputy minority leader, he was the minister for generators. Now the minister for generators, he was producing the whole Ghana with smoke. And so we should continue to produce smoke. Let me speak. Why?
Honorable Minister for Energy. Honorable former Minister for Energy, yes.
The Minister of Energy should thank us that by the time he came, we had solved all the doomsday problems. So all he can do is to travel around and get all his award for women.
I want to conclude by saying that you solved the problem, and I came to get the awards. And you know what you're saying? Have you taken the generators out of Ghana? Mr. Speaker, this is the most enlightening tax that I have seen in the last 20 years. Yes.